Welcome to the first public hearing for the inquiry into the provision of the Voluntary Assisted Dying Bill 2021. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of the land on the land on which Parliament sits. I would also like to pay respects to the elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present. Today we'll be hearing from supporters of the bill. We will hear from Dying with Dignity New South Wales, Go Gentle Australia and representatives from other key peak bodies. We'll also be hearing from a number of private individuals with lived experience relating to the bill. Before we commence, I would like to make some brief comments about the procedures for today's hearing. I note that the hearing room is closed to the general public for this hearing and the hearings on the 10th and 13th of December for this inquiry as well. This is due to the room capacity restrictions under the New South Wales Parliament's COVID safe arrangements. However, the hearing will be broadcast live on the Parliament's website. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. Therefore, I urge witnesses to be careful about comments you may make to the media or others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the individual issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that witnesses could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer by the 28th of January 2022. As I mentioned, today's proceedings are being live streamed and a transcript will be placed on the committee's website when it becomes available. In terms of audibility for today's hearing, we have witnesses in person and via the video conference system. Can I ask committee members to clearly identify who questions are directed to? And could I ask everyone appearing remotely to please state their name when they begin speaking? Could everyone appearing via video conference please mute their microphones when they are not speaking? Members and witnesses should avoid speaking over each other so that we can all be heard clearly and to assist Hansard. And also to assist Hansard, may I remind members to speak directly into their microphones and avoid making comments when your head is turned away. I will now welcome our first witnesses. Could each witness, starting from my left, state their name and position title and swear either an oath or affirmation?
Where is the oath?
Do we have the affirmation thing?
Do you have the affirmation?
We're just bringing it to you now. And for witnesses in the room, it might just assist to bring your microphone a little bit closer. Thank you.
Steve is first, from his left, yeah.
My name is Steve Offner. I'm the Communications Director at Go Gentle Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Ms. Hackett?
My name's Penny Hackett. I'm the President of Dying with Dignity New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Hackett. And you might need to just bring your microphone a little bit closer. You'll assist the Hansard reporters and the live stream audience if you do so. Thank you.
And us, actually. And us.
And us.
My name is Shane Higson and I'm the Vice President of Dying with Dignity New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Ms. Cohen.
Yes, my name is Janet Cohen and I'm a volunteer advocate with Go Gentle New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And Mr. Wood. Mr. Wood, I believe you might be on mute.
Yes.
Ian Wood, spokesperson for Christians supporting choice for voluntary dying. I swear that the evidence about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. We're now providing witnesses the opportunity to make an opening statement. Now, I believe that Dying with Dignity will start with their opening statement first. Thank you.
Yes, thank you, Chair. We welcome the opportunity to participate in this hearing. Dying with Dignity New South Wales is a registered charity. Our principal aim is to have voluntary assisted dying laws passed in New South Wales, and we've been lobbying for this reform since the 1970s. Numerous independent polls and surveys over many years show overwhelming public support for these laws, ranging between 75 to 85%. This covers all locations, demographics and political persuasions. It also includes a sizable majority of those with religious faith. There's a very high level of public awareness of this issue. Death is not theoretical for anyone, and almost every adult will have had some personal experience with death of a family member or friend. We have over 110,000 supporters in New South Wales. The vast majority have a personal experience of the bad death of a loved one. Some are terminally ill themselves. Many are healthcare workers who see terrible deaths in their professional lives. And they know that even the best palliative care can't always relieve the suffering of some dying people. Some of our supporters have lost loved ones to suicide because they could no longer endure their suffering. You'll hear from some of these people later today, but I will just make a personal comment that the mother of one of my own friends jumped in front of a train at Linfield Station several years ago, and she had a terrible cancer and saw no other way to end her suffering. She had a loving family and the best possible medical care, but she felt she had to take matters into her own hands. We've heard thousands of testimonies, and I have personally read over 26,000 messages sent by our supporters to New South Wales MPs over the last 4 years. Many of these are so shocking and distressing that I've sought professional counselling. We're not medical or legal experts or professional campaigners, and we have no ideology. We're simply advocates giving voice to people who would benefit from VAD laws or who have watched loved ones suffer. For us, this is about giving choice to people who are already dying and want some control over how they die. The bill passed the Legislative Assembly with a resounding majority. It's a bill that was carefully developed over many months and drew on the laws passed in other states and numerous inquiries and independent reviews, plus the detailed reports from the Victorian VAD Review Board. It creates a regime which is substantially the same as those in other states. It's conservative and balances the rights of patients and healthcare workers with robust safeguards for everyone involved. But it also avoids unnecessary processes and barriers that would simply increase or prolong the suffering of the very people it's designed to help. There's a few key points I would appreciate the committee making note of as you embark on these hearings and the review of submissions. We fully support palliative care, and we welcome the Premier's commitment to greater funding and access in New South Wales. But it's absolutely clear that even the best palliative care cannot relieve symptoms for a small but significant minority of dying people, and it's for these people that VAD is essential. VAD and palliative care are not mutually exclusive. Evidence from Victoria and other jurisdictions show that the majority of people who use VAD are also in palliative care. It's also clear that VAD laws are not detrimental to delivery or funding of palliative care. Palliative Care Australia, which is the peak body for palliative care, in 2018 they conducted a major review and found that in jurisdictions with VAD laws, the palliative care sector had further advanced. Many opponents of VAD, including those in the palliative care profession, will claim that palliative care can deal with all suffering at end of life. And this was asserted by a number of MPs in their second reading speeches last month. Sadly, this is not the case, and this is confirmed by Palliative Care Australia itself and acknowledged by all major medical bodies, including the AMA. I might just take the opportunity to quote from the testimony of Dr. Edward Mantle at the Queensland Parliamentary Inquiry. He's a palliative care specialist in Perth who does not support VAD. He said, "I think it is disingenuous and it is probably closer to a bald-faced lie when palliative care physicians say they can relieve all suffering for all patients. It is simply not true." You'll hear from a number of groups during these hearings, and we appreciate and respect the genuinely held beliefs of those who oppose these laws, but Parliament must legislate for everyone. And the beliefs of those who hold a religious or ideological objection to VAD laws should not determine the end-of-life rights of people who don't share those beliefs. The key feature of this law is choice. It is voluntary and no one is compelled to be involved. Those who oppose VAD laws are not required to use them or to participate in the process. It would be unconscionable to deny the choice of VAD to others in our community due to the objections of a small minority who will not be affected by these laws. Ideally, VAD would be addressed by federal legislation, but it's a matter of state jurisdiction under the Constitution. The committee will hopefully agree that nationally consistent legislation is desirable. Dying people in this country should have the same rights at the end of their lives, regardless of where they live. Equally, practitioners, professional bodies and healthcare organisations should have broadly similar regimes to work with when they're creating guidelines for the care of patients and legal protections for their members and staff. In the Assembly debate, many opponents expressed concerns about the risk of elder abuse or coercion of vulnerable people, and this is a very serious issue in our community. But we would submit that the safeguards and assessments in the VAD process are more likely to expose abuse than to facilitate it. And we ask the committee to listen to bodies who represent these vulnerable groups, in particular the Council on the Ageing, which is the peak body representing older Australians. They have endorsed the VAD bill and consider its protections sufficient. And other supportive groups include the Older Persons Advocacy Network and the Older Women's Network. You might also note the submission from the Physical Disability Council of New South Wales, in which they believe the bill strikes the right balance between safeguards and accessibility of the regime. In closing, we support the VAD bill as it now stands without further amendment. There is nothing uniquely special or vulnerable about dying people in New South Wales to warrant adding additional requirements or safeguards above and beyond those which apply to dying people in other states. To amend the substantive provisions of the bill to add more onerous criteria or processes, particularly in relation to medical assessments, would significantly reduce the ability of dying people to access the regime, and this is especially relevant for people in regional and remote areas. It would simply increase the suffering of people who are already struggling with a significant burden of illness without adding any meaningful protections against abuse. Thank you for your time.
Thank you very much. I'll now invite a representative from Go Gentle to provide an opening statement.
Thank you for the invitation to address the committee. First off, I would like to acknowledge and thank you for the task that you are undertaking. Not only is the scope of this inquiry wide, it is also one where emotions can run high, and as we know, the subject matter is difficult. By way of some background on the organisation that I represent, Go Gentle Australia is an expert advisory and health promotion charity founded by Andrew Denton. Some years ago, Andrew began a journey to explore why, at that time, we did not have a voluntary assisted dying law in Australia, and by contrast, why some other countries did. For more than a year, he travelled across the globe to speak with those for and against assisted dying, doctors and nurses, legislators, palliative care specialists, disability, patient and elderly advocacy groups, and the terminally ill. The result was an initial, and now 2 comprehensive documentary podcast series called Better Off Dead that provide a compelling insight into why these laws are so necessary. The evidence Andrew collected galvanised his resolve that Australia had to have a better conversation about end-of-life choice, and he and others established Go Gentle in 2016 to do this. By way of our credentials, Go Gentle has played a key role providing evidence-based information to legislators in every Australian parliamentary VAD debate. This furnishes us with a strong understanding of the political realities and the challenges of developing a law acceptable to both politicians and the general public. In all our work, we emphasise three basic principles. The first principle, that any legislation must be practically useful for the eligible terminally ill person. While it should contain strict safeguards, these safeguards should not be so onerous that the very people the law was designed to help struggle to access it. A second principle, we believe it is important that VAD laws are made on the basis of careful analysis, peer-reviewed evidence and established facts. In any debate, if no evidence can be provided to support statements and other claims, we believe those claims should be set aside. Just as importantly, if evidence is provided, it is essential to ask how reliable is it, who provided it, and are there any undeclared allegiances that are influencing conclusions. And underscoring everything is a simple third principle, that Australians should have the right to choose what happens at the end of their lives and not be coerced because of someone else's beliefs into cruel, pointless, and avoidable suffering. We've produced many resources in the last 5 years. The most recent is the booklet, The State of Suffering, which we produced in collaboration with Dying with Dignity. It collates more than 150 testimonies of cruel suffering in New South Wales in the absence of a voluntary assisted dying law. These accounts were drawn from more than 26,000 we received from all corners of the state. It's not an easy read, but I urge members to do it. These are the people this law is designed to help and who are currently denied the choice of a legal and compassionate alternative. In contrast to these testimonies, the implementation of Victoria's landmark VAD law in 2019 is a significant step forward for Australians who want choice at the end of life. More than 300 people have made use of the law in its first 2 years. Some of their stories are told in the second series of the podcast Better Off Dead, and also in our submission to this committee. The difference between their peaceful, empowered deaths and the cruel, often gruesome deaths recounted in State of Suffering is stark. Also, and this is a point already emphasised, VAD is just one option at the end of life. We also strongly support the need for good, well-resourced palliative care. Palliative care's aims to alleviate suffering and to make possible a good death, both for the dying person and their families, are also Go Gentle's aims. To conclude, New South Wales must join other Australian states to allow a kinder, more compassionate option for people who are dying and who want to alleviate their suffering. We commend the bill in the form that passed the Legislative Assembly with its strong endorsement, and we urge no major changes. Any changes, should they arise, should seek to improve the operation of the bill and facilitate access for eligible terminally ill people in New South Wales. We caution against last-minute pile-on amendments, those seemingly small changes to a carefully developed bill that could have larger unintended ramifications. Especially, it is crucial to avoid any changes that would have a negative impact on the people the law is intended to help. As a society, we must do better by our terminally ill, who are among our most vulnerable. These are the people, for obvious reasons, that you won't see marching in the streets advocating for their rights, but it is to their voices that we must listen. I welcome any questions, and thank you.
Thank you very much. And Mr. Wood, do you have an opening statement?
Yes, thank you for this opportunity to give evidence. My background, I was a community pharmacist in Port Pirie, South Australia for 40 years, which involved caring for people. My wife and I raised 2 children and we enjoyed community involvement in heritage conservation, classical music and entertaining at aged care facilities with music and singing. I had long supported assisted dying choice but became public to be supported in 2009 when Reverend Trevor Bench, a retired minister and hospital chaplain at the church I attended, decided that Christians who supported VAD needed a voice, and we formed our group. Our vision essentially is do unto others and love thy neighbour, which leads to how is love best served. Conservative Christians in the past opposed the abolition of slavery, opposed pay relief in childbirth for women, and opposed women becoming doctors, lawyers and politicians. We believe those Christians were wrong. Conservative Christians opposed marriage equality and discussion on sexual orientation. With regards to sexual orientation, we find that to its eternal shame, many of the church hierarchy indulge in a massive cover-up of pedophile clergy, in many cases leading to the tragic suicide of the innocent victims, in a cruel irony with the church opposition to VAD. Clearly, those Christians were very wrong. So how is love best served for a person who is about to die, but has suffering that they find unbearable? A very vocal majority of Christians say, hold that person's hand, say that we're with you, but let the suffering continue. Where is their Christian empathy, we might well ask. Curiously, the religious opposition generally now does not give religious reasons opposing VAD. So this is an issue in our society whose time has come. For the reasons outlined in our submission and numerous other reports, the vast majority of voters, including a significant majority of Christians, trust that this inquiry and the New South Wales Parliament will conclude that Christian love is best served by putting the dying patient at the centre of this debate and in control, providing choice and compassion under the provisions of this bill. I've also requested 4 additional documents be tabled for the inquiry to consider. I hope they'll be circulated. Thank you.
Thank you very much. And my apologies. I'll also give the other witnesses an opportunity to make a short opening statement if they'd like to as well. Ms Higson.
Thank you. My name is Shane Higson and I'm the Vice President of Dying with Dignity, New South Wales. Thank you for the opportunity to speak today. As some of you know, I have been an advocate for voluntary assisted dying law reform for 9 years, following the death of my beautiful mother Jan from an aggressive brain cancer. When Mum died in late 2012, there was no law to provide her with a more compassionate end-of-life option, so she was forced to endure the terrible end stages of that dreadful disease, and we, her loved ones, were forced to watch on, powerless and traumatised. My mother loved life, and she had a loving family supporting her and caring for her through the entire 7-month journey from diagnosis to death. We were also supported by a caring community palliative care team from one of Sydney's top hospices, Sacred Heart in Darlinghurst. Despite all that support, Mum did not die peacefully, and the last 15 days of her life were cruel and harrowing. Just 2 weeks before her death, Mum started to ask for some form of medication that would knock her out, but nothing the doctors prescribed eased her suffering or distress. Each day it just got worse, and Mum couldn't take it anymore. She kept asking, why are they doing this to me? Why are they torturing me? Over the 9 years that I've been advocating for assisted dying through organisations including the Voluntary Euthanasia Party, Dying with Dignity and Go Gentle Australia, I have heard literally hundreds, if not thousands, of similar testimonies, so Mum's experience is far from unique. Later today, the committee will hear from 6 other family members. If you had more time, you could take evidence from hundreds more, but there won't be time, so instead I wish to table 2 documents if I can. The first is a book that was published in 2016 when I worked for Go Gentle Australia, called The Damage Done. The Damage Done. The second is a booklet that Go Gentle and Dying with Dignity published together this year, called The State of Suffering, which Steve referred to earlier. These publications contain testimonies from terminally ill people and their families, doctors and nurses, and they expose the suffering, the trauma and the suicides that take place in the absence of assisted dying laws. The contents are explicit and emotionally powerful. They can be challenging and disturbing, but we believe it is vital for all members on this committee and all members of the Legislative Council to read these personal accounts. to understand why people like me and the wider community want to see voluntary assisted dying legalised in New South Wales. I would like to stress three critical points. Firstly, and most importantly, despite the very best efforts of palliative care, there are some terminally ill people, like my mother, who will be forced to endure the unbearable end stage of their illness with suffering that many describe as torture. The second point is that others who are facing unbearable end-of-life suffering decide to take matters into their own hands to avoid the end stage of their illness. These suicides are lonely and often horrific and devastating for families and first responders. As data released earlier this year showed, over 20% of suicides of people over 40 in New South Wales in 2019 were by people with a terminal or debilitating medical condition or had experienced a significant decline in physical health. The third point is that under the current law, our society already allows someone with end-of-life suffering to hasten their death by refusing all treatment, including food and water, to basically starve and dehydrate themselves to death. In New South Wales, in the absence of an assisted dying law, family members, carers, doctors and nurses have to accept the person's decision to begin this long and psychologically cruel process. It is legal for someone to choose to hasten their death in this way or by suicide, but it can be devastating for all involved based on the testimonies sent to MPs and the examples documented in the publication that I've tabled. A voluntary assisted dying law, in contrast, would give the dying individual the option to die quickly and peacefully at a time and place of their choosing. I would like to finish my opening statement with one sincere request. Please always consider the effect on the dying individual. No matter what amendments are suggested throughout this inquiry or during the debate in the upper house, just ask yourselves, how will this affect the dying individual and will it add to their suffering? The voluntary assisted dying law must be workable so that unnecessary and prolonged suffering can be avoided. I sincerely hope that New South Wales will soon join every other state and pass voluntary assisted dying legislation which would give terminally ill people in New South Wales the same rights as other Australians. Thank you.
Thank you very much. Ms Cohen, I'd invite you to make an opening statement if you would so wish.
Yes, thank you. Actually, I'm one of the people who will be the beneficiaries of this law if and when it's passed. On the surface, I just look like any other 60s plus retiree living the good life in the Port Macquarie area. But you probably wouldn't guess that I'm terminally ill. In 2013, just before my 60th birthday, lung cancer uprooted my life like a gale-force storm. In the 8.5 years since, it's been very challenging for my partner Glenn and me to stay afloat in very unpredictable weather. We're lucky we've had many periods of smooth sailing between some pretty major squalls, of lung surgery and brain surgery when the cancer metastasised. So, but we haven't capsized yet, and I'm grateful for that. And I'm very grateful to have had my life extended time and time again by lung and brain surgery, targeted medications, augmented by the inherent nature of my cancer, which was described by an oncologist as indolent. Whoever thought that being lazy would be a positive attribute? But again, the weather has changed, and recently a new mutation has surfaced like a monster from the deep. Targeted treatment options have run out, and we feel like we're on the edge of a very major tempest. Last week, I finished a course of radiation, and we feel like we're now drifting in a fog of uncertainty. Of course, I'll cling to life, but I'll probably die within a few years. These mornings, I'm wide awake before the birds sing. My thoughts go round and round in a familiar course. Am I going to live long enough to access that in New South Wales? How will I get to Switzerland in the midst of a pandemic if this law doesn't pass? From the very beginning of this end-of-life journey, I've had two very clear aims, and these have never wavered. One is to live well, and the other is to die well, which to me means having the choice to plan a dignified exit if the impact of my illness becomes unbearable and can't be relieved by the best that palliative care can offer. I knew from the very outset that only the choice of a voluntary assisted death would give me the degree of control I needed over the kind of death that I want. I want to be supported by this law to take proactive steps to prepare for for this major life transition as anyone would for any important major life event. I want to die in a way that's consistent with my values and ethical compass, not dictated to by someone else's beliefs about what they think is right for me. As far as I'm concerned, I've already completed a master's degree in suffering over the last 8.5 years, and I've no need to gain a PhD in the subject when I die, as opponents of voluntary assisted dying would have me do. As a voluntary assisted death wasn't, and still isn't, available to me in my home state, I took two pathways. Firstly, in 2015, I became an advocate, volunteering with DWD New South Wales and Go Gentle Australia. In 2018, I took a fall and received the green light, which has given me provisional approval for an assisted death in Basel with an organisation called Life Circle, run by Dr. in Switzerland. I shouldn't have to travel, it goes without saying almost, that I shouldn't have to travel halfway across the world for an assisted death or contemplate moving to another state, as I have also done. But I might have to take this course if federal legislation isn't passed and enacted as soon as possible. Like many people with a terminal illness, I don't fear death, but I'm under no illusions about what a bad death could look like. And the very real prospect disrupts the peace I try to find in each day. I just can't overstate the positive effect that having approval for an assisted death, albeit overseas, has had on me and my family. It's been deeply reassuring to know that if my pain and suffering become unbearable and can't be relieved by palliative care, that I have a choice to say enough is enough and to enact my exit plan. A voluntary assisted dying option has actually put me back in the driver's seat, giving me a sense of control at a time when my life feels increasingly out of control. Applying for assisted death has also been a surprisingly empowering process. It's provided a legal framework for me to think deeply about death and life and what I value and the kind of death that I want. It's enabled me to discuss the confronting subject of death with loved ones and medical professions, normalising these conversations in the context of a society which has incredibly low levels of death literacy. Opponents of VAD emphasise the need to protect vulnerable people. Well, I couldn't agree more. One doesn't need to imagine coercive family scenarios to identify who these vulnerable people really are. They're the people who, like me, without VAD legislation, may die in fear and unbearable suffering. Another concept frequently cast about is that of the slippery slope, inciting unfounded fears that the passing of a VAD bill will herald an inevitable decline of society's moral and ethical standards. Well, from where I'm standing, I can report that the real slippery slope, arguably the slipperiest of slopes, is the dying process itself. I know there are some sturdy grab rails at hand in the form of palliative care and the best medical treatment can offer, but what I really want and need as well is a safety net at the bottom of that slope in the form of this legal framework. Finally, I don't want you to feel sorry for me and then do absolutely nothing to help. Citizen act just feels like callous indifference. I want you to act to protect me and others in my situation at the most vulnerable time in our lives. I want you to help us achieve, what we deserve. The right to a choice for humane, empowered and peaceful death. I want you to help us die. I want you to help us die the way we want to die, protected by a legal framework and a robust and closely monitored management process. And above all, I want you to help families achieve greater peace and save them from stress and uncertainty at the time of their loved one's death. I also want you to act in accordance with the wishes of the majority of the people of New South Wales who have waited far too long for this legislation. In closing, I would like to add that the bill as passed in the Lower House is more than adequate, provides more than adequate protection for the vulnerable, and I hope that the upper house will respect the wishes of the people's house and just pass this bill in its current form. Thank you for your attention, and I apologise for the emotion, but for me it's a very personal issue.
Thank you, Ms Cohen, and there's no apology necessary. We'll now move to questioning. I'm going to invite Mr Khan to commence the questioning.
My question, I think, is directed to Ms Hackett and Ms Offner, but Mr Offner, but that doesn't prevent anyone else from making a contribution. What I'm interested in is the Victorian experience, as that's the scheme that's being operated longest in Australia, and how the expectations of the number of people taking up access to the scheme has, whether that's been consistent with what the expectation was or whether it's been different.
I might answer that. The Victorian experience shows that only a very small number of people seek to access a voluntary assisted dying law. In the first 2 years of the law's operation in that state, less than 0.5% of all deaths in that state were through voluntary assisted dying, which is a spectacularly small number. In the first 2 years, I think that number was somewhere in the vicinity of 330 people. And really, at the beginning of that law, there were no real expectations of the number of people who would take up that option. We had some guidance from countries that had already passed these laws, but their models of VAD were very different. And I think, broadly speaking, it was in the basic expectation, those figures in the first 2 years.
So that's the number of people who've accessed the scheme and, in a sense, gone through the process. What is the number of people who've accessed the scheme but haven't then used the facility that they've been provided, assuming that they've been successful?
According to the statistics from the Voluntary Assisted Dying Review Board that collects some of this data, it's somewhere in the vicinity of 50% of people who apply or initiate the process end up not going through for various reasons, either because they have died already or a smaller number they've felt that voluntary assisted dying was not necessary for them.
I think my next question is to Ms Cohen, because I think it flows on from some of her evidence. Ms Cohen, in regards to that group that accessed the scheme but then didn't go through with it, is what you were saying towards the end of your evidence that there is an assurance given to you by being able to access the scheme but not necessarily using it? Is that one of the points that you are making?
Yes, very definitely. It feels to me like an insurance policy, as with most people with a terminal illness. I'm expecting that I will be in active palliative care by the time I need to make that decision. And yes, I may not need to access that option, but it's very reassuring to know that the exit door is open and it's not it is a choice. It gives me greater choice.
All right.
I would like to add also that I think the Victorian scheme has seen greater integration between palliative care and voluntary assisted dying, and I think that's one of the things that's really needed. It's not an either or choice.
Ms Cohen, do you think, in that regard, do you think the existence of a voluntary assisted dying law actually allows at least some people to have the discussion about death that perhaps they sometimes avoid, and doctors avoid?
Yes. I've had the same GP for over 15, 20 years, and the existence of a bad law in Switzerland and my intention to use it, of course I've had to discuss that with him and with my medical oncologist. And I would say that we've both been greatly educated in the process. It has enabled and allowed those conversations to be had within a legal framework.
All right, my final question is this, again taking into account the Victorian legislation, what, if any, evidence has been gathered since the passing of their law of elder abuse in the operation of the scheme?
Again, according to the Voluntary Assisted Dying Review Board, which is the independent body tasked with overseeing the operation of that law, absolutely none.
Thank you.
Thank you, Mr. Khan. I will now pass the questioning to the Deputy Chair.
Thanks, Chair, and thank you all for coming in today and being with us over the internet. Could I just direct my first question, and probably instead of, I understand there's two representatives from both the key organisations, Dying with Dignity and Go Gentle Australia, so I mean, it just facilitates things. I think if there's one spokesperson for each, so we can sort of get through the questions. So who that is, I don't mind. But if we just go to the bill itself, that is the current bill that's passed the Assembly. And do you have a copy of the bill there with you?
Yes. Would you mind speaking up a little bit? You're
Sure.
a little bit soft.
Said that at Greg before.
I know, I did. We can provide a copy if you So the bill itself, the second print of the bill which passed the Legislative Assembly, you've got a copy of that?
I've only got the first print, but we've got a copy of the amendments that were passed.
We're just arranging some copies for you. Thank you.
Mr. Offner has a copy. Is that a second print? Mr.
I have the amendments that were agreed to.
I'll just pause. Okay, well, I mean, I'll just pause because...
What I might do, we're getting some other, we're getting some other
Here you go. there's a
copies.
copy.
I've got a copy.
And I've got a spare one. If we need a second one, I've got a spare.
Only got
Thanks.
the digital one, sorry.
Well, the digital one, as long as it's a second print. So, do you have a copy there?
Yes.
Yep. Can I just take you to Clause 6 of the bill, which deals with decision-making capacity? On page 3, I think you'll find,
I think that changed.
on my copy.
Yes.
You got that? Can I take you to 6 in brackets 2 that says, for the purpose of this Act, well, it's bill obviously still, a patient is, A, presumed to have the capacity to understand information or advice about voluntary assisted dying if it reasonably appears the patient is able to understand an explanation of the consequences of making the decision, and B, presumed to have decision-making capacity in relation to voluntary assisted dying unless the patient is shown not to have the capacity. In terms of this issue of presuming they have the capacity, this is in terms of the decision-making process with respect to proceeding with wanting to access the legislation. Do you believe that it's a satisfactory bar to just have the presumption of them having the capacity compared to examining to see whether they actually do have the capacity, for example, by involving medical specialists that may assist in diagnosing, for example, depression that the person might be going through, which could be affecting their decision-making?
Well, obviously I'm not a doctor, but I understand that these clauses are consistent not only with the other VAD legislation in other states, but also other laws relating to healthcare and legal matters such as making wills and enduring guardianship, is that it is accepted that the onus is to prove lack of capacity rather than to prove that someone has decision-making capacity. So I think it's legislatively consistent with the arrangements that apply to a whole manner of other decisions that people make in their lives.
So it's a reverse onus, is that what you're saying? But reverse onus of what normally applies?
Yes, it's exactly that. And
Oh, sorry. I think Mr. The Deputy Chair is putting words in the witness's mouth. The witness said exactly the opposite, that it's consistent with the balance of
Yes,
medical...
but then,
So
he
point
put
of- no,
the proposition
order.
and it was confirmed.
Yeah, but...
Order.
Listen, I don't want my time. I want the clock
you
to
know,
stop.
I know-
If he's going to cut in on mine,
Order.
You can't put words in the witness's mouth.
if he's going to cut in on my time...
Order.
So
The first thing
Greg could ask the question again.
Ms. Hackett, sorry, I just need to rule on a few things. The first is that Hansard cannot record when we are talking over each other, and it's also impolite to the witnesses. Now, Mr. Donnelly, we haven't got a clock running on you. I'm prepared to provide you, as much time as you need to get through the questioning, as provided that we get some opportunities to other people as well. Mr. Shoebridge, I accept your point. I don't believe he was putting words in the mouth. He was putting a proposition forward that the witness was more than capable, clearly, of addressing. So I'll allow Mr. Donnelly to continue the questioning. Please, can only one person speak at a time? Thank you.
Okay. So my question was about this presumption, which is contained in 6.2, the proposition that instead of just having a presumption, actually ensuring that the individual is fully able and cognizant of being able to make the decision through ensuring, for example, and I use the example, for example, that they are not suffering from depression. In other words, a specialist would examine the individual and establish that they weren't depressed, medically speaking, and that impacting potentially on their decision making. So the proposition is, this is putting a position of presumption. I'm putting it to you to ensure that the individual was, in fact, clearly in their mind making a decision, which is a significant decision about ending their life through assisted suicide or euthanasia, that there be quite a high bar set to ensure that the person perhaps was not making a serious misstep.
Similar provisions apply to other various serious decisions, including decisions made in medical treatment all the time, including treatments or refusal of treatments which may end a person's life. So doctors are accustomed to determining whether someone has the capacity to consent to decisions of a minor nature and a major nature. So embarking on surgery that may potentially kill them, deciding to refuse treatment, deciding to refuse food and water and hasten their death that way.
I'm talking about this bill, because this is inquiry into the provisions of this bill.
I think it should be consistent with the laws applicable in other circumstances which deal with important issues, including those which also relate to life and death.
So that being the case, I presume you've read carefully the Bar Council of New South Wales, the New South Wales Bar Council submission dealing with this issue of capacity?
I've skimmed through it, but I have not examined it in great detail.
Well, I'll perhaps just direct you to clause 67.
Well, I don't have it. I don't have it in front of me.
Well, you don't have it in there with you. Well, I won't pursue that. I'll just draw your attention to the reference at page 13, paragraph 67, which leads on to a discussion around specifically. And this is what I'm trying to establish, I guess, from yourself, if this is what you're getting at. What's called the...
Can I just jump in there? The witness could, it is available for the witness to take this question on notice and provide a considered response to, so perhaps just so that the witnesses understand that option is available, that they can go away.
I'm not actually asking a question, I'm just taking them to... Well, David, do you have a problem with the questions?
No.
I mean...
Order. We are not going... Order. We are not going to do this today. We are going to be very respectful. Mr. Donnelly, we can provide the witnesses the submission if required. If you want to get questioning on this.
I'm just clarifying her evidence about these provisions in other laws.
Okay.
There is in the Bar Council submission reference to the New South Wales Attorney General's online publication called Capacity Toolkit, which deals with matters of capacity and decision making. Is that what you are referring to, or in terms of what's recommended in New South Wales, or?
I'm not familiar in detail with that toolkit, but my understanding is that in a whole range of legal and medical circumstances that capacity is presumed.
Okay.
And Mr. Donnelly, I'd add that it is a cornerstone of the law of consent, this assumption of capacity. And I would say to reverse that assumption in the case of terminally ill people seeking VAD is inconsistent and unjust. And there is no special case. And if there is a special case, I would say the onus is on others to point to why there should be a special case that assumption should be reversed.
Some may
Mr.
argue.
Donnelly, I'm just going to. We've got Mr. Shoebridge, Mr. Diadam, Mr. Martin, who want to ask some questions. So I'll pass to Mr. Shoebridge, and I'll come back to you if that's okay. Mr. Shoebridge, you've got the call.
Oh, thanks, Chair, and thanks to all of you for your time today, and particularly Janet. Thank you for giving up your precious time to come and be here with us today. My question was actually to Mr. Wood. Mr. Wood, I think it was you who gave reference the most recent study of the experience of the Canadian medically assisted dying laws and the review of a series of practitioners and their experience of medically assisted dying laws. I thought that was your most recent submission. Did you want to just give a brief summary of what the conclusions of that study were?
Well, to sum up, conclusions were that there were very many positive aspects of their medical assistance in dying law, and that it led to further discussion with the doctors. The overall experiences of dying were positive. We get people in an obituary congratulating and thanking the Canadian government for passing the legislation that gave them the peace of mind when they were approaching death, and overall it's positive.
Ms. Cohen, in many ways, what people in your situation are asking for is a sense of empowerment at this time in their life. Do you want to talk about how empowering that would, if we'd passed the laws and it was applicable for you, how important that sense of empowerment is?
Well, death is one of the most confronting transitions we will ever make, all of us will ever make in our lives. And I think the culture around death and dying is changing in our society from being a subject that we shy away from, that we fear, to being a subject that we embrace and that offers us an opportunity to think really deeply about the things that we value in our lives. And that in itself is a very empowering experience. Not being afraid is an empowering experience. Not having the background to your days filled with anxiety and uncertainty is an empowering experience. Being able to talk openly to medical professionals about one's wishes is incredibly empowering. And I think that whole scenario is changing for the better as well, where patients are being seen more as equals with their medical professionals, and a patient knows just as much about what they want as their medical professional does. It's we're going from a situation of control by others to self-control and independence. And for me, personally, it's been a very supportive experience. Dr. Erica Pricey, I've been in communication with her since 2018, and she's an advocate for voluntary assisted dying programs all over the world. But surprisingly, she has encouraged and empowered me to live a better life since being diagnosed with a terminal illness. The emails that we shoot back and forth are very supportive. I thought I was going to die in 2018. There was no other treatment available. I was on the edge of the cliff. And she emailed me back saying, don't give up right now. I understand why you need this reassurance, but I don't actually want to see you in Switzerland. I'd prefer that you didn't come here. And absolutely, so would I. So, yes, I hope that's answered the question.
No, it has. And I suppose, Ms. Higson, reflecting back upon your family's experience and how different do you think it would have been if there'd been that ability to have control?
It would have made an enormous difference. My mother was told at the very first appointment after her seizure, they did an MRI, and she was told that there was nothing they could do to save her life and that she had less than 12 months to live. She actually only lived 7 months, but her condition deteriorated rapidly. She actually asked, when they told her that there was nothing more that could be done, or nothing that could be done, she asked the doctor, the neurologist, "You will help me at the end, won't you?" And I was in the room at the time in St Vincent's Private Hospital. And of course, he didn't answer that question because we were never going to see him again, because Mum was referred to palliative care at that point. And obviously, he knew that he wouldn't be there for the full journey. But I know that my mother she loved life. She had 5 beautiful grandchildren that she just, adored. She wanted to live for as long as possible. It was only and she, withstood so much suffering through that 7 months, but it was only in the last sort of 3 weeks or so that the suffering, all the symptoms were so bad that she started asking to, for something, as I said, to just be knocked out, because she had had terminal sedation described to her. But the fear, when that wasn't possible, it was just terrible. And she was under the very best of palliative care, a top palliative care specialist. But under the current laws, they are not allowed to hasten the death. And so Mum wasn't able, she wanted to avoid just that last few weeks, which is what so many people want. And when Mr. Khan asked earlier about the peace of mind that it gives people with terminal illness to know that that's an option, not only is it giving people like Janet a peace of mind, but it's also preventing the suicides that we know occur. And I believe that there will be a witness later this afternoon whose husband, Laurie Daniel, was in the damage done, and I knew Laurie. He had multiple sclerosis. His symptoms were very severe. He was in a wheelchair, and I'm sure you could get more information later. But he ended up having to take his life earlier than he otherwise would have, because he would have lost the ability to end his own life if he waited for the multiple sclerosis to progress. If New South Wales had had voluntary assisted dying laws then, he would have had more time to spend with his wife and his 2 young children. And that is, I think that should be remembered as well. But I'm confident that my mother would have been one of the people who would have wanted to have this option. And I would picture that she would have chosen to end her life just 2 weeks earlier. And she would have been able to say, the thank you to me and my sisters and her partner for taking care of her. But instead, my mum died angry and so disappointed that we couldn't help her. At one point in those last few weeks, when she was struggling to talk because brain cancer affects that, and she was paralysed down one side, she actually put my sister and I and her partner were in the bedroom round her bed, and she looked at her partner and she just put her hand up to her throat, the one hand, to indicate, please kill me, like strangled. She was so desperate. So no family would want to do. I know it would have made a huge difference to my mum to be able to die peacefully.
Thanks, Ms. Higson.
I'll now pass the questioning to the Honourable Taylor Martin.
Thank you, Chair. And I'll begin with a question to Mr. Offner from Go Gentle Australia. In your submission, it states, and I quote, GGA broadly supports the bill as put forward by Alex Greenwich MP. What aspects of the bill lead you to use the wording broadly opposed to, for example, completely support in regards to the bill?
I think just in the general sense of the word, we expressed broad support for the detail and the intention of the bill.
Okay, well, I'll be more specific because this is an inquiry into the provisions of the bill. So which provisions would you like to see written differently?
I think if you have our submission there are certain recommendations that we made that we felt would strengthen the bill. However, that submission was written before the lower house debate.
Yep.
And we're completely comfortable with the bill as it emerged from the lower house after that scrutiny. And the lower house was very comfortable with the bill, and they voted very strongly in favour of that bill, and we're very comfortable with that outcome.
So lowering the length of time practiced by a GP from 10 years down to 5 years, that was in your submission?
That was one of the points that we thought there was an inconsistency in the bill.
Okay, extending the time frame to 12 months for all diagnosis?
We would broadly support that notion, yes.
Okay, so I guess to the point of my questioning here, and the reason why the wording broadly has kind of led me to ask these questions, if this bill passes the upper house, will your organisation then seek to have those amendments made to what will then be the law of the state to change?
No, we will abide by the decision of the Parliament of New South Wales.
Will your organisation cease to operate because you'll effectively have achieved your end goal of having euthanasia in New South Wales, or?
That is one of our goals, but it's not every goal of our organisation.
Okay, could I ask the same of
not euthanasia,
dying with dignity? Will your organisation continue to advocate?
I'm going to take an objection to this line of questioning. This inquiry is in relation to the bill, not future campaigning, not the organisations that are before us, but the bill. We have a very limited term of reference, and we have a limited amount of time, and I'd ask that you restrain the questioning to the bill, not the future campaigning of these organisations.
Well, to the point of order.
Point of order. I mean, listen,
I'm prepared to...
example of cutting into people's time.
I'm already prepared to rule on your point of order. While, Mr Shibridge, I accept your position, I do note that obviously we've got witnesses who are providing evidence that has other jurisdictions, examples of other jurisdictions, and so I'm going to allow Mr Martin a little bit of latitude here with his questioning, but I will remind him that it is an inquiry into the bill, and so there is a reasonable amount of latitude, but there will have to be a point where we draw a line. But you, at the moment, I'm going to permit you to continue your questioning.
Okay, at the heart of my questions is really, I'm asking, is there consensus around the provisions in the bill introduced by Alex Greenwich and passed in the lower house, to those few examples that me and Mr Offner went over a moment ago, that's the bill will become the law if it's passed by the upper house, and it will basically stay as is, or does it need to be widened?
The simple answer is yes. We are very happy with the bill in its current form. And I understand that there is a review process built into the legislation, and that's right and proper. And if there are things that need to be considered at that time, then of course that would be entirely appropriate.
Okay, thank you. Anything to add, Ms?
Just that I'm very happy to answer your question about what we do should a bill pass.
Yeah.
The experience of particularly Dying with Dignity Victoria and now Dying with Dignity Western Australia is that they have had to play a very big role in the implementation process and making sure that it's implemented expeditiously and that all of the intent of the law is followed through in terms of guidelines and things. We also feel that we have a strong process of education for not just the public but also practitioners, and we've already started engaging with groups like the College of Regional and Remote doctors and other groups. We would expect that we would be presenting to them to give them an understanding about how the law works. There's a very low level of literacy on this issue in the medical profession because they're busy being doctors. And there's also other groups like, for example, used to be Life Circle, but now Violet, other people that provide support and counselling to people who are dying, but also healthcare institutions. There'll be a very big burden on a lot of organisations in getting themselves set up, whether they are prepared to permit VAT on their premises or not. They will need to be prepared to answer questions. So we will educate and participate in the process and also monitor the implementation to make sure that it's in accordance with Parliament's intentions.
Ms Higson, did you want to add to that?
Well, I'd just also like to point out that Dying with Dignity, as the name reflects, we're not just about voluntary assisted dying legislation. For many, many years, we have been providing advanced care directives. Not everyone who is reaching the end of their life will be able to access voluntary assisted dying. As we know, it's less than half of 1%. So our organisation does care and deals with other end-of-life care and advice and that sort of thing. So I can't see our organisation folding.
Okay, thank you. Mr Wood?
Our organisation would certainly be supporting legislation in the two territories, and then I would suspect that the main reason for our group perhaps cease to exist, except that some members would be encouraged to be willing to put themselves forward, perhaps to act as witnesses in some of the applications and so on.
Okay, thank you, and thank you for that particularly informative answer, which Mr Schubers has left, but he need not run interference because that was actually very helpful. Thank you.
Thank you very much. I'll now pass the questioning to Mr Diadam.
Thank you, and thank you for your appearance today and your submissions. They were very helpful. I wanted to turn to the issue around terminal sedation. And I suppose my question is, why is terminal sedation not an adequate approach to dealing with end-of-life care? And perhaps to elaborate on that, what are the kind of regulatory arrangements that exist for terminal sedation that perhaps you could elucidate on that?
If I can start with some more technical things, but then Shane can give you the actual experience of her mother having had terminal sedation. Under the palliative care guidelines, terminal sedation is really only available when it's assessed that the person has only 2 or so days to live. And as I'm sure everyone who has watched someone dying from cancer will understand, that the suffering is not just in the last 2 or 3 days, and it is the case that you can be effectively made unconscious in an induced coma by terminal sedation, and you might have no actual suffering during that short period, but you may well have had months and months of terrible suffering prior to that, which terminal sedation, firstly, not available, and secondly, people do not want to be unconscious for very long periods of time. So we would like to see terminal sedation used more widely. It's an arbitrary choice about 2 days or a week. There are stories of people who've been put in terminal sedation who have lived for, weeks, if not months. And the point of that is that the person will starve or dehydrate to death during that period, or their symptoms or the course of their disease will lead to their death, which could involve massive tumours, growing, suffocation, those types of things. As we understand it, the intention is that the person is not conscious or aware of that suffering, but and I think you can ask these questions of the doctors that will be appearing, but it's not always the case that the person has relief of symptoms. There's also an issue within the palliative care specialty about whether or not terminal sedation is actually slow euthanasia. So there are some who will not administer it.
I'd just add too that terminal sedation is one of the tools in the toolbox, and it's used as a last resort. It does not prevent suffering. In fact, it's a response to suffering that is already happening and that cannot be managed. So, as Penny said, there can be weeks, if not months, of intolerable suffering leading up to the point where the patient is put into terminal sedation. So, it is a last resort. And I would also add that from our research, many people who have a terminal illness do not want to be sedated into a coma at the end of their life. That is just something they do not want. And so it is a last resort, but it's one that most people, many people, do not wish to have.
Can you perhaps explain how does the decision about electing for terminal sedation occur?
It's often administered without the patient knowing they're in such a desperate circumstance that the decision is made by the doctor or the doctor in consultation with the family. We would actually prefer that it be formally discussed and offered to people as an option. I think that does happen sometimes, but other times it's a response to a desperate set of circumstances where they have tried everything and the solution to the distressed person is to fill them up with I'm not sure what the drugs are, but it's intended to render the person unconscious to various degrees. What they call titrate it to the level that they consider is going to be sufficient to relieve the person's suffering. Our view is that if someone is suffering that badly, they should have had treatment or whatever drugs are necessary to relieve that suffering at the time, rather than having to wait until they reach a sufficient level of suffering that the doctors decide based on guidelines or their judgment that the person then qualifies for terminal sedation. So the person generally doesn't put their hand up and say, I'd like to have some terminal sedation, please.
It's not that active. I suppose where I'm getting at is that there's not that active process of consent and consideration that occurs that's proposed under the legislative framework for voluntary assisted dying, and there doesn't appear to be there's the two practitioners. That process is not. There's not a sort of like double oversight process applying to terminal sedation. Is that correct?
No, that's definitely from the experience is. Not just my mum's experience, but I've got friends too this year whose parents, died. At the end, it was increased levels of morphine, and those discussions were not made with the patient. It was just the family member and with the doctor. And I think everybody probably knows of cases where that is true, but also the so-called terminal sedation that my mum had at the very end when things were so desperate. It was not like a general anaesthetic. And I would, obviously I'm not a doctor, and I hope that you will have medical specialists who support assisted dying who can explain in more detail the medical thing, but I can just say from looking on and also from the evidence from all the testimonies that we've written that people are not fully unconscious. My mum, in those last few days, the leg that wasn't paralysed was moving up and down on the bed. Her head was rocking from side to side. If that happened when you were having an operation on a general anaesthetic, I think the anaesthetist would be rapidly changing things. But so the reason why the level of medication is not high enough to fully, take away all symptoms is because that would be pretty much, as Penny said, admitting that it's euthanasia, slow use. So it's a grey area, and that's the whole problem. And I would love to see that change. That people, I as a personal thing, not representing Dying with Dignity, but I cannot see the difference in that terminal sedation over 5 days or longer and allowing someone to die quickly and peacefully with voluntary assisted dying. It's not such a huge difference in my personal opinion, and it would just mean that someone like my mum would not have been forced to endure that last stage suffering.
Look, I wanted to come back to the issues that Mr. Khan raised around the experience in Victoria So correct me if I'm wrong, but the Victorian system also has a mandatory training requirement for practitioners who are involved in the process. What can you tell us about the uptake of training? Has that been an issue? I suppose, you know, there's the threshold issue about whether a voluntary assisted dying right should be established at law. And then there's the question about access. If we say people should have a right to voluntary assisted dying, how do we facilitate access? And I suppose one of the potential blockages is there's not enough practitioners in the system who have the training and are actually in a position to be able to implement the scheme. Can you perhaps...
Yes. Look, it has been one of the issues in Victoria and also to our understanding in Western Australia, where VAD has been operating for several months now. And it goes some way to answering Mr. Martin's question before about what our role might be after the passage of this law. There's a huge need for education and information sharing about the option of voluntary assisted dying. Doctors, like the general public, may not even be aware. I mean, it might be hard for us to believe because we're so entrenched in the debate, but there would be many doctors in Victoria still who would not know that voluntary assisted dying was an option. The Victorian law itself provides some restrictions on the sharing of information about voluntary assisted dying, which I'm happy to say the New South Wales bill avoids. So you aren't, for example, from the patient side, you know, the doctor isn't allowed to raise the option, the legal option of voluntary assisted dying. So there is a general issue with, you know, the profile of voluntary assisted dying in Victoria. But to answer your question specifically, there was a reasonable uptake in the training initially, but like everything that is new, it takes time for people to understand the processes, understand what's required, and doctors are very busy people, and the training, which is an online training over a day or more, is quite strenuous. And there is you know, it's a 90% pass rate. I think you need to achieve 90% to actually pass. So it does require a lot of doctors. And so it's perfectly understandable that some doctors would be reluctant to take up that training. But we imagine that in coming years, there will be a much greater uptake, especially by specialists, which there is, especially neurologists in Victoria. There does seem to be a lack of neurologists taking up the voluntary assisted dying training, and that is imposing some quite unnecessary barriers to access for people, especially with neurodegenerative conditions in Victoria.
Mr. Diadam, do you mind if I come back to you? I've got Mr. Roberts, Mr. Khan and Mr. Donnelly who have got some questions. Mr. Roberts, you've got the call.
Okay. Thank you, Mr. Hoffner. I'll direct my question to you firstly. The last time a bill of a similar nature came before this Parliament was in 2017, and you're probably aware I wasn't in Parliament at that point in time. But I just want to ask you, did you and your organisation support the 2017 bill as it was?
I could give evidence on that.
Oh, well, I'm sure you can, and I'm asking Mr. Hoffner as witness today.
They were not enthusiasts.
Look, that is true. I wasn't with the organisation in 2017, but it is my understanding that Go Gentle was very focused on the Victorian bill and its passage through Parliament. There were elements of the 2017 bill that we weren't enthusiastic about, as Mr. Khan has said. Having said that, I think the 2021 bill is vastly superior and stronger in almost all respects.
Cruel, but fair.
Mr. Roberts, have you completed?
No,
Thank you.
Thank you.
Mr. Donnelly's now got the call.
Thank you, Chair. Listen, my question is directed to both the organisations. You obviously have a membership base, both organisations. I think you described the membership of at least one of them in terms of size. And you have a number of supporters who clearly wish to control the time of their death. I mean, presumably that's one of the reasons why they become members of the respective organisation and participate in what you've been doing over a period of time. But they would not, a number of those people would not be entitled to VAD under the proposed legislation that's before the New South Wales Parliament now, as amended by the Legislative Assembly. Don't you believe that that clearly discriminates, that the bill as passed by the Assembly clearly discriminates against those individuals of your organisation who wish to, as I've said, control the timing of the end of their life?
Obviously, some of our supporters are facing a terminal diagnosis, and some of them would qualify under the VAD bill. For others...
I'm talking about those who are not eligible.
Well...
Just allow Ms Hackett to finish her answer, Mr Donnelly, before we interject. Thank you.
People generally understand, obviously, that death is inevitable, and we live in a community where almost everyone will have some contact with the death of someone they know or love at some point in their lives. Now, many of those people have seen deaths which have caused them to either be traumatised themselves, or it has made them fearful about their own death, and they would like the comfort of knowing that if they are in that circumstance themselves, there would be an option available to them. I don't think our 110,000 supporters are sitting there worrying about whether they would be eligible for VAD. They are of all ages and in all locations.
But the proposition is that you would have members, and indeed Go Gentle Australia would have members, who wish to and have articulated to both organisations the desire to have the ultimate control over the timing of their death. That clearly is the case with members of both organisations. The proposition I'm putting to you both separately is that with respect to the proposed legislation, and I can't put a number on it, but there would be presumably numbers of people in both organisations may not be eligible for VAD under the proposed amended legislation. So my question is, does that not mean that this legislation is clearly discriminating against them in terms of their choice to have control over the timing of the end of their life?
So I think you're asking about theoretical discrimination relating to people that don't have a terminal illness. I'm not quite sure what it is that you're asking.
Well, I'll repeat it again, that you've got members of your organisation from various backgrounds, but clearly articulating to both organisations their desire to control the timing of their death. They articulate that position to both organisations. So my question is that this legislation creates a framework which is not going to enable them to meet their desires. Does that not create a situation of discriminating against them or depriving them of their opportunity to end life on their own timing?
I think any legislation is drafted within certain parameters, and this legislation has been drafted with quite strict parameters. So by definition, there will be people who will fall outside those parameters.
Right.
I think that is right and just in a piece of legislation like this. Go Gentle Australia is not a membership organisation, but yes, we have supporters, and we do know that some of those supporters would like a broader bill. And, you know, I think a vast majority of people would like to control the timing and circumstances of their death. But there will always be people who will fall outside the parameters of any legislation, and this legislation is no different. And I think that is completely appropriate. I think discrimination is probably the wrong word to use.
We've only got about 5 minutes left, so Mr. Donnelly, I'll allow you one more question. Then I've got Mr. Diadam and Mr. Farlow's indicated he's also got a question. So
Okay. No. I've had my day.
Just moving on to this issue of the issue around the prognostication of end of life, and the matter of, and this goes to the very heart of my point about the eligibility criteria in clause 16, 16(1)(d), about the person is diagnosed. We're talking about the diagnosis of the condition. That you would be aware, I presume, that, and this information is in the public domain, quite readily available, that oncologists generally have up to a 5-fold error rate in prognostication in favour of longer survival than actually occurs. Intensive care physicians generally have a 3-fold error rate in favour of shorter survival than actually occurs. And it's well accepted in medical science and medicine that estimating prognosis has wide, I repeat the word wide, errors of margin. And I note that witnesses coming before the committee later today, Professors Ben White and Lindy Wilmot, did a study which highlighted the high levels of inaccuracies of prognostication, which in fact Go Gentle incorporate in their submission. Now, rather than arguing that doctors get the prognosis wrong, I'll put the proposition to you that the issue of the 12-month window is not satisfactory. That what we really need to be doing is looking to see how we can better diagnose the conditions that people may be suffering to enable them to better understand their circumstances, and thus the argument for providing access to specialised medical individuals like the oncologists, the palliative care specialists, etc., etc., etc.
I think if there's a way to improve diagnosis of all illnesses, then we would welcome it. And I don't think there would be anyone who wouldn't. And in terms of prognostication, it is an inexact science, and any doctor will tell you that. But I think, you've referred to error rates. I think there's doctors usually overestimate the time that people have left, not underestimate.
Well,
and I think the error rate...
That's not what I put to you in what my...
I think if you're referring to the Ben White and Lindy Wilmot study, that's exactly what they found.
Mr. Diadam.
I wanted to ask just about the, perhaps you could take this on notice. When Miss Cohen was talking about her situation and her plans to go to Basel in Switzerland, it struck me that there could be significant, I suppose, financial barriers to people accessing the scheme, and I wonder whether the Victorian experiences, whether there's been any analysis around the socio-economic availability of VOD in Victoria, and I suppose the other sort of issue that would be useful to know is around the regional access question, and whether the experience of Victoria has been that there's been an imbalance in terms of the access for those who live in a region and perhaps aren't able to access consulting doctors necessary to actually meet the requirements to access the scheme, perhaps.
I'd encourage the members of the committee to actually look at the Voluntary Assisted Dying Review Board reports. They've done 6 monthly reports over the first 2 years of the law's operation, and a lot of that detail is included in those reports. So I'd encourage members to read those. In broad terms, socioeconomic situation, unlike other jurisdictions around the world where there seems to be a skew towards sort of higher socioeconomic characteristics, it seems to be quite a balanced spread in Victoria. The same can be said for the regional and metropolitan people accessing the law. There's a slight skew towards people from the city, but there are higher numbers of people in the city. And one of the things that those reports does make very clear, and I think that the board has already made recommendations on, is trying to encourage more specialist uptake of the VAD training in regional areas, because that does seem to be an area of great need. People in regional areas in Victoria, and it would be no different in any other state, usually are limited to the number of specialists that they can access, and to access those specialists they usually have to travel to a metropolitan area, and anyone with a terminal illness will find that quite difficult.
Unfortunately, we've run out of time. Mr. Farlow, I'm so sorry. Are you happy to put your question on notice? If you
I'm interested that we keep to time. So look,
so that's what I'm saying. You're happy to put
it to another witness later today.
Thank you very much. I appreciate that.
Sorry, just before we finish, I forgot to mention that I do have some booklets to table for the committee as well. So if I could,
thank you. The committee staff will liaise with you to get those tabled. For the witnesses that have taken questions on notice, the Secretariat will be in contact with you to liaise and arrange for the tabling of those answers. And I thank you very much for your appearance today. We'll be taking a short 15-minute break, and we'll be returning at 11 a.m. Thank you.
Thank you.
Well, welcome back to the second session in the hearing today. Starting from my left, I'll invite the witnesses to state either an oath or affirmation and their name and position title.
My name is Laura Toos. I'm a legal officer from the New South Wales Nurses and Midwives Association. I'll be taking an affirmation. Thank you.
Okay. Do you have the affirmation in front of you?
I do.
If you could state that now, that would be fantastic. Thank you.
I solemnly and sincerely declare and affirm that the evidence that now to be given shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And I'll just remind all witnesses, if you can bring the microphone nice and close so that it aids audibility for Hansard, for us in the room, but also those on the broadcast.
Shay Candish, Assistant General Secretary of the New South Wales Nurses and Midwives Association. I'll be stating the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much.
Hi, my name is April Fleming. I'm a registered nurse representing the New South Wales Nurses Association. I'll be taking an affirmation today. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Now, will any or all of you like to make an opening statement?
Yes, thank you, I would.
Thank you.
Thank you to the committee for the opportunity to speak at this important inquiry into the provisions of the Voluntary Assisted Dying Bill 2021. As Assistant General Secretary of the New South Wales Nurses and Midwives Association, I'm representing over 73,000 members. Our organisation is the peak professional and industrial organisation for nurses and midwives. Our association believes a fair and just society is one in which people with a terminal illness are afforded the liberty to decide the healthcare and medical treatment they receive at the end of their life. And this includes access to voluntary assisted dying, which can assure them a good death, one that offers them dignity and compassion. As referenced in our submission to this committee, a recent survey of almost 4,000 members found more than 85% are in support of voluntary assisted dying law reform. Meanwhile, 84% indicated having professional experience in providing care to terminally ill patients, and over half of those had been asked by a patient for assistance to end their life. Nurses want to deliver care that recognises and upholds the rights of their patients to make informed decisions about their care. Current laws can prevent clinicians from providing the specific end-of-life care that a terminally ill patient may seek, and this conflicts with nursing obligations, which require that nurses must advocate on behalf of people in a way that respects their personal autonomy and decision-making capacity. We respect that the topic of voluntary assisted dying is confronting for some, and and we believe this bill offers a clear process for access to voluntary assisted dying in appropriate circumstances, whilst also maintaining the rights of those who conscientiously object to participation. We are also committed to supporting any of our members who exercise their own professional objection. Our association is satisfied with the legislative protections that would be extended to nurses and other healthcare workers who do participate in this process, or who engage in discussions with patients in their care. We support the requirement for those participating to be provided with all the appropriate education and professional safeguards for their work. And importantly, this legislation and its amendments will ensure people can still access palliative care options. It is our position that those suffering from a terminal illness are entitled to receive well-resourced palliative care, as well as having the option to seek access to voluntary assisted dying in the proposed regulated manner. Our members provide high-quality palliative care that for many patients does alleviate their physical pain and provide adequate levels of comfort. However, it's widely acknowledged among our members that palliative care is not effective for all terminally ill patients, and some do experience unbearable pain and suffering for prolonged periods. As a previous emergency nurse, I can recall several occasions when terminally ill patients would seek access to emergency treatment to relieve acute exacerbations of their symptoms associated with their illness. After a long and often uncomfortable stay in our emergency department, the best we could hope for was to provide these patients with some minimal relief from their discomfort. In closing, on behalf of our members, we sincerely encourage this committee to choose compassion over politics, to recognise the significance of the suffering by those who are terminally ill, to respect the professional integrity of the clinical practitioners who would participate in the process of voluntary assisted dying, and finally, to recommend the passage of this well-considered law reform through the upper house. Thank you.
Thank you very much for that opening statement. Did anybody else in the witness panel have an opening statement? If not, I will pass to questioning.
No, thank you.
Okay. Mr. Khan, can I invite you to ask the first question?
Yes, look, seems to me we're confronted, at least in terms of some of the mountain of emails we receive, with an either or in terms of palliative care or assisted dying. I take it from your submission you see them as complementary. Is that the case?
Absolutely. We wouldn't advocate for an either or option. We think that voluntary assisted dying provides people with additional options for treatment that they don't have access to currently. So it's one of the many options that can be considered when they're considering their end-of-life care.
And we have received in this inquiry, no, I withdraw that. It seems that some people, including some health practitioners, assert that the way forward is more expenditure on palliative care because that will provide the answer for patients. What do you say to that proposition?
We would absolutely welcome more expenditure into palliative care. We think there's much more that can be done in that space, but that doesn't provide the same opportunities for patients to exercise decision making as voluntary assisted dying does for those that would want it.
So if I go to page 6 of your submission and I go to the blue bits, and the first of those blue bits, or the first paragraph, is this observation: too many times I've watched people suffer to their death with pain medication no longer relieving their symptoms during palliation. And there are a number of those paragraphs or statements that are repeated over the next page.
Mm-hmm.
Is what you're describing bad palliation, or is it a question of an ineffectiveness because of the nature of the disease that the patient is suffering from?
Look, I think the value of voluntary assisted dying is in the second example that you've offered there. It's really about when all of the medical options have reached their limits. Sometimes we can't provide any further symptom relief for people. I have no doubt there are aspects of bad palliation, but those things can be improved. But there are people who will experience a level of deterioration in their health that all of the modern healthcare we have for them simply can't provide symptom relief. And in those instances, voluntary assisted dying really offers people an opportunity to access some level of control over their healthcare that they don't currently have now.
So just in terms of weighing up, and I'm not in any way being rude when I say this, but weighing up which group of medical professionals we should give appropriate notice to, in terms of caring for a patient in those final weeks of life, how much time is spent with the patient, say by the palliative care specialist, as compared to the nurses on the ward?
April, this might be something you might want to talk to.
So I'm currently employed in a publicly funded specialist palliative care unit in metropolitan Sydney, and I've been working there for 5 years. I mainly do night shift, where I spend 10 hours with patients. The patient load varies, but I'd say 9 out of the 10 hours are direct patient care.
And when you compare that to the palliative care team or the overseeing doctor, how much time would they spend with the patients?
So the overseeing doctors aren't there every day. There are doctors that review the patients daily, and on a night shift we might liaise with the doctor on call if needed to amend any of their cares. So I would say it could be anywhere between half an hour a day, maximum an hour a day, once a week.
Now, much has been made of the issue of suffering, and indeed, one of the amendments that was proposed was that suffering in some way be defined as physical pain or similar words to that. Would one of you describe the nature of the suffering that a patient, say, with a liver cancer experiences? Obviously, one of those is pain, but there are other symptoms or things that patient goes through in the end stages of their life.
Would you like to? Yeah, I'm happy to take that. So a patient with end-stage liver cancer would be quite symptomatic, often with pain from the liver cancer. They might have metastases to other organs or bones, which is quite painful. They often have an ascites, which is a collection of fluid in the abdomen, which is...
that is, and sorry to break in, but that is, and I'll tell you, this is a description of my father.
Yep.
Their belly will blow up to a very considerable extent.
Spot on.
Yeah.
Yeah, and that causes pressure and pain. They may have a itch, which is irretractable. There's limited medications that we can use for this itch, and it is very distressing. It interrupts their sleep. And they have a build-up of toxins because their liver is not processing that properly, which can cause hepatic encephalopathy and confusion. And so they are quite distressed emotionally as well.
If I can add as well, as a former emergency nurse, these types of patients would typically present to an emergency department. So, they would be receiving usually palliative care, but they would come in to receive some assistance around that acute exacerbation of the ascites. So we would tap that fluid and take it off, which would give them some symptom relief in terms of them being able to breathe more capably. And the challenge is the more that we do that and we intervene, the faster the fluid would come back. So, you provide a level of symptom relief, but it is only for a period of time.
So I've just picked one example because it's close to my heart. Sure. But when we talk about suffering, do I take it we're not simply talking about fixing pain? There are a whole range of other symptoms that patients experience in those end stages of their life.
Absolutely.
All right, we could go into some other outcomes of that build-up of fluid, but I think we're probably best to leave it alone. I'll finish there.
Thank you very much, and I'll pass now to the Deputy Chair.
Thank you, Chair, and thank you for coming along. Just in regards to your submission on page number 11, dealing with the matter of conscientious objection. Now, before I proceed with my questions around that, with respect to the New South Wales Nurses and Midwives Association, you acknowledge that there is a specialist organisation called the Palliative Care Nurses Association of Australia?
Yes.
Limited. And what's your association or relationship with that organisation?
Do you want to talk to that? I can talk to that. We don't currently have any association. We're the registered trade union and also professional association. We're the largest professional association representing nurses and midwives in New South Wales. Palliative Care Australia, you may be better to direct that question to them in terms of their...
Could I just ask you to bring your microphone a little bit closer, please?
The Palliative Care Nurses Association.
No, sorry, you might have to bring it closer. Apologies.
Sorry. Thank you.
The organisation called the Palliative Care Nurses Association. You have no relationship with them?
No.
No. Okay. You know nothing about what they actually do?
I would say that they're a specialist organisation representing the interests of a discrete group of nurses who are their members.
Palliative Care Nurses?
Yes.
Yes, okay. Now, moving on to the issue of your organisation, does your organisation enrol and represent student nurses or nurses in training?
Yes, we do.
Yes, yes. And they pay union fees and are represented in any other way by your organisation, industrial and otherwise, in terms of services?
That question has a few elements, I suppose. So if they're purely student members, then no, their membership with us is free.
Okay, so free, okay. But they're bona fide members of the organisation? They are members of the union and have rights other than paying fees equivalent to a fee-paying member of the organisation. That's right.
Well, they don't exercise voting rights and they don't have industrial representation because they're students. They don't have. They're not working or having coverage within the industrial framework.
So they don't have industrial representation?
Not if they're working, then they would be a full fee-paying member. If they're simply students who are not working, then they're not fee-paying members. No.
Okay. In page 4, clause 9 of the legislation, which deals with the conscientious objection, it says registered health practitioners may refuse to participate in voluntary assisted dying. 9.1 says a registered health practitioner who has a conscientious objection to voluntary assisted dying then goes on and lays out the issues or provisions. But it specifically says a registered health practitioner. Now, if we go to the back of the legislation, under the definition of what a registered health practitioner is, you would be aware of what a definition of a registered health practitioner is?
Yes.
Yes. So it says, means a person registered under the Health Practitioners Regulation, national law, to practice a health profession. Now, I won't read on at this point. So are nurses covered by that?
Yes.
So all level of nurses?
All level of nurses who are registered. So that is registered nurses, enrolled nurses, nurse practitioners, which are a subset of registered nurses who hold endorsement.
Sure. Then it goes on here in this definition to say other than a student.
Yes.
Other than a student.
Students are registered under the national law, the Health Practitioner Regulation national law, as students, and that it has a distinct definition under the national law from registered health practitioner.
Indeed. So my question is this, that if there was a member of your organisation, this is if the new legislation passed and came into effect, who was a student as defined by that legislation and presumably your student classification or category of membership, they would not be covered by the conscientious objection rights in the legislation. That would be right? Because this only applies to, the conscientious objection provision only applies to a registered health practitioner that has a specific definition.
Yes, but students who are on placement, nursing students who are on placement, have a very limited scope in terms of what they're able to do on those placements. Participating in a process of voluntary assisted dying would be well acknowledged to be outside of the scope of what a student would do in the course of a placement.
Can I just ask for clarification? Is it okay? Sorry, just with regard to registered medical practitioner, that's not related to registration with you per se, is it? It would be registration with the New South Wales Health Department?
No, a medical practitioner is a category of health practitioner who is registered under the Health Practitioner Regulation National Board. So a medical practitioner is commonly known as a doctor. They would be registered with the Medical Board of Australia.
Yep.
A nurse would be registered with the Nursing and Midwifery Board of Australia.
Yep.
So that is
which is separate to your, so.
Yes.
Yeah, but for the purposes of this definition in the legislation, which says a registered health practitioner, this is what the legislation provides for, means a person registered under the Health Practitioners Regulation national law to practice a health profession. Nurses in New South Wales are covered by that definition. Is that the case?
Yes.
Right. But not if they're students.
No.
No. So my question to you is that if you had a student working in a facility and there was voluntary assisted dying arrangements in practice in that facility, the students would not be protected by the provisions of this legislation, would they? In terms of having the conscientious rejection rights.
I'll just remind witnesses that they can take questions on notice.
No, I think I will take that on notice. I believe that there is a protection, but I would like to clarify whether or not it's in the current.
No, that's fine. That's fine. On the question of the issue, and you made this point very clear at the start, that obviously nurses are not medically trained to the extent of a doctor, a GP, and certainly not trained to the level of a specialist. You would be aware that with respect to diagnosis and prognostication around end of life, that is death, that in fact it's very hard to predict that, isn't it?
To predict the prognosis of a patient?
To predict when a person's going to die.
I would say that nurses exercise caution in this space. Exactly as you said, they're not doctors and they don't try to be. But they certainly have a certain level of experience working with patients, particularly people like April who work in palliative care day in and day out. Their experience demonstrates some patterns or trends that you will usually see people go through in terms of their illness progression. And nurses are very good at predicting those things.
But you would agree with a statement that you can't predict when a person's going to die, and you wouldn't claim to know that, would you?
No.
No. And that in fact, with respect to the death of an individual person, that the best one can say that there is, dare I say, a statistical average or statistical calculation one could do to work out approximately when a person might die. Is that correct?
I don't think I would agree with that, to be honest. I think there's far too many variables that you would need to take into consideration about a patient's illness and what it precisely is that they've been diagnosed with.
Yes.
So I couldn't answer that.
So the diagnosis is really important in regards to even thinking about when the end of that life of the person might be. Is that right? So the diagnosis is important to get right.
Well, I would say in all cases the diagnosis is important to get right because it offers a whole range of treatment options that are directed towards that diagnosis.
And that diagnosis ought to be made as thoroughly as possible. Would you agree with that statement?
In all cases, yes.
Yes. Okay, thank you.
Mr. Diadam, you've got the call then to Mr. Farlow.
Look, I've got just one question. So in clause 55 of the bill, 55A, it creates a provision that allows a nurse practitioner to be an administering practitioner. And I just wondered whether you could explain the difference between a registered nurse and a nurse practitioner and whether it's a higher or lower threshold in terms of the competence and capability of a nurse practitioner.
So as I alluded to before, a nurse practitioner is someone who is a registered nurse who holds additionally, on top of their registration as a nurse, an endorsement which is granted by the Nursing Midwifery Board of Australia as a nurse practitioner. In order to obtain that endorsement, a person would have to complete, I guess in this day and age, have a Bachelor of Nursing or equivalent, and then complete subsequent postgraduate training in a Master of Nurse Practitioner. Usually it's in a specialised area, and that would give a nurse, the ability to have an expanded scope of practice. And so those things could include things like prescribing, limited diagnosing in very, very limited circumstances, as well as ordering perhaps diagnostic imaging or ordering blood tests and things like that. And they're an incredibly valuable resource, but they are, because they are so highly trained and skilled. Yes.
How many years training in total would a nurse practitioner have?
I would say a minimum of 6 years full time.
Right.
Yeah. Okay.
And how common is it for there to be a nurse? How many are there as a proportion of the profession?
I would have to take that question on notice. The data is available on the Nursing Midwifery Board of Australia website.
Thank you.
Mr. Farlow.
Thank you very much for your attendance today and for your submission as well. Just wanting to turn to actually follow on from Mr. Donnelly's issues with the right to conscientious objection and the views of your members in regards to that. And I note your submission in terms of some members raising religious beliefs being a concern for them. How do you see it working in practice in terms of those Section 9 provisions for any of your members? Would that be a registered process by which they would have some form of registration that they had in place a conscientious objection and therefore weren't involved, or would it be an ad hoc basis? What's sort of your experience in the past?
I think it's not unlike other kind of areas of practice. And there are going to be occasions where people may have some discomfort with being involved in the provision of care to either particular patients. It could be because they've had a interaction, because there has been, something said to them that makes them uncomfortable. There is always a process whereby someone can escalate to the person who they report to and say, look, I'm not comfortable with participating in the provision of this person's care, and arrange for care to be provided by one of their colleagues instead. That's common. It happens probably every day in New South Wales, at least, and I would imagine and envisage that this would be no different. I would also imagine that this, if the Voluntary Assisted Dying Bill is passed, that the provision of assistance in dying would happen in discrete circumstances, and people who didn't want to be involved perhaps would be less inclined to work in one of those areas.
Thank you.
Ms Fairman.
Thank you, Chair. Thanks for appearing today. I just wanted to just go back to treating patients who are terminally ill at the end stages of their lives with some of the terminal illnesses that we particularly hear about that are excruciating at their end stages. Just wondering if any of you would just care to talk about what I assume is a very stressful situation for you and your colleagues, having some of the patients, for example, some of the stories that we've heard that are in these great, these books from Dying with Dignity and Go Gentle that have detailed some of the personal experiences, some of which we'll hear this afternoon. For example, one man who had mesothelioma who was screaming in the final 2 weeks or so of his life. Nothing could alleviate his pain. And another woman whose brother had an awful facial tumour, who we'll hear from this afternoon, and again who was just kind of screaming as much as he could, but just wanting help in the final stages. And that's what we hear from the families. But of course, you, Ms. Fleming, so my eyesight is bad today. You would hear that a lot, and your colleagues would hear that a lot. Would you just care to tell the committee how what that feels like and the stress placed on you? Obviously, you are able to alleviate a lot of patients' pain in terms of palliative care, but there are those that are just begging to be relieved and begging to have their pain relieved that you just can't do anything about.
Yeah, you're right. We do our best with the resources that we have, but there is occasions where patient suffering can't be relieved, whether that's emotional suffering, whether it's physical suffering through symptoms of pain, breathlessness, nausea. It's really hard. I do have a lot of, there has been a lot of cases recently where people's suffering hasn't been able to be relieved, even with really high doses of opioids, and it's very distressing for the patient, for the family, and for the staff. I've recently had patients that have sought methods to end their life as well, because they don't have the option of voluntary assisted dying. They might stockpile their medications. And I've had one lady recently that decided to put a plastic bag over her head and slit her wrists, and then walked into her son's room and decided, maybe I don't want to do this. Wow. But she came to the palliative care ward and she spent 2 weeks there in agony, absolutely emotional agony. She was tormented. She wanted to die.
Are you able to tell the committee what her condition was?
She had tongue SCC.
And what does that...
So it's a cancer of the tongue.
Yep.
She had difficulty swallowing. She had a swelling, so she couldn't communicate properly, and she had terrible pain. And
ultimately, cancer like that just gets bigger and bigger and invades the
airway
until that's the death.
Yeah.
And there's also there was a story from a few years ago, and I was wondering if you could potentially talk about this as well, but not this particular story, but the conditional case of some sometimes bowel cancer that a young woman whose story I have told for a number of years now, called Angelique Flowers, who was an advocate for voluntary assisted dying for some time, and she died a terrible death, and she sought to be able to die with dignity because she knew that the death that she was going to experience was horrendous, including dying, probably vomiting up her own faeces. And I will say that, and I know it's a horrible thing for us to have to say in a committee or anywhere, but that's also the death that people face, isn't it?
Yeah,
Just
it is
in
quite
terms of,
common for people with advanced bowel and ovarian cancers to have malignant bowel obstructions which aren't relieved by medications. They do often die vomiting their faeces, or they have massive internal bleeding, and it's very traumatic.
And doctors tell them that this is potentially what they are going to face. Is it quite an open discussion?
They will say that there is a risk of bowel obstruction. Often it occurs a couple of times before their last one. They won't go into graphic details about how horrible their death will be, though.
I could go on, but I'll if other members have questions.
Thank you very much. Mr. Khan, did you have any follow-ups?
Not at the moment.
Mr. Deputy Chair, you've got the call.
Thank you. I'm just wondering whether anyone at the table can provide some explanation to the committee of, in the context of the nursing profession, compassion fatigue. Is that a piece of study, quite significant study that's been done with respect to nursing over a period of time? Do you have knowledge of the research around compassion fatigue and what it means for nurses?
Yes, I do.
So can you explain what compassion fatigue is, please?
My understanding of compassion fatigue is the ongoing demand on not just nurses but all people who work in care roles to continually empathise with the people who are in their care, and the fact that that can take a toll over a number of years emotionally on them.
So sorry, just say it again, that their degree to empathise with.
Yes, that they're professionally required
Yeah.
to provide can take a personal toll on them.
By to providing the actual empathy, that takes a personal toll.
Yes.
Yeah.
I don't think it's exclusive to the nursing profession.
No, we're talking about nurses because that's your organisation represented at the table. So with respect to nurses, how does this actually reflect in your members? Do your members talk to you as an organisation about their experiences of compassion fatigue?
They wouldn't articulate it in that language. I think the themes that we see are the struggles that our members have when they're unable to provide the level of care that they believe that their patients require. So that can be based on resourcing, that can be based on limitations with, treatment options that are available to them. But that's the challenge ultimately. Nurses and midwives get into this profession because they want to do the right thing by their patients. So when they're in a position where they're unable to do that, it presents a level of distress to them, absolutely.
So if you take nurses and midwives, or specific nurses I should say, around the state of New South Wales, away from Newcastle, Sydney, Wollongong, so in regional, rural and remote New South Wales, we know as a matter of fact, I presume you do so as well as a professional organisation representing nurses, that in many parts of the state there is access to very, very little palliative care. Would you agree with that statement?
I'd say access is problematic in a number of areas. I would completely accept that.
So you accept that proposition that palliative care is quite restricted in many parts of the state. Would you agree with that statement?
Yes.
So that being the case, in other words, that individuals can't access palliative care who otherwise may need palliative care, that would result potentially in those individuals suffering quite badly. Is that correct?
Potentially.
And by suffering very badly, my words, suffering very badly, I've described it in these terms if there's no palliative care, that observation of seeing those people, that nurses who have a vocation to care for and look after and support people, that would be very difficult for a nurse, wouldn't it, to see that?
I think it's important not to conflate separate issues though. So our members can very clearly articulate when all of the available options within healthcare fail a patient versus when a patient can't access the care that they require because they're in a remote area. So that isn't something that we would hear from our members.
So you wouldn't hear from members anxiety around seeing patients suffering in regional rural New South Wales?
No more than we would.
Accessing palliative care?
But they would articulate that the suffering is because of their lack of access to palliative care. Yeah. Like our members who live in those communities know better than anyone when there are limitations to access around palliative care services. Yeah. They're the first to say that is the problem.
Yes, and that's been the evidence by nurses right across New South Wales in the inquiry. You would know that?
Absolutely.
Yes, and they have been calling out very strongly to significantly improve access to mitigate against people's suffering. Would you agree with that?
Yes.
Thank you.
Mr. Khan.
I just want to go back to this conscientious objection issue. Could I just go to the circumstance that's been described earlier, and that is the provision of, and I think perhaps this is to Ms. Fleming from your experience, the provision of terminal sedation, I think it's been called at various times. I've heard other usages also, but is there a capacity for a nurse to conscientiously object to a patient receiving terminal sedation?
Yes. A nurse always has the opportunity to object to anything they don't feel comfortable with. I think most nurses working with palliative patients would hate to see their patients suffering, and if they require terminal sedation, they're happy to do it. But
in a sense, there are mechanisms that already exist within the health sector to deal with nurses or other health practitioners objecting to a style of treatment without it having to be written into a piece of legislation. Is that the general drift?
Would you like?
And is it legally enforceable?
Well, I'm asking the question at this stage, Ms.
So yes, I would say that is absolutely custom and practice in every workplace. Nurses are bound by a number of provisions, like, for example, the 5 rights of medication administration. And, you know, I think most nurses would tell you at least once a day they're given an order that doesn't fit the bill from that regard, and so they have to object to administering it. And it's done between the doctor and nurse. It's rectified. A nurse would routinely question a doctor around some treatment that's been prescribed if they don't agree or don't understand. If it's resolved, then that would be the end of it. But if it's not resolved, it's escalated. It's escalated through the nursing pathway. So the nurse would approach their manager and say, this is what I'm uncomfortable about and this is why. And that can be escalated all the way to, you know, the highest levels of the patient's treating professional doctor or their medical team.
Can I also add to that? Scope of practice is an incredibly important issue. So a scope of practice for a nurse is anything that they're educated, authorised and competent to perform. So activities of care that are that they undertake need to be conformed within that framework. If someone is, you know, theoretically providing care to someone who's receiving palliative care and that person decides to access voluntary assisted dying, then and they have a conscientious objection, well, it's likely that it would be outside of their scope of practice to actually participate in the provision of that care because they wouldn't have done the training, you know, that they wouldn't be educated, authorised, competent to be involved in that process. So it's not just a matter of can they put their hand up and say, oh, I don't want to be a part of this. It's actually, I can't be a part of this because I haven't received the appropriate training.
I'll just return to Ms. Fleming. It's not uncommon, is it, that in the end stages of a person's life, there will be a discussion that may involve the nurse. This is, I'm saying, with the medical practitioner. It may involve the nurse, with the doctor essentially saying, look, we are going to up the dosage.
Yes.
And one of the consequences of that is likely to be the death of the patient at some stage. That's not an uncommon outcome, is it?
The conversation wouldn't go as
brutally as that.
No, it would be the side effect of increasing this medication, maybe increased drowsiness or sleeping more. might be a decreased respiratory rate. That would be as far as the conversation would go.
I'm not suggesting.
Yeah.
But
I think you are.
Order.
What I was saying is I'm not suggesting an impropriety, Greg, if you'd allowed me to finish. If a nurse is involved in that style of conversation, is the nurse able, in those circumstances, to say, I don't want a part of this? In essence, I conscientiously object to this course of action?
That's entirely up to the nurse.
Unfortunately, Mr. Khan, we've reached our time limit. I wanted to thank all the witnesses for this session. Thank you for appearing today. For the questions that you've taken on notice, the Secretariat will be in contact with you to liaise their tabling. We thank you very much for making the time. And we'll have a short switch over of witnesses. Thank you. We've now got our third session for today's hearing, and I'll ask the witnesses in the room to state their name, position, title, and swear either an oath or affirmation. And then after that, I'll go to the witnesses on the WebEx system.
Very well. Thank you, Chair. My name is Simeon Beckett, and I'm the co-chair of the Human Rights Committee of the New South Wales Bar Association, and I will take an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
And I appear, of course, with Mr. Glover.
Mr. Glover.
Good morning, Chair and committee members. My name is Trent Glover. I'm a barrister and a member of the New South Wales Bar Association's Human Rights Committee. I will be taking an oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. Mr. Cowdrey.
Hi, my name is Nicholas Richard Cowdrey, and I'm appearing on behalf of the New South Wales Council for Civil Liberties, of which I am in fact the immediate past president, not the current president, and I'm still a member of the committee. And I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Professor Wilmot.
Hi, my name is Lindy Wilmot. I'm a Professor of Law at the Queensland University of Technology and a member of the Australian Centre for Health Law Research, and I will take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And Professor White.
My name is Ben White. I'm a Professor of End-of-Life Law and Regulation in the Australian Centre for Health Law Research. I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. We now give witnesses the opportunity to make opening statements. I'll start with the Bar Association. Do you both or are sharing a opening statement?
We'll make one opening statement.
Thank you.
If that's suitable. And then Mr Glover and I will address various questions because Mr Glover is in fact the author of the submission and he's the holder of the technical knowledge, I have to say. First of all, I wanted to say thank you to the Chair and also to the members of the committee for inviting the New South Wales Bar Association here to make submissions orally and to back up our written submission, which was filed some time ago. Thanks for the opportunity to participate in the inquiry. The subject matter of the bill and this committee's inquiry is very much the subject of debate around the world. Indeed, the UK House of Lords is currently engaged with considering a private member's bill on the same subject with respect to England and Wales. The Bar Association submission engages with what is the most significant of all human rights, the right to life, but also seeks to bring to the committee's attention other human rights that are engaged by this bill, in particular prohibition on cruel, inhuman or degrading treatment, on the rights to freedom of thought, conscience and religion, and on the rights to privacy and family life, and of course the rights of persons who have a disability. The detail of that is set out in the detailed written submission that we've put on. The Bar Association's submission focuses on some of the more technical aspects of the bill, and that is really with a view to ensuring that the legislation in the form Parliament sees fit to enact as having a degree of certainty of operation and to ensure certainty for all those people who are affected by the bill. Of course, the committee has heard and will be hearing from stakeholder groups and individuals later in the day, and that evidence might be expected to focus on the broader policy considerations associated with the legislation. Now, the position of the New South Wales Bar Association is on a policy basis neither to support nor oppose the particular bill. Our focus is really if the bill is to go ahead and be enacted, that it be done in a way so that it enforces, it makes sure that the policy outcomes, particularly in terms of certainty, are adhered to. And so our focus has been very much on ambiguity, at removing ambiguity and trying to assist with understanding how the bill will work in practice, and trying to identify those issues where there might be some concern about ambiguity. And I won't belabor that rather than to refer the committee and its members to our submission. We wanted to make, we've considered the amendments, at least in passing, as a result of what occurred in the other place, and we wanted to make specific mention of the new guidelines proposed at clause 186 capital A. The ability to make guidelines and requirements to have regard to those guidelines will serve to assist with clarification of the operation of the bill. So we support the guidelines, we support that particular amendment on the basis that we have put our written submission. Thank you, and obviously after the others have opened, we're happy to take your questions.
Thank you very much. Mr Cowdery, I'll now offer you the opportunity to make a submission.
Thank you. I will make a short submission. First, I also thank you for the invitation to appear today on behalf of the New South Wales Council for Civil Liberties. And I thank you for allowing me to appear by video conference. It's not because of any lack of vaccination. I'm in fact triple vaccinated, but it enables me to attend to other commitments that I have today. So thank you for that indulgence. The New South Wales Council for Civil Liberties submission was made on the 18th of November, and I rely on that written submission. Our submission is that as a matter of policy, this bill should pass and this regime should be enacted, and the Council has been in support of such a move now for some decades. I also have a personal submission before the committee, which I note is referred to in the schedule of events for this session. The civil liberty or human right is at issue, of course, the principal one. I accept the others that my colleague has referred to, but the principal one is the right to life. And it's the freedom of an individual to choose how that life is led, and to do so in accordance with law, in accordance with morality, with ethical considerations, with philosophical and religious considerations that might apply in any particular case. There are three aspects of Article 6.1 of the International Covenant on Civil and Political Rights. I'm referring to this now in my opening because we haven't directly addressed this issue in the written submission. But there are three elements of Article 6.1, and it's reflected in other instruments, of course, and in international customary law. It says every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. It's an inherent right, that is, every human possesses it by reason of being human. And it's non-derogable. It can't be taken away by the state, even in circumstances of emergency. But I want to emphasise that it is the person's right, and I'll say a little bit more about that in a moment. It is protected by law. It has to be protected against threats to life that might exist in the community. And the state has a discretion as to the extent to which it will intervene to protect that right. It must act proportionately to any risk that is anticipated. And the article says that a person is not to be arbitrarily deprived of life, that is, unlawfully or unjustly. There must be controls to ensure proportionality of action that is taken. And so that must be reflected in this kind of legislation as well. There is an argument as to whether or not the right to life is discretionary or mandatory, and I leave that to academics specialised in this particular field. It's an ongoing controversy, I understand, but the state has responsibilities in relation to individuals who interfere with their own right to life. There is a need to prevent compulsion of any kind. If a person ends his or her life, it must be with genuine consent. And the state can set the limits. It can set the limits of the authenticity of action that can be taken, the reliability of that action, and the safeguards that are in place for everybody involved in the process. It's our submission that the present bill does that, it meets those requirements, and in substance it appropriately preserves the right to life, but it also gives freedom of choice to the right holder. Thank you very much.
Thank you, Mr. Cowdery. Now, Professors Wilmot or White, do you both or either one of you have a opening statement that you'd like to make?
Thanks, Chair. We each have a brief statement, if that's all right.
Absolutely. Perhaps you might like to start, Professor Wilmot.
Yes, certainly. And thank you for the invitation to be a witness before the committee today. We're particularly grateful given that we're from across the border, so thanks for accommodating the video conferencing as well. I acknowledge the traditional owners of the land on which I live. For the past 20 years, I've researched almost exclusively in the law, policy and practice of end-of-life decision-making, including in relation to voluntary assisted dying. In the past 2 years, I've also undertaken empirical research into how the Victorian bail system has been operating, and this research informs my position. As part of our research in this area, Ben White and I have drafted a bad bill. This bill was adopted by the Queensland Health Committee as its preferred legislative model in the bad report tabled in the Parliament of that committee in March last year. The extensive research that we've undertaken into BAD informs that legislative model and also informs the positions that we articulate here today. In this opening statement, I'd like to make 2 points. The first is that we believe it's possible to have safe BAD laws that give choice to patients who are already dying. In our view, the bill as passed by the Legislative Assembly should be enacted. While we suggest some minor amendments to the bill in our written submission, we believe it is a sensible and measured bill that will provide choice for terminally ill patients while operating safely, including protecting the vulnerable in our community. During this inquiry, I expect that the committee will hear arguments to introduce further safeguards, for example, requiring compulsory psychiatric assessment or compulsory palliative care consultation. I urge the committee to resist such proposed amendments. The bill, as passed by the Legislative Assembly, already contains sufficient safeguards. Adding further safeguards will only serve to make accessing BAD even more difficult for terminally ill patients. The second point is to respectfully urge the committee to pass a bill which is the best bill for New South Wales and not to amend the current bill so it looks more like the Victorian model. A departure from the Victorian model does not mean that the New South Wales bill is inferior or not as safe. The fact that the Victorian Act is the first act in any Australian state does not make it the best possible act. The Victorian legislation has been in operation for 2 years, and there are important lessons to be learned from their experience. We can address the committee about the results of our research into the Victorian experience if that would be useful. The Victorian legislative model can be improved, and the New South Wales bill, as passed by the Legislative Assembly, has done just that. Thank you. That concludes my opening remarks.
Thank you. Professor White.
Look, thank you, and thank you also for the opportunity to address the committee. I'll apologise in advance. I received the invitation while I was on leave, and I'm still on leave, so I'm doing this on a tiny mobile phone. So my apologies if there are if that's a little suboptimal.
We appreciate you taking the effort and time to come and talk to us.
I'm delighted. I acknowledge the traditional owners of the land where I'm currently at, the Gubbi Gubbi people. And like Lindy, I've been researching in voluntary assisted dying for the last 20 years. It's the sole focus of my research at the moment. And in 2020, I was awarded an Australian Research Council Future Fellowship, which is a 4-year project effectively focusing on how best to regulate voluntary assisted dying in Australia. Also relevant background is that Lindy and I designed and developed the mandatory training for the Victorian and Western Australian governments. So I give that background to set the context for the brief statement I will make. I agree with the point that Lindy made about the New South Wales bill being a sensible and measured bad law. It reflects what is now the broad Australian model and is safe. I would make 2 comments in my opening remarks. The first is to respectfully urge the New South Wales Parliament to avoid the ad hoc addition of the many late amendments or safeguards that we've seen elsewhere. We've called this the piling on of safeguards. As it currently stands, the New South Wales bill is based on the bad laws passed in other Australian states, themselves a product of extensive consultation and expert input over many years. These add-ons to an established model risk making the law unwieldy, incoherent, and indeed even unworkable. It is our view that such proposed additions do not make the law better or safer. In fact, they risk harming the intent of the law by making an already rigorous and very difficult process actually unworkable. So that patients whom the law would otherwise deem eligible, in theory, in practice, cannot access voluntary assisted dying because they cannot get through the process. So that was the opening comment, the first comment about avoiding the ad hoc piling on of amendments. The second relates to evidence, and to repeat our call for evidence-based lawmaking. We propose the Parliament's decision about the best bad law for New South Wales should be based on the large body of reliable and high quality evidence that is available about how bad systems work internationally, and there is also now evidence about how it is working safely in Victoria. In the article in the Australian Health Review, which is attached to our submission, it proposes that, like for all science, reliable evidence means enough data, enough cases that we can trust, and that evidence has been externally and robustly tested. So, for example, peer-reviewed empirical evidence is reliable, but anecdotes and media reports are not reliable evidence, and so are not a safe basis upon which to make laws. What counts as reliable evidence is significant because you have, and I'm sure we'll hear over the course of your inquiry, many conflicting claims. People will say that is safe, but others will say it is dangerous. And perhaps a concrete example can help. A concrete example of conflicting claims relates to the question of, are vulnerable patient groups more likely to see bad? And this is an example of where reliable evidence can resolve this factual claim. There is peer-reviewed research of large data sets published in international leading journals, and it concludes that vulnerable patient groups are not more likely to seek bad. So my point here is not a sort of for or against bad, but rather that good lawmaking should be evidence-based, and there's an opportunity to draw on a large available body of reliable evidence. Those are my opening remarks.
Thank you very much. And just noting the time, it's just past midday now, and I know that there are some time constraints for people at 1 p.m, so we've got just under an hour for questioning. I'll pass to the Deputy Chair to start.
Thank you, Chair, and thank you all for participating today as witnesses to this important inquiry. Can I just direct my first lot of questions to the representatives from the New South Wales Bar Association, and thank you very much for coming along today. First of all, thank you for the submission. It was very helpful in structuring our thinking around some of the matters we need to turn our attention to, so it's appreciated. Can I go to just particular paragraphs in your submission? That might be the quickest way. We've got limited time. I'm sorry if I sound like I'm cutting this tight, but we've got limited time. Can I go first of all to paragraph 27 on page number 5. I suppose this is providing an opportunity to just elucidate, if necessary, the leading paragraphs which brings to the conclusion, which are in these particular paragraphs I wish to draw out. But in 27, paragraph 27, the first part of the sentence which goes into the second line says, for this reason, the association suggests that the community of persons with disability be recognised as a community with a significant interest in the operation of the bill, and then continues on. Can I ask you to elucidate on the thinking behind that, and what would be the steps to take to create this significant interest? What would be the process required to achieve what's suggested there?
Mr. Glover and I think we'll probably both reply to that, but if I can just pick up the obvious one, certainly that this committee, I would have thought, and the proceedings that we're currently engaged in is an appropriate vehicle in terms of the shaping of the bill and to making sure that... I
might just ask you to bring the microphone just a touch closer to you, if you wouldn't mind. Thank you.
Right, sorry about that. And that the community of persons with disabilities, and of which there are many non-government organisations, should be engaged and invited to engage in this process so that they're heard in the making of the legislation. One of the particular amendments that I'll get Mr. Glover to pick up on that we have suggested is a safeguard with respect to protecting that part of the community of persons with disability to ensure that VAD is not applied where disability is the sole ground upon which a decision is made, and we've made our position quite clear on that, but I'll turn over to Mr. Glover.
And just to clarify, that's disability as we would broadly understand it, both physical and intellectual disability? If we can, is that what we're essentially talking about here, broadly understood?
Yes, and I think, Deputy Chair, the Bar Association's concern in this respect didn't necessarily touch on the provisions of the bill, but more a bringing along in the process of persons with disability, because as you will see in the paragraphs preceding 27, there is obviously, as the committee will be aware, a significant international convention that deals with the rights of persons with disability. Indeed, at a federal level and indeed a state Royal Commission level, there is an ongoing Royal Commission which is sitting at the moment. And it's really designed to make sure that the voices of people with disability in opposition to voluntary assisted dying laws are heard, and the committee and indeed Parliament more generally takes their views into account.
If I put this proposition to you, that with respect to this inquiry currently before us, there's roughly 110 submissions that are what might I call substantial or significant in terms of content. And indeed yours is one of them, but around 110, that as far as I can see, not one of them is from an organisation that represents people with a disability, either physical or intellectual. Do you think that is something that we should be concerned about, that there has been nothing heard from, broadly defined, the disability community in regards to this proposed legislation?
I think the general proposition is, well, first of all, we're not aware of the nature of the detailed consultations that have already gone to date, but I would have thought it was within the remit of the committee to actually write to such organisations and to solicit submissions if you were concerned about that particular issue. Trent, did you want to?
I find that quite interesting. It may not be a cause for concern. There may also be a degree of ambivalence towards this legislation, given it was considered previously in the previous versions of the bill by the Parliamentary Working Group. It is definitely, in my submission, I would say something the committee should follow up on.
Moving on then.
Would you mind if I just follow on from that a little bit? So in terms of your suggestions of amendments to the bill, I think at 75 you outline some changes to the legislation as you see it to provide better protections for those with a disability. Do you want to expand on that perhaps?
Is that okay?
I was on more. Oh yeah, no, that's fine.
I think those proposed amendments are designed to ensure that persons who are deemed ineligible, and particularly having regard to disability, are just safeguarded in the bill. And this is not taking up the professor's points in opening, an additional safeguard that affects accessibility, but it almost operates in the reverse. So it makes it clear that it protects persons from, or persons who are vulnerable, like those who have disability, from being regarded as ineligible. The other important amendment in that respect, in this paragraph of the submission, is really the one that follows it, which is ensuring reviewability of those decisions about eligibility. That is a useful oversight mechanism on the safeguards. And I'm aware that in the previous iterations of the bill, even though this is well different, one of the great developments between the 2016 bill and the 2017 bill was a recognition of the jurisdiction of the Supreme Court to provide oversight.
Thank you. Sorry, Mr. Donnelly.
Thank you. Moving on to page 8 and your paragraph 45. Just reading it quickly. Having regard to the number of different ways the term advanced could be reasonably interpreted, the association suggests a definition of the term advanced be included in the bill. So that obviously goes to the question of the eligibility provisions within the bill. You'd be well familiar with that. So with respect to that particular point, is there anything that you wish to elucidate or comment on?
indeed, it might be something, given that the Professors Wilmot and Smith are in this session, that they are more qualified to speak on, given their role in drafting the Queensland legislation, which picks up on the Victorian provision.
I have to say I'm more interested in your evidence this morning. So perhaps directing it to you, you obviously had reasons for putting that in your submission. It stands as your evidence. You had reasons clearly for that. What were the reasons behind that?
It's really to ensure the certainty, or as much certainty as possible, with respect to accessibility or eligibility. And it's basically what the Bar Association's submission is directed to are really seeking as much clarification as possible in three discrete aspects of the bill. That's the accessibility or eligibility, the assessment of that accessibility or eligibility, and then the enforcement provisions. Or enforcement or oversight, I should add.
My time, I'm sure, is running out. Can I take you next to paragraph 54? Sorry for the Cook's tour. Page 10. You say, for those reasons, the association suggests that the meaning of the term suffering should be further clarified in the bill. So is there anything you'd like to say in regard to that particular piece of your evidence?
Again, this is something that has been considered in other jurisdictions, in particular Tasmania, which has that really extensive definition of suffering. Really, again, what the Bar Association was seeking to do was draw out particular expressions that may be capable of different meanings, so that if enacted in whatever form Parliament chooses fit, it is as of certain operation as possible.
I'm just going to go now to Mr. Diadam for a section. I'll come back to you
later. Well, I might just then pick up on that and ask Professor White and Wilmot to...
You've stolen my thunder.
Address the issues that have been identified
around
the proposed amendments from the Bar Association. So
the restrictions.
Order.
And their necessity
no interjections.
or otherwise. So, Professor Wilmot or Professor White?
I'll have to start off then, if you wanted to chime in after. My apologies, I'm afraid I have not had the advantage of reading that particular submission, but obviously I've picked up on some of the content. In relation to the further defining suffering, I would certainly be concerned about any attempt to do that. Suffering, as it is currently expressed in the eligibility criteria, is subjective. So that is a level of suffering that is intolerable to the patient themselves, and it can be as a result, of course, of physical pain or existential pain. So I think that if a patient who satisfies the other criteria, having advanced progressive illness, are going to die within 6 to 12 months, and say that their suffering is intolerable, I do think that is sufficiently clear. I don't think that is a problem in terms of certainty, and it certainly hasn't been something that has emerged that I'm aware of from the Victorian experience as to any concerns by doctors about whether or not that is satisfied. Just my off the top of my head comment in relation to the requirement or suggestion that the term as will be defined. My comments are similar here. When you look at the combination of all of the eligibility criteria, so the illness is advanced, progressive, and will cause death on the balance of probability within 6 months or 12 months for a neurodegenerative disease. Those diseases like cancer, if it's at an early stage, it won't be causing death within 6 to 6 months. so it wouldn't be classified as advanced. So when you take those terms collectively, I don't think that there is any uncertainty. I think my colleague Ben might be having some issues with his connection, but when he's back on, he may have additional comments.
I think maybe we're waiting for Professor White.
Go at taking off my.
Well, we've got your audio, Mr. Professor White. So if you are able to add some elucidations to that, that would be fantastic.
Of course, I've just taken my video off to try and, I guess, for the bandwidth. Look, I agree with the points that Lindy's made. Starting with the advanced, I think the risk of taking an established Australian law, which is there in place and hasn't been causing problems in practice, I don't think there's upsides to that. I guess the other challenging thing is medical practitioners are already very comfortable and aware of what an advanced medical condition is. You know, for example, in cancer, there's 4 diagnoses. There's a range of different things which are different across different illnesses. The risk of trying to define in sort of a very detailed way is that there may be as to how that would apply to the diverse range of illnesses that arise. So I would support leaving advanced as it is, because I think that's understood. It's used in other jurisdictions. On the suffering point, I agree with the points that Lindy's made. Perhaps the only thing to add might be if there is merit in clarifying that the suffering could include, for example, harm by the treatment, treating their illness, or claiming that it can in fact be existential emotional suffering as well. But those are the only other thoughts I would add to that.
Thank you, Professor White. Do you have some more, Mr.
I'd
Downer?
like to perhaps ask Professor White and Professor Wilmot to, drawing on their knowledge of international experience, to perhaps, we hear the slippery slope argument seems to be one of the key arguments advanced in opposition to the bill. I wonder whether you can perhaps give us some insights about whether there's any validity to that argument in relation to the international experience.
I'm happy to start off on that one, Lindy, if that sounds okay. And I might slippery slope can be met. One of the arguments is that once you allow voluntary assisted dying, that other unlawful practices will increase over time. Again, here I would just go to the evidence. There is evidence tracking what has happened in Belgium and in the Netherlands over the last 2 decades. There was research before voluntary assisted dying was lawfalised in those jurisdictions and after. And those concerned about a slippery slope would point to, for example, unlawful ending of life happening more frequently due to voluntary assisted dying becoming lawful. In fact, the experience has been the opposite. The Belgian and Dutch teams have collected data on a category of death which is LAWER, which is effectively ending life without explicit request. So it's basically ending someone's life without them seeking voluntary assisted dying. That has actually declined over time and declined after the passing of the assisted dying legislation. So there's a range of ways, I guess, we can think about slippery slope, but in terms of that one, that's one I think where I go to the evidence, and the evidence I think makes clear.
Professor Wilmot,
Professor Wilmot, do you have a further contribution on that question?
Maybe only to say that was one aspect of the slippery slope. The other aspect of the slippery slope is that once you enact this legislation, then Parliament will widen the criteria, for example, the eligibility criteria. And I guess, again, we urge you to look at the evidence. There has been some modification, very limited modification in some places, but for example, in the US, which has a model very similar to the Australian model, that eligibility criteria has not changed. So there is not evidence of that slippery slope that some people claim. The other thing that I would add too in relation to this argument of slippery slope in terms of changing the legislation, we do live in a democracy and we are governed by Parliament. Parliament, after extraordinary amount of consideration, committee work, submissions, deliberations in committees such as yourselves, pass or don't pass legislation. In 20 years down the track, if the society or community expects through its parliamentarians, we want to change this law, then that's part of being a democracy. But certainly we have not seen that internationally, except in very limited circumstances.
I'll yield.
Thank you. Mr. Farlow?
Thank you very much. Thank you very much, Mr. Chair. And I might return back to the Bar Association with my question and maybe pick up from where Mr. Donnelly left off with some of the issues that have been raised in your submission. But I might first pick up the point raised by Professor White with respect to sort of the additional safeguards and making legislation unworkable. Do you think that the legislation as it stands is currently so workable that we couldn't possibly consider any amendments?
It's such a broad question, and which part are you drawing attention to with respect to that?
Well, look, in terms of the operation, and I know the Bar Association has taken the position that you're not either in favour or not in favour of the legislation, but you are in a position where you are trying to raise some concerns with the legislation and how it could be workable. So do you believe that there is therefore some scope to better refine and define the legislation to make it workable?
Well, we've certainly set that out.
Just wanted to pick up that as the first starting point.
I certainly agree with that. Indeed, I think the amendments that were passed in the other place also improve the operation of the Act. And I suppose, as a lawyer, if you ask generally, can legislation ever be improved, that's probably the case. And I appreciate I'm talking to a room of parliamentarians and lawmakers, but it's invariably the case that legislation can always be improved.
Thank you. Now, just to go to some, I think where Mr. Donnelly left off in terms of some of your issues that you'd raised, we're probably at capacity. Then I think was the next issue that was raised in your submission, and the requirements. And look, thank you for your submission, because I think it's a very useful starting point in assessing each state's parameters and where there are differences and where New South Wales may be able to follow from some of the lessons of other states in this area as well. But in terms of capacity, and I think it's at page 14, where you recommend that the bill be clarified to make it plain, and I won't go into it, but if you'd like to perhaps further expand upon some of the issues you see in terms of decision-making capacity as it stands presently in the legislation.
So one of the issues that struck us was the temporal component of the process, the requests and the assessment before the administration of the substance, assuming that you're assessed as eligible and you pass through those gates. I note that some of the amendments in the other place actually deal with a permanent loss of capacity. So once you have permanently lost capacity, you then become ineligible forever to access this regime. But to the Bar Association's submission, there was another aspect to that temporal component, and it's how the Parliament intended the legislation to work in relation to a person who may have capacity at some time, loses capacity, and has capacity regained at another time. And it seemed to the Bar Association that it's certainly possible to read the legislation as it currently is, or the bill as it currently is, as applying to assessments of capacity at particular points in time of the of the process. But if that's the case, then the bill could probably be improved by expressly recognising that, if that's Parliament's intention.
Thank you. Now, also with respect to the offences provisions, and I think the Bar Association at 16 makes some brief comments with respect to the offences provision, but just interested in particularly 41C, as it appears in the bill, with respect to inducing another person to request or access voluntary assisted dying. Do you believe that this covers the total gamut of areas where duress could effectively be placed upon an individual, and that provision's sufficient?
Are these the new amendments?
Yes, this is 41C, appearing on page 77 of the bill.
Okay.
Have you got a view in terms of that provision at all, or?
I certainly thought, speaking personally, that the amendments that were made in the other place that inserted, I think by Minister Stokes, that inserted further regard to pressure and duress were useful ones. I think it is difficult to consider on the run, so to speak, whether they...
If I could invite you potentially
yes,
to perhaps take it on notice and
yes.
have some consideration in terms of those provisions,
Could I also-
particularly around duress.
You have obviously have the former Director of Public Prosecutions online, and that Mr. Cowdery might have a view about those particular offences as well.
I'm happy to refer to Mr. Cowdery on that as well, and I know that
You don't.
yeah,
so.
I'm sure you will.
Yeah.
And I note that he made comments with respect to that and those safeguards as well in his opening statement, so I'm happy to invite him to comment on that as well.
Mr. Cowdery.
Well, thank you. Yes, I'm just looking at the proposed section 41C. I think it covers the circumstances that might be encountered. Dishonesty, pressure or duress, and pressure or duress are defined in the dictionary to the bill. Can't, as I sit here now, think of action that might not be included in action that might not be included in those descriptions. So I would suggest that it does cover the field appropriately.
Okay. That's it from me, Mr. Chair.
Okay. Apologies, I've just the deputy chair's just raised with me. In the copy of the bill that he's got 41 4C. Is that the provision that's being discussed?
No, I was referring to 41C in the second print, page 77.
Page 77.
41.
Thank you.
Schedule 1A.
Oh, and the schedule.
Consequential
I
amendments,
apologise.
Thank you. There you go. Have you concluded your questioning? I know Mr. Khan had a question, so I'll go to Mr. Khan next, and then Ms. Fairman, and then probably back to the Deputy Chair. Unless Mr. Taylor
I think I'll ask the professors a question at this stage. I've now got so many pages open on my desk that I'm not going to find your submission again, but in your submission you made reference to the Victorian legislation and if I paraphrase it correctly, essentially identify that there are some shortcomings in the Victorian legislation. Are you able to identify what those are and whether the New South Wales bill appropriately deals with any of those shortcomings?
Then I'm happy to have a first crack at this.
That's great.
Could I just briefly say what our research was in relation to Victoria? We interviewed 32 doctors who were either consulting or coordinating doctors in the first year of its operation. And we were interested in their thoughts about how it had been operating in that first year out. And of course, we were particularly interested in regulatory components of that. As you know, the two main purposes of the legislation is to ensure access to voluntary assisted dying by people who are eligible as defined by the legislation, but secondly also to ensure that there are sufficient safeguards in the legislation so that ineligible people cannot access voluntary assisted dying. So I guess one of the overall main findings of the legislation was that doctors were certainly satisfied in relation to safety of the regime. So they were not concerned that people who were not eligible, as defined, were receiving assistance to die. But there were some concerns in relation to access, and that the procedure and the process was so difficult that some people were just too sick, too ill to get through the process. It was just too rigorous. So I guess that was a headline finding of our research. To drill down to specifics, there are a number of issues highlighted, but maybe two where I think that the New South Wales bill has to an extent addressed issues. And one is in relation to the Section 8 prohibition in the Victorian legislation, which prohibited registered health professionals from initiating a conversation in relation to voluntary assisted dying. That blanket prohibition was of concern to the doctors that we interviewed. They felt that disadvantaged people, particularly whose health literacy was not good, or people with English as a second language. So I think the New South Wales bill has improved that provision because it does allow the issue to be raised, provided other things occur, such as also discussing palliative care and other treatment options. So Ben and I have made a submission that we think that provision would be better out of the bill because it creates confusion and it might compromise still whether or not this is raised when perhaps it might be appropriate to the patient. But that's another story. And I guess the other way we think that the New South Wales bill has improved the situation is about eligibility of doctors who are able to be a coordinating or consulting doctor. We think that the provisions there are much better in New South Wales. It still provides sufficient safety because the doctors are experienced doctors, either specialist doctors or have a generalist registration for 10 years. But without the requirement to be a specialist, in Victoria that has had implications for access issues for patients and not being able to access specialists. It means it doesn't include palliative care physicians, geriatricians and GPs, for example. So I just mentioned those two as clear ways I think the New South Wales bill is clearer. And I don't know if you had anything you wanted to add to that.
Look, I guess only just to say, I think New South Wales really has followed on the Victorian lead. I mean, I know we're talking about differences, but it really is very much similar to the Victoria. So in that sense, it is a narrow and conservative bad model. There is an opportunity which has been taken to fix or tweak a few things, but I still think it is very narrow. I think we can say with some confidence that the challenges we see in terms of patients finding it hard to get through the process. Some patients and families talk about the challenges in getting through, as do doctors. We will see that in New South Wales as well, but I think that's a function, that's the price, I guess, of a decision to take this particular model.
Mr. Khan, do you have some further questions?
Look, the only other issue that I will raise, it is dealt with in your submission, and that is the residency requirement that exists. Seeing we're the last state to jump on board, has the residency requirement now become somewhat superfluous? And I'm thinking also in the context that I think one of the things that we've learned out of COVID is that there is an interaction between states in the provision of healthcare that is far more nuanced than I ever thought it was before we've gone through the last 12 months. So what's your view?
Good point. I'll just jump in. It's perhaps whether you want to take the question or not. Look, I think that's a really good question. When Victoria first had that enacted legislation, you could see that requirement was there to stop euthanasia tourism. So you could understand it, but the more states that have passed legislation, I think it becomes less of a requirement. There might be policy reasons for wanting the Australian residency requirement to stay, but I certainly do think there is an argument that maybe that particular residency requirement can be removed, as New South Wales is the only state now that can legalise voluntary assisted dying.
Yeah, all right, I'll
just
cede the floor.
Was somebody else just about to make a contribution before I pass the...
I can make a short contribution to that.
Sorry, yes.
Just really, it's a question of consistency. I mean, those laws would not be required. Those residency requirements, at least for Australians who are resident, or people who are resident in Australia or Australian citizens, unless there is inconsistency between the various states and territories. And, that can be sorted out at a ministerial level, and that is to say that the Commonwealth Health Minister, for example, might convene the other health ministers who would all come together and they could agree on that, and then legislation could be introduced in each state and territory removing that residence requirement, because there is in effect one single law essentially across the country. So it's just a question of administration and coordination amongst the various state and territory governments.
Thank you. I'll pass the question now to Ms. Femin.
Thank you, Chair. I'll just go back to the Bar Association, the discussion earlier in relation to the section of your submission regarding rights of persons with disability. Are you aware that the Physical Disability Council of New South Wales did make a submission to the inquiry?
No, we were not aware.
No, we're not aware.
Yeah, just to clarify and reassure you that that submission, which is submission number 99 to this inquiry, did recommend, make a few recommendations in terms of further safeguarding people with disability, but it does say that the Physical Disability Council of New South Wales considers that the New South Wales Voluntary Assisted Dying Bill carefully navigates these issues and, most importantly to us, contains strong safeguards to protect the rights of people with disability via sound, rights-based principles that we can support. So that's reassuring.
Yeah,
is
indeed
it
is. Yeah.
Yeah, that's probably all I have, Chair. My other questions are answered in relation to Victoria.
An explanation. I didn't intend to mislead any of the witnesses.
Nor is anyone suggesting.
No. But please tidy up. I appreciate that. I do apologise. I wasn't aware. I'm sure I passed at some stage, but it didn't jump out at me. So I just want to clarify that I didn't intend to mislead. So that's good.
Thank you. I know Mr. Adams has got some questions, but I just wanted to check Mr. Roberts, so you and Mr. Martin.
All good.
So Mr. Diadam and then Deputy Chair. And
I just wanted to perhaps get some views from the panel about the requirement around the first consultation needing to be in person, and then the consequent workaround from clause 176(1)(a). This arises as a result of the intersection between Commonwealth law and state law, and I just wanted to perhaps give the panel an opportunity to provide some comments on that as an issue for the bill. And I'll have a follow-up question around the experience in Victoria, perhaps for Professor Wilmot and Professor White, around whether there's any evidence that's come out around that being a barrier for regional participants in the scheme in particular.
I'm happy to start off on the point of the Commonwealth law intersection with the state law. This is something which our research team, led by Katrine Belvilla, has written on. This is something we addressed in our submission. This is a challenge that Commonwealth law unintended to cause problems with state voluntary assisted dying, lawful state voluntary assisted dying regimes is in place. Our submission was that if this bill was to pass, the New South Wales government should write to the Commonwealth seeking its law to change. To some extent, because of the Commonwealth, the way the Commonwealth law obviously trumps state, there are some limitations as to what can be lawfully done. In terms of the challenges that have been experienced, so we can talk both about doctors and patients. So that the paper that Lindy mentioned, published in the Medical Journal of Australia, there were 3 big problems identified in terms of how the regulation was working in Victoria, and this was one of those 3. Doctors spoke about challenges of having to drive themselves long distances, alternatively asking very, very sick patients to make the travel as well. We are partway through, as part of that 4-year research project I mentioned about studying voluntary assisted dying, we're partway through interviewing patients and families. And again, this has cropped up as a very, very significant problem. Folks weren't suggesting that telehealth would be used in all times, and a lot of doctors said they wanted face-to-face time and have the confidence of seeing a patient. But some of in Victoria, for example, their guidelines take a very strict approach. And things like pharmacists having to physically visit or prescriptions not being able to be sent by email. Some of the side effects of this have been significant for access for terminally ill patients.
Could I just please add that the current situation is really appalling in that our patients are disadvantaged and suffering as a result of the inconsistency between the Commonwealth and state laws, as well as a significant burden being placed on doctors who will travel to patients if they are unable to travel to them. And as Ben said, this is the feedback that we've got very strongly in our research. And there is a very, very easy fix by the Commonwealth to amend their criminal code. And it's an extremely easy amendment. And it was recommended in that paper that Katrina de Villa from our centre led. I understand the Queensland Premier has written to the Commonwealth Attorney General seeking an amendment so this problem can go away. And I understand that the Commonwealth Attorney General is declining to do that and insisting that the responsibility is on states to pass laws that are consistent with Commonwealth laws. So unfortunately, I don't think there's much that can be done at state level. Section 176 is a good attempt, but I think that's very confusing for not because of the draft bill, but because there still remains this issue of inconsistency with the Commonwealth legislation.
And it's fair to say that this impacts disproportionately on those who are seeking to access the scheme in country areas, isn't it? Is that fair to say?
Absolutely, that's correct.
Thank you.
Thank you. I'll pass back to the Deputy Chair.
Thank you, Chair. If I could please return to the Bar Council Association. The Bar Association, I say. And could I please go to your paragraph 63 on page 12 of your submission? And I'd be pleased to hear any thoughts and reflections about the matter of the provisions, I'll call them provisions, the elements of the New South Wales Attorney General's online publication called the Capacity Toolkit, which looks at the matter of capacity broadly provided for in New South Wales under New South Wales state legislation, and reflecting that into the matter of capacity as defined in the bill itself. In other words, the matter of capacity obviously is across a whole range of different domains considered under state law. But you've obviously given some serious thought to looking at what's in the toolkit, how they've endeavoured to try and explain matters of capacity, and I'd just be keen on your reflections about its relevance and thinking in terms of what's in the provision of capacity in the bill before us?
Yes, thank you for the question. I think a witness earlier today in the committee mentioned that capacity in a legal sense is fairly well defined and well understood. But even despite that understanding, sort of particularly at common law, when you're talking about testamentary capacity, there is always room for argument. New South Wales has quite a developed capacity toolkit, which is used in a range of other legislative settings, particularly the Guardianship Act. And really, the toolkit, when you go back to our submission, does reflect what the other jurisdictions have in their voluntary assisted dying legislation. So it would be my submission that the committee in the course of this inquiry should have a look at the toolkit, and particularly against what is done in Queensland. And I think the other good example is Victoria and South Australia, and give consideration to almost ensuring as much consistency with those frameworks as possible.
Thank you. Can I just go now to this?
Can I just supplement
please, yes, please.
that answer, but just by saying that the import of the submission is very much around assisting to analyse and to assess capacity, and so the guidelines that have been suggested as an amendment, or that have been the substance of an amendment in the other place, is where these sorts of things, the matters that are set out in the toolkit, could also be picked up in those guidelines. It might not necessarily be something for this committee to recommend. It might be something that's implemented by the executive afterwards. Doesn't necessarily need to be the substance of a substantive amendment to the Act.
Can I just take you now to the back of the bill, the dictionary, which is Schedule 1 to the bill. And if we go through the dictionary, if one looks at S, there is no S's, in fact, I think at all. There's schedule and self-administration and specialist registration and supply, but there's no definition of safeguards, the word safeguard. So that's just a matter of fact that the bill doesn't define what a safeguard is. My question is this, that the notion of a safeguard, the phrase or the word safeguard, gets tossed around a fair bit in this debate over legislating for assisted suicide and euthanasia. What is a safeguard and what's not a safeguard? And in fact, one could put the position, and I'd invite you to respond to this, take into account you're not taking a position on the bill, and I respect that. I'm not asking you to depart from that position. But the proposition that one person's view of the shortcomings within a bill or deficiencies in a bill could be seen by another person as safeguards in the bill. Or you put it the other way around, the safeguards in a bill could be argued from the other side as being a provision of an inertia or a break or a moderation or restriction around access. But really it's a matter of how the legislature ultimately passes the legislation, which contains within it specific provisions. So if we take, for example, the Victorian situations which the professors have referred to, the matter of Section 8 in that legislation about the requests and the issue of consulting doctors not being a specialist, which is different from the provisions in New South Wales. they could be argued from the Victorian point of view as safeguards, and presumably if one reads the Hansard of the debate down there, that's in fact what they were advanced for. But to then after the event put the proposition that these are shortcomings or deficiencies, it really is a matter of opinion, isn't it? Would you agree with that statement? At the end of the day, the legislature speaks and determines, but the matter of calling it a safeguard or not really is almost a political discussion, isn't it?
Well, it's a general term about you're talking about the formation of policy with respect to the bill, and then that policy of introducing safeguards, and the bill is absolutely replete with safeguards and constraints placed on every stage of a very detailed process, with numerous checking points throughout that process, I would say, and overseen, of course, by the board, who obtain relevant documentation at every stage of the process. As to what those safeguards might be and the constraints that are put on the decision making, it is quintessentially a matter for Parliament to make those sorts of decisions and to weigh as to, first of all, whether there should be a safeguard, secondly, whether the extent of that safeguard, and no doubt the debate in Parliament as to whether it is appropriate or deficient is a matter for this very committee, yes, and indeed for the Parliament itself. Having said that, obviously you have a number of eminent experts who are appearing before yourself, excluding myself, who will have an opinion based on experience and evidence, as I think Professor Wilmot was very strong on stating, that there is a need and in fact a justification for having an evidence-based approach to the enactment of this sort of legislation, and obviously I'll take by that an implication that ideological considerations should not be to the fore.
Could I put that to you, Biss, that with respect to the professor referred to the research being done and undertaken, and specifically referred to a case study of Victorian doctors who are participating in the VAD scheme.
Yes.
But they were the sample, the doctors who participated in the VAD scheme. As I understand the research, it wasn't surveying doctors at large, it was specifically surveying doctors who participate in the VAD scheme. Now, it may well be the case that those doctors who are in fact involved in the VAD scheme have a different view. In fact, it's likely that they would have a different view about the matter of issues around eligibility than doctors who are outside the VAD scheme. So it's interesting to say that this is evidence-based research, but it's a case, though, of picking what your sample is.
If I could interpolate, sorry, I didn't mean to do so, but I think Professor Wilmot, she referred to the particular study. It's not one that the Bar Association.
No. But I'm just making the point. I'm only taking the lead from the professor's evidence this morning that the actual sample of the doctors upon which the research and the learnings that they see are drawn from the research are from doctors who participate in the scheme, not doctors at large. So, I mean, it seems to me that begs the question that it may well be, in fact, a piece of research that is actually producing a result that one would not be completely surprised about, because these are doctors who are participating in the scheme and no doubt have a view about voluntary assisted dying.
Well, with respect, there are a number of assumptions in what you've just said about that particular study. And again, if I could defer to Professor Wilmot, who is no doubt itching to address that particular.
So I'll invite Professor Wilmot to make a contribution, and then
I haven't finished my questions.
Well, I think other members of the committee are entitled to time as well.
I've got Mr. Carney wants to ask a question, and then Ms. Fairman. So Professor Wilmot, if you could make a contribution, then I'll pass to Mr. Khan.
Sure. So first of all, that's correct. The doctors that were surveyed were interviewed, were specialists. And I want to clarify that the general statement, the general concerns they had was broadly the safeguards writ large were providing access issues. I didn't say that they specifically made in terms of the definition of eligibility of the doctors.
I'll give you a chance to clarify.
Or not.
Well, can I just clarify, Professor
Wilmot,
you said specialists. these are specialists participating in the VAD scheme. Is that correct?
Yes, there are a range of doctors. In Victoria, one of them has to be a specialist. So not all of the sample were specialists. So some were generalists, such as a palliative care physician.
But they're all participants in the VAD scheme in Victoria. Is that correct?
Correct.
Thank you.
That is correct.
Thank you. That's all I want to clarify.
And if I might just, if I could just perhaps add to that, would that be permitted?
Yeah, well,
Yes,
if it's not
please.
on his time, it's on mine, so you're going to get the chance. It's
Oh, no, I'm happy. I've got more questions, but Mr. Trevor Khan's got a question, I think. So.
Professor White, I'll allow you to make a contribution, then I will pass to Mr. Khan.
Look, I guess the key thing there is the research question was, how is the system working? The only sensible group to interview were those who are actually involved in voluntary assisted dying. That was listed as a limitation of the research. The study is with you. It was sent through as a submission. So the limitations of the study, as per usual research conventions, have been fully disclosed. But that is the only sensible sample to talk to. The sort of study you spoke about of sampling all doctors who don't have engagement or understanding with the system wouldn't advance understanding on that.
Well, can I ask this question?
I must pass to Mr. Khan because he has indicated.
No, look, if Greg's got a further question, I don't want to be in any way accused of stifling debate.
Well, it seems to me that if we're talking about this issue of, I use it in quotes, safeguards, whether they are at a particular level or need some modification or refinements, I do not understand why you would only choose doctors participating in the scheme, because doctors at large, namely specialists not participating in the VAD scheme or general practitioners not participating in the VAD scheme, may have also views about the matter of the safeguards. And they may well be quite contrary views in terms of the safeguards are not high enough and may engage with you over concerns that they have with respect to the fact that the safeguards are not rigorous enough. So to essentially, now let me finish, so to essentially use a subgroup who are actually only supporters of the legislation seems to me to be quite jaundiced.
I'll rule that last section, the last comment, out of order. I'm going to provide Professor White an opportunity to respond, and then I note that the time is almost finished, and we do have participants who have a 1 o'clock.
Can I say, if the word jaundiced is not appropriate, skewed. Skewed.
Well, I'm going to rule that out of order as well. We're not going to draw conclusions. I'm going to ask Professor White to make a contribution, please.
I'm also conscious of time. I would just invite the honourable member to read the study.
I have.
According to research conventions, it contains appropriate limitations. I'm probably not sure there's much more I can say about that.
Could I just add that it was published in the Medical Journal of Australia, a peer-reviewed journal. I'll say nothing further, and that can be brought down to conclusion.
Yeah, we've got very little time left. Mr. Khan, have you got something quick that you wanted to clarify?
Quickly, I'll put this to Mr. Glover and Mr. Beckett, and I think this is within your area of expertise. There was a question asked earlier on with regards to Clause 6 and the presumption in favour of capacity. If you look at such cases as Hunter New England Area Health Service and A, which was an advanced care directive case, I think you knew that, but others might not. That case reinforced the view that at common law there is a presumption in favour of capacity, does it not?
Yes.
Yeah. And indeed, if you look at those advanced care directive cases, apart from the patient having capacity, really those cases which deal with the capacity of people essentially terminating their life through the direction of the removal of medical care, including food, water, etc., none of the safeguards that are contained in those bills, in this bill, apply to the making of an advanced care directive that may achieve precisely the same result. That's right, isn't it?
Yes, that's right.
On that note, I note the time and we are almost about to pass 1 o'clock. I want to thank all the witnesses for appearing today. Thank you very much for making yourselves available. For the questions that have been taken on notice, the Secretariat will be in contact with you to liaise their tabling. We'll now have a lunch break and we'll return at 2 p.m. Thank you very much.
Thank you.
Thank you, Chair.
Thank you.
Yeah, I was just making, yes, well, we are live. For returning to this afternoon session of the hearing, I'll ask all the witnesses, starting from my left, to state their name and position title and swear either an oath or affirmation.
My name is Dr. Gavin Patello.
You might have to bring the microphone a little bit
My name is
closer.
Dr. Gavin Patello. I'm a senior staff specialist anaesthetist and pain medicine physician in Sydney, and I'm going to swear an affirmation.
Thank you. You can do. You have to read the affirmation.
Oh,
now.
I have to read. Sorry. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much.
Sorry.
Dr. David Leaf. I'm a GP and medical educator. I'm also the New South Wales State Convener for Doctors for Assisted Dying Choice. I shall take the affirmation as well. I solemnly, sincerely and truthfully declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much.
And I'm Robert Marr. I'm a GP and Vice President of the Doctors Reform Society. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Dr. Marr. Does anybody have an opening statement they wish to make, or do all three of you have one? And if so, we can start. Perhaps if you'd like to start, Dr. Tulio?
Yes, I think we all have opening statements. I'm happy to start. Thank you very much. So I've already introduced myself. Clearly, the VAD discussion encompasses the areas of pain and suffering, and I certainly I'm grateful for the opportunity to speak to the committee about those topics, as that's an area of my expertise and knowledge. I've been very fortunate in my career that I trained under and then worked alongside Australia's foremost pain management expert, who was world renowned, and he did actually write the textbook on pain management. More importantly, though, I'm actually here to be the voice for my wife, Dr. Vanessa Patello, who at the age of 42, 3 years ago, took her own life. That was after 14 years of living with recurrent aggressive leukemia, the treatments for which had left her severely short of breath because it had damaged her lungs, a known side effect. And she faced a death by asphyxiation. Vanessa hadn't been beaten by her cancer. She hadn't given in. It was quite the opposite, in fact. She took the upper hand and she took control, and she beat it at its own game. On the 2nd of July 2018, I went off to work like any other day, thinking that I'd come home to see my beautiful wife. And I did come home to find my beautiful wife, but she was no longer alive. Vanessa had been forced to take her own life alone and without saying goodbye to her loved ones because of the laws of this state. I always knew my wife was going to die before me, but I wanted that day to be with me holding her hand and her holding my hand, so we both knew everything would be okay. Thank you for listening to Vanessa today.
Thank you, Dr. Chula.
So I'm a practicing GP with 27 years experience in that specialty and 31 years as a doctor. I have both Australian GP specialist fellowships and postgraduate advanced diplomas in emergency medicine. I've worked in 3 countries, including 4 tours of duty overseas with the Royal Australian Air Force and the United Nations. I'm also a medical educator, training urban and rural GPs with roles in assessment and curriculum development for the College of Rural Medicine. I'm also an expert reviewer for the Australian Journal of General Practice. Most importantly, I am currently providing palliative care and end-of-life care for patients through my practice in their homes, in nursing homes and in hospitals. I've often known these patients and their families for many years, and I live in their community. I'm currently the only New South Wales active campaigner for assisted dying choice who's currently engaged in palliative care, although I know many of my colleagues sympathise with our cause. I've been campaigning for assisted dying for 18 years after seeing 2 horrific deaths where palliative care was unable and in some cases unwilling to assist. I speak on behalf of our group, the Doctors for Assisted Dying Choice, which is a national and now an international body, having a chapter in New Zealand. I support this bill for the following reasons. It will assist my profession to offer the full suite of options for patients at end of life. Some patients want this as the least worst option. It allows them to take control and to be assured that their death will come in a timely and peaceful manner when they can withstand no longer, something that my colleague's wife was unable to take advantage of. I support their autonomy. And the third reason that I support this bill is like any other medical intervention or treatment choice I offer my patients. It is now supported by international evidence and a wealth of national evidence from our country. And when I say support, it supports the utility of this method and the safety of this intervention. And I must evaluate these interventions that I give my patients as a scientist and a physician, and I'm satisfied that it's safe.
Thank you.
Thank you. Yes, Mr Chairman and honourable members of the committee, the Doctors Reform Society supports the legalisation of voluntary assisted dying in New South Wales and strongly opposes any amendments that would make it more difficult or onerous for terminally ill people to access the law of voluntary assisted dying. I've been a GP in New South Wales for over 40 years, and I've had, unfortunately, many conversations with terminally ill people about what they want. Most of them say they want to know a bit about how they might be going to die. Most of them want to die at home, and some of them say to me, "Please don't let me suffer, Doc." Tragically, most terminally ill people in New South Wales die in hospital, and they often have distressing and difficult deaths. Some of you may be aware of the article written by Professor Chris O'Brien's daughter about his last 3 days. Now, you'd think a professor with a terminal illness, professor of neurosurgery at Prince Alfred Hospital, would be able to organise a decent death. Well, he didn't have a decent death. Professor O'Brien wanted to die at home. He'd organised palliative care to give him a palliative care bed. That's what they'd given him, a palliative care bed. He woke up one morning and he had bleeding from his head and CSF leaking out of his brain. And he knew as an experienced neurosurgeon that he was dying, and he was going to die. And he wanted to die at home with morphine. So he did the logical thing and he rang his GP and said, "Can I have some morphine?" And the GP was away and it was a locum, and he said, "I'm too busy to come and see you." So then he got his wife to ring the ambulance. The ambulance arrived and he said, "Look, I'm Professor O'Brien, I'm dying, I just want some morphine." They said, "Well, we don't have any morphine, you have to ring an ICU ambulance for that." So he rings an ICU ambulance and they arrive. So he's got 2 ambulances at his place. He said, "Look, I'm Professor O'Brien, I'm dying, I've got the palliative care bed here, I just want some morphine so I can die at home." They said, "Oh, we can't give you morphine like that. You've got to go to hospital if you want morphine." And he said, "Why do I have to go to hospital?" And he said, "Well, we're not allowed to give you morphine at home just if you want to die. You know, it's, I don't know whether they said it could be assisted dying or whatever, but they said it's illegal, we can't do it." He said, "All right, so I've got to go to hospital." He said, "Yes." "That's the only way I can get morphine?" "Yes." So they gave him some morphine, he agreed to go to hospital, and they took him to Prince Alfred. He spent the next 2 days, according to his daughter, quite in some suffering, but they were there in hospital. They gave him the best treatment they could, no doubt, probably morphine and all sorts of things. And they were all gathered around for over 2 days, waiting for him to die. And in the middle of the night, he sits up, and they think, "Oh, he's going to say something." He just vomits profusely and then collapses back in bed. And then shortly after that, he died. And that's Professor Chris O'Brien that we named that hospital after. Now, if he can't get a decent death, who can in New South Wales? I became personally supportive of voluntary assisted dying through my father's death. My father died of motor neurone disease. Now, before I thought about voluntary assisted dying, I used to think, well, maybe palliative care can ease all the suffering of dying people. But then I thought about my father, and he didn't have really any pain. He was just suffocating to death. And palliative care couldn't have eased that. And I know palliative care can't relieve all the suffering of terminally ill people. And most palliative care doctors will tell you that. Even Professor Ian Maddox, who's regarded as the grandfather of Australian palliative care and was Senior Australian of the Year in 2013, he said, one of his quotes is, "Voluntary assisted dying can be good medicine when it's seen as part of palliative care." That's what he views. It's a logical part. And I know from my discussions with patients that, you know, they want to know that when it really gets to the end of their life, that somebody's going to be there and that won't just leave them suffering. I guess at the end of the day, this law's not really about doctors or even politicians. It's about empowering terminally ill people, which could be any of us one day, to have the legal right to decide how much suffering we have to go through at the end of our life. Thank you.
Thank you very much for those submissions. I'll now open for questioning. Mr. Diadam, did you want to perhaps...
I can kick off. Look, I wanted to ask specifically around the submission in regard to the experience in WA. I had a question about the operation of clauses 59.7 and 68.1 of the New South Wales Bill. These provisions weren't there in the WA Act around the supply of the lethal medication. So I wonder if maybe you could elaborate on that particular provision, the experience in WA, and why you think the provisions in the New South Wales Bill are appropriate and necessary.
Could you elaborate the question, please?
In relation to authorising agents and contact people to prepare the supply of the lethal medication for self-administration. The submission says that this proved a problem in WA, and I wonder whether you might be able to elaborate.
Our group has a Western Australian section, and to my knowledge, the biggest problem in Western Australia at the moment, having it only been in operation since the middle of the year, is that the distances involved in Western Australia is a problem. It's centrally located, the pharmacy in Perth, of course, and so getting the medications moved to wherever it's needed it can be a problem. Secondly, the number of doctors who are involved in assisted dying, whilst growing rapidly and satisfactorily, is fairly small at the moment. Last time I heard, it was something like 40 to 50. So the number of doctors involved is a problem for prescribing and getting the process moving.
Right, I see. Look, I might ask about, I asked earlier about terminal sedation, and I wonder whether you could give the medical profession's perspective on terminal sedation and why it's not an appropriate alternative to voluntary assisted dying.
So terminal sedation is not what we're talking about here. Terminal sedation is a change in the treatment of a patient who is actively dying, and it's usually used fairly imminently, where death is imminent. Okay, so their symptoms are unable to be controlled by often pain, but sometimes shortness of breath, like Robert was talking about, unable to be controlled by escalating medication doses. And so the doses, usually morphine or other drugs like midazolam, are increased well above what we would normally use for non-dying patients. And the acceptance is made that that increase in dose will cause their death. It is done in consultation with the treating team, with the patient if possible. Sometimes it's not possible because they're comatose or delirious, but certainly with their loved ones. And it is often an expression of their advanced healthcare directive, if they have one, or if failing that, if it's plain common sense that should occur, they're very elderly with advanced disease and any further curative treatment is futile, then terminal sedation occurs. That's a different scenario to what the New South Wales Bill is talking about. And I'd like to just make the distinction to help you understand that a little bit from a medical profession. The ideal assisted dying conversation occurs with someone like me or Robert or Gavin in the cold light of day in an office where there's no time imperative occurring, where there's an open and honest and a conversation that can occur with or without the patient's relatives as they want, where the patient is competent, as opposed to in the last few days where someone is actively dying. If we've got to that stage, we've missed the boat.
And on the topic of terminal sedation, I think as doctors we know that there are plenty of documented cases of people coming out of terminal sedation. So it's not a guaranteed thing that, you know, people stay unconscious. There's, you know, documented cases of people coming out saying, am I dead yet? You know, it's not a guaranteed way that a person is going to die, because you have to titrate the doses, people get used to them. And it's not, you know, because of the law, a doctor can't actually give a lethal dose. You're gradually increasing the dose, and some people have different responses. But there's a bigger issue here, really. Terminal sedation is something that doctors do to patients, and that's not really what voluntary assisted dying is all about. What this law is about is giving and empowering terminally ill people, which could be any one of us one day, to decide for ourselves. It's not up to the doctors, it's not up to the priests, it's not up to the politicians. It's up to us as individually terminally ill people, what we want to do at the end of our life. And that's what voluntary assisted dying is all about. And that's why it's totally different from doctors administering terminal sedation, which may or may not, you know, help end up a patient's life.
I think Ms. Furman, you had a follow-up?
No, you go.
I was going to give you an example of a case where this might illuminate it for you, and pictures paint 1,000 words. And it was the first case that ever got me involved in the assisted dying cause. It occurred in 2003 with a fellow called Ian, who was a local businessman in his 50s, and he had a cough. And I saw him one day and got a chest X-ray, and his lung was full of fluid on the X-ray. And he said to me, "That's mesothelioma, David, and I want you to help me die." So this is 2002. And I spun around and said to him, "Hang on a minute, slow down here." Turned out that he had helped his father, who had died from mesothelioma 20 years before. And the father had died a horrible drowning death from mesothelioma. It's an asbestos-related lung cancer. It's horrible. There's no cure, and there still isn't 20 years later. And Ian had helped his father wash his boiler suit when his father came home from the factory. Now, Ian had acquired mesothelioma. He knew it. He could see it, a non-medical person. And I told him I couldn't help him. I'd be there for him. Long story short, and about 8 months later, Ian was drowning in his own lungs. The tumour had eaten through his chest wall where a biopsy had taken. It had involved all the intercostal nerves. And he was not only in agony every time he breathed, but he was drowning. He was short of breath. And he knew what was coming. He'd known for 8 months, ever since I'd shown him that chest X-ray. Colleagues like Gavin, who were pain specialists, were unable to help him. There wasn't a specific treatment for that. And even these days, it's enormously difficult to treat. The palliative care team were unable to help him. There was nothing they could do to relieve his symptoms. The radiation oncologists couldn't help him, the surgeons couldn't help him, and I was stuck in my country town with a palliative care team trying to give him doses of morphine. And the palliative care team wouldn't let me increase the doses, even though I was the doctor in charge, and there was a palliative care physician at a distance in Newcastle. They wouldn't let me increase his doses to a level where his pain to him was relieved. And I'll never forget Anzac Day 2003 when I visited his home. I happened to be on call that day, and I will see his face the day I die. He was sweating, terrified and in agony, and so were his family. So I started terminal sedation for him, which he was able to be he was able to get comfort for and relieved for 3 weeks. So we sacked the palliative care team through consultation with his family, and he had comfort for 3 weeks until he passed away. That was terminal sedation. What he wanted had been 8 months before, or at least had the option.
Thank you.
Yeah, I think Dr. Leaf kind of explained it pretty well then, but also, Dr. Ma, you talked about the patient's agency and how empowering it is, and their ability to, at a certain point in time when they know potentially what is ahead of them, to be able to avoid the worst of it. Dr. Leaf, you said that's, with the consent of the patient in terms of terminal sedation. I assume that's not. I assume by the time you're getting to terminal sedation, that is often a difficult thing to get the patient going, yes, I'm okay.
By definition.
Yeah.
Absolutely. Yep. Their disease is well advanced, their multi-system failure, they may be demented, and they're not the patients we're talking about here. They may never have had capacity. And may I say, terminal sedation happens all day, every day, in every hospital in our country and around the world.
I'll come back for more, but...
Thank you. Well, I'll pass to the Deputy Chair for...
Thank you, gentlemen, for coming in today. Dr. Leaf, can I just ask you, with respect to Doctors for Voluntary Assisted Dying Choice New South Wales, that's a membership-based organisation?
It is.
And how many members do you have in New South Wales?
Is that relevant?
Yes, it is. It's my question to you. You're here appearing on behalf of an organisation. As their spokesperson, I'd like you to let us know, or tell me specifically.
Well, I will take the point of order. Apart from this inquiry being into a bill, look, if we go down this line, on Friday, do I ask...
You may.
No, I'm taking a point of order. Everyone who comes along, look, how many people do you have in your organisation? Are you kosher in some way? And I think... what we will do is denigrate both the witnesses and also the quality of the evidence that we receive. So I just genuinely ask that we carefully navigate this without ending up crucifying witnesses who are coming here genuinely on both sides.
Well, let me make it very clear. It's a very specific question.
Well, I'm going to make a ruling on this.
You haven't even heard from me.
Well, I'm going to rule, but what I'm going to... So the ruling I'm going to make is the question was in order. However, I will caution all members that this is somewhat of a Pandora's box. This is opened up here. As Trevor said, it can be opened up elsewhere. Absolutely. Now, I would also caution that this is an inquiry about the bill, and I have allowed a little bit of latitude around this, but I would just ask, Deputy Chair, that you perhaps reconsider the question. If you still want to press it, then that obviously may open up a number of issues later on.
That's okay. We have various doctor organisations appearing before the hearings. You're one of them, your organisation, and Dr. Ma, your organisation. It's fair and reasonable to ask the question about the size of your membership in terms of its voice into this debate.
Sorry, I was just going to also, when you finished your question, I just want to remind witnesses as well that they can take the question on notice. That's the other option I was going to make. Thank you.
So my question is, with respect to the membership of your respective organisations, Dr. Leaf, the Doctors for Voluntary Assisted Dying Choice New South Wales, what is its membership in New South Wales?
It's several dozen. I haven't counted it recently, but I may say that since the last 6 months, our numbers have swelled.
Okay, well, several dozen is your answer. Is that the answer?
Mm-hmm.
Okay. So, Dr. Ma, with respect to the Doctors Reform Society, which I presume is the New South Wales branch, is that the case? How many members do you have?
We've got about 100 members.
You've got 100 members, thank you. Moving on then, can I just ask this question about the issue of pain? Because we're talking about pain, we have obviously at the table here some people with some quite significant experience with pain and pain management. Do you agree, and I'll ask, the question is the same question to all of you and you can answer it as you see fit, but it is directed to all of you, that do you agree that suffering pain diminishes voluntariness with respect to decision making? So the experiencing of pain, that does impact, or shall I say, it can impact, and clearly if the pain is strong pain, it's probably on balance likely to impact on the decision making of an individual.
I'm happy to answer that one for you.
Well, I'm actually asking all three of you, so I can start with you.
I'll start. Yeah. So I'm an anaesthetist. I've put in several hundred epidurals into ladies in labour, and they're all suffering in pain, in extreme pain. And I do a consent for every one of them, either verbal or written. And those all hold up in court. So that's my answer.
No. Sorry, I think you misunderstand my question.
Can you explain it further then?
Well, I can't be any clearer than putting it the way I did. That with respect to this, the experiencing of pain, an individual experiencing pain, a human being experiencing pain, do you agree with the proposition that the experience of pain, and let's assume if it's a very mild pain like pricking a finger with a needle, on a scale right through to that sort of existential pain that we're talking about in the context of end of life, that looking at the end of life pain, that very serious pain at the end of life, that does or can and does impact potentially on the voluntariness of the decision making of the person about what to do in their circumstances?
I'm not really sure that that's a really appropriate question. I think at that sort of stage of life, where you're suffering
Deputy Chair, he must be allowed to conclude his answer before you interject, please.
That's not an appropriate question.
Because I think if someone's suffering that much, then they're going to be on a lot of mind-altering medications at that point. So you're kind of clouding the question when you put that or clouding the answer when you put it like that. And I really, that's why I said to you about ladies in labour who are in extreme pain and they are capable of giving a consent.
Mr. Chair, may I seek leave to answer slightly obscurely, and then I'll directly answer the Deputy's question?
Very much.
Yeah. Can I say that the international evidence is that pain is about the third or fourth symptom which is responsible for patients in their surveys accessing assisted dying around the world. It's not in the top 2 or 3. In fact, in Oregon, it's number 4.
No, thank you for that. That's very important evidence.
In front of that is existential crisis and losing autonomy. Those two are the main reasons patients want to access assisted dying choice, right? In relation to the Deputy's question, when you actually understand, as doctors do, and they have to, the tests for capacity, it's got nothing to do with pain. In fact, patients who have slight cognitive impairment, which we're not dealing with here today, they can still have capacity for specific decisions. So the test of capacity is that the patient can understand what you're saying, they can weigh up the decision, they can then communicate back to you in a reasonable way what their decision is. Okay? Now, pain will certainly get your attention, and particularly if it's a horrible, unremitting pain like my patient Ian that I mentioned, right? But it does not affect the medical or legal definition of capacity.
Well, I understand your answer, but my question was going to this point, to sort of follow on. We're dealing with the issue of outside of Newcastle, Sydney and Wollongong, many citizens of this state who just do not have access to even the most basic of palliative care. In fact, towns around the state that don't even have a GP. So we've got people in those communities dying today, tomorrow, yesterday, in a week's time, in circumstances of reasonably challenging pain because there's just no palliative care. So I'm trying to understand in those circumstances where that is a matter of fact, and no one's really contesting that as far as I can tell, that has the potential to impact on their decision making because they can't access the palliative care that otherwise would be reasonably available certainly in the big population centres around New South Wales. And for me, that's a matter of concern in the context of this sort of legislation, because we're not talking about delivering Rolls-Royce palliative care to every last citizen in the state. We're talking about citizens in country New South Wales where there isn't even a GP in the town to provide the most basic of pain relief.
May I answer now? Yeah. So I'm a rural generalist. I've spent many, many years working in the country. I educate rural doctors. And so I'm acutely aware of the problems accessing all kinds of medical services, not just palliative care. But may I remind you, Mr Deputy, that at least 80% of palliative care in this country is delivered quite competently by general practitioners, rural or city. Right? That's the first thing. The second thing is that if I was a GP in one of those rural towns, the very first thing I'd be telling that patient is what their full suite of options are in the ideal world, as it would be for anything. And one of those options is the benefits and boundaries and limits of palliative care. Now, palliative care is just like every other specialty I work with on a daily basis, whether it's cardiology, dermatology, and it has its limits. Palliative care is great, but it's not magic, okay? Now, you cannot, Mr Deputy Chair, relieve existential suffering or lack of autonomy with a morphine drip. I've seen it. You can't do it. If a patient that I was working for in West Gundawindi or somewhere where they couldn't get access to the pain relief they need, it's not a default setting then just to give them a magic green pill. The default setting there is to get them to somewhere where they can access adequate pain relief.
I'm just about to pass to the Honourable Trevor Khan for some questions, and then I'll actually be asking some myself. Mr Khan.
Look, I'm happy to, but you haven't had much of a go in any so far, so I'm happy
I'm
to.
being, well, thank you, Mr Khan. Well, Mr Pachullo, Dr Pachullo, apologies. I was very moved by your story, not only your submission, but you had an article in the Sydney Morning Herald, I believe, and it was, it was particularly moving. And I noted in your opening address today that you said you were going to be a voice for Vanessa. So I wanted to give you that opportunity. But I also, I guess I was seeking, did you have the opportunity to speak with her about what it was that she would have elected to do? And what were you aware of what her choices would have been had she been given the opportunity? I'm keen to know through you what her choices would have been for herself had she had them.
Thank you. It's obviously quite personal, I guess. It's also very hard. I suppose, I mean, everyone's in love with their partner. Vanessa was an amazing human being. I've never met anybody like her. The smartest person I've ever met. She already had a worldwide reputation in her field. We all thought she was going to be Professor of Medicine one day. You could not get anything past her. She'd worked most of her life in a hospital. She'd seen everything. She'd worked on palliative care wards. She knew what palliative care wards were about. And I think that's a really key message when you've got someone like Vanessa, super smart, super compassionate, super caring. She chose to die alone without saying a goodbye to her loved ones. And that was for a really, really good reason. Because she knew what the alternatives were. She did not want to die in a hospital. She knew what it would be like. We've seen it as doctors. Most of us, it's a stat that we all know. Most doctors refuse most of the medical therapies that are available because we know what they're like. The public doesn't know what they're like, and we tend to refuse them. And that's what you saw with Vanessa. She said, I'm making a choice, doing it at home. So I think it's very clear what she would have chosen. If VAD was available, she's shown you what it was that she would have chosen, because she did it herself. It's just that it wasn't legalised, and she couldn't say anything to me or to the rest of her loved ones for fear of insinuation of involvement.
And incrimination, perhaps?
What's that?
Incrimination as well?
Incrimination, insinuation, incrimination. That's why she did that. She knew that she could not put any of us at risk of that. And I think it's a tragedy. It's just an absolute tragedy. It burns my heart to think of her walking up the stairs to our bedroom, knowing that that was the last time she was ever going to walk up to the bedroom, that I was going to find her on that bed that night when I came home. And I don't be too sad. It was beautiful. She was the most beautiful girl I've ever met, and on the day of her death, she was still the most beautiful girl I've ever met. It was just beautiful.
If I could just add something, I've often thought, as doctors, we see quite a lot of people die, and we know that in most cases, actually, it's not very pleasant. And this is the thing that most people don't realise. I think I've always thought it'd be really good if you died twice, because you'd say, well, I don't want that death again. Most cases, deaths are not pleasant. They're distressing, discomforting, and upsetting. We do the best we can in hospitals, but honestly, most deaths are not good. So, if people died twice, we would have had voluntary euthanasia years ago, because people would come back and say, well, I'm not going to bloody die like that again. Most deaths are pretty bloody awful, even with the best palliative care.
Mr. Chair, can I make a point, please, in relation to my colleague's moving story? I've been in contact with my counterpart in the United States, Dr. David Grube, who's was one of the original doctors in Oregon who has been involved in assisted dying for 24 years. He came out to Australia in 2019 to assist us with the Western Australian debate. And he made a really interesting point, having lived through both sides of the legalisation prior to the legalisation in Oregon in 1997 and since. And he talks about the differences in the families left behind between the two types of deaths. And I think it's something that we need to be as a community mindful of. So in those families who have had to come home to find their loved one deceased, and it sounds like my colleague had not as bad a experience of that as some families get, where the person has some sort of horrible end, or it's occurred in a surprising way, compared to those deaths where assisted dying has been able to be achieved. Dr. Grube has said repeatedly that the families left behind, and especially children and adolescents, are much better off for the rest of their life. And you can imagine coming home to find your father or loved one dead in some grisly way, compared to having the opportunity to set a date, it's coming, the person dies peacefully, there's some music, you get to hold their hand, you get to have a cry and say goodbye. What do you think will be the difference for that community?
I know Ms. Fairman had a follow-up question. I've got one more after that. No, you ask your follow-up, then I've got one more, then I'll pass to Mr.
Thanks,
Khan.
Chair. It was just in relation to, which I think is a really important point. I know, Dr. Leaf, you've spoken about it before, but in relation to the fact that I think it's 1/3 of terminally ill patients who get approved and are able to access a life-ending drug under the scheme in Oregon, and I think in Victoria where it works. Yep. Okay, don't end up using, and it's that whole peace of mind. I think, Dr. Petula, maybe it's relevant for you to answer this as well, in terms of the peace of mind that if Vanessa had that, no doubt you would have had probably many more days with her. I don't want to say that as an expectation, but that's what's happening for at least 1/3 of people.
Which was the question I was going to ask.
Oh, sorry.
No, it's exactly. I think we're on the same page, with...
Did you want to say something?
Sorry, sir.
No, you're spot on.
Do you want time to think?
I was just going to comment what my colleague David was saying, that when it's essentially illegal, what my wife did was illegal, so I could not access any counselling services. I don't think I've done too badly. You won't find me wandering down the street at 3 a.m. in my pyjamas yelling out her name. I think I've coped quite well. But I don't think people always have the sort of resources I had available. I've got a very deep medical community colleague group who were extremely supportive of me, but I did not access formal counselling services, which I think people should be able to. I was too scared to see a psychologist because for fear that they would have to mandatory report me for a concern that I may have been invaluable. So I kept quiet to any proper professional, and I only talked to my friends about it. And you could imagine people who are isolated, what devastation that's going to cause them. Because I can tell you, I carry a lot of guilt about going off to work that day and missing things. So you could imagine someone who hasn't got that resources available to them. You're leaving this collateral damage, not just the person that's died. There's all this other collateral damage. And you bring it into the open, get proper counselling. It's so much better for our society.
But also the preparation for the event, as I was trying to describe it. Thanks, Kate, for bringing that up. And that's why our group would actually prefer to see the qualification period of 6 months be extended to 12 months. Because, as we know, 30-40% of patients don't take the medication. But they all say internationally, and now in Victoria and West Australia, that having that medication in the cupboard gives them the power, and it is palliative care all by itself, having that there, because they know that if things get really bad, they can take it. If you wait 6 months, often the disease is more advanced, it gets harder to prognosticate. At 12 months, you're allowing that medication in the cupboard all by itself to be have a palliative effect.
And I think that's the most important thing, that this is really about empowering terminally ill people. And quite often, in up to a third of cases, people don't use or don't access the lethal dose, even though they've been approved for it. But it gives them that reassurance. And that's really what voluntary assisted dying is all about, empowering terminally ill people. And I'm always surprised that, like in Oregon, where it's been legal for over 20 years, less than 1% of deaths use voluntary assisted dying. Even in the more liberal states like the Netherlands, it's only about 5%. So very few people actually use it, but it's very strongly supported because most people really would want that option just in case. It's like an insurance policy. First of all, the policy there, it's legal. And then if you get approved, if you have a terminal illness and you go through all the process and you get approved and you actually have that lethal dose, but you might not choose to use it because it's still...
Only 1/3 of those who are approved will not use it.
They die with it still in the cupboard.
Yeah, but it gives them great reassurance, and often they live longer than they might have otherwise, and they don't have to take their own lives in all sorts of desperate ways.
Thank you. Mr. Khan.
So, in a variety of the emails that we've received, and no doubt in the evidence I suspect that we'll receive tomorrow, one of the assertions made is that because a person has received a diagnosis of, for instance, cancer or some other life-terminating illness, that these people are depressed and therefore lack capacity to make an informed decision in the context of that. I wonder if you'd like, as doctors and Dr. Patello, quite frankly, in terms of a personal experience, as to whether that concept of being depressed as a result of the diagnosis is a valid basis to say that people aren't actually making a rational decision.
Can I please answer that? There's a big difference between being clinically depressed and being unhappy. Okay. And being...
I actually do understand that difference, but it's good that you pointed out.
I understand that you do, Mr. Khan, but I think some people don't. You can be very distressed about the diagnosis, and most people would be, let's face it. But to then stretch it to say that they are so depressed that their clinical decision-making is affected almost never occurs, okay? And if we examine the patient as doctors and we feel that they are exhibiting significant signs of actual major depression such that their cognition is impaired, then I will guarantee that I will seek assistance from a specialist involved at that point. But I've never met a terminal patient, a patient in whom I've diagnosed cancer, and I did it last week for a young lady, who is anything other than distressed and unhappy. but I wouldn't go so far as to say that she's depressed.
Dr. Patella or Dr. Ma? Do you...
Well, I don't think being depressed necessarily removes capacity anyway. I think a lot of people depressed and they can still make a rational decision. So it's even if a person was depressed, you could still clinically assess, their situation. If it was primarily due to their terminal illness, well, that's quite rational and reasonable. I mean, probably a lot of us would be depressed if we were going to die within a few months, So it doesn't mean you can't choose to end your suffering. If you're going to die anyway, and you also happen to be depressed, what are you going to do? Force them to stay alive and force antidepressants on them, and basically. This whole law is about empowering terminally ill people, not forcing them to endure more suffering. If they're going to die anyway from their terminal illness, we're just enabling them to have the power to legally choose to end their suffering and not to linger on and force them to suffer more.
And I just add sort of on a counter-argument, I mean, 2 days before Vanessa ended her life, we were out celebrating her 42nd birthday at her favourite restaurant, and she almost wiped me out, spending money on expensive French champagne by the glass. She wasn't sad, I can tell you what. She was very, maybe it's because she knew what she was planning. I don't know, but certainly for her, I wouldn't have, I didn't pick that she was down or whatever. So I think there's a whole spectrum, I think, that we're going to see for patients with this sort of diagnosis.
And that has certainly been the experience around the world where voluntary euthanasia or voluntary assisted dying has been legalised, that there's great relief amongst the terminally ill people once they know that they have a mechanism that they can end their suffering. And then quite often, almost miraculously, many of them don't use it because they have that reassurance that that thing they feared the most, a horrible death, they're not going to necessarily suffer that. And so they often prolong their life and they have a deep sense of relief.
All right. Well, my only other question is this: in the context of VAD, one of the common arguments put against it is, I'll shorten it to say, elder abuse. If the law passed, how would you, as a treating physician, attempt to deal and assess coercion of elderly patients?
Can I tell you what I do with any vulnerable patient? Whether it's a teenager, a refugee, a mentally ill person, or an elderly person, or a dying person. After you've assessed that they're able to talk to you and they're of reasonable sound mind, you ask them how they would like you to talk with them about a really delicate topic. And this is how we train our registrars, by the way. And if that person, and we offer them, they can talk alone or they can talk with a loved one with them. And if I have the slightest suspicion, I ask to speak to them alone. And sometimes if it's a teenager, I will get a nurse chaperone in with me so there's no suggestion of anything improper. And if you talk to them and say, look, I need to ask you this, are you being coerced? Is there any pressure on you whatsoever to make a decision you're not comfortable with? I need to know, can you tell me? Never spoken to a dying person and said they're under any pressure. Never happened, right? But can I flip it round? If you were a family member and you were so evil that you wanted to knock that grandmother off for financial gain or something, how will you do it? You'll do it in the dark. You won't subject them to a open, transparent, accountable, government-sponsored process with lots of people watching. You'll do it in the dark in some way. I haven't even thought about how you do it, but you wouldn't do it in this process, through this process. The international evidence is that it doesn't happen.
Would any of the other two witnesses like to comment on that assertion by Dr. Leaf?
Well, that's the international evidence. I mean, this has been one of the accusations by opponents for years, and in the jurisdictions like Oregon, where it's been legal for over 20 years, and the Netherlands, they looked for all that sort of thing, and they have strong ombudsman protections and looking into it, and there doesn't seem to be any evidence in that way. And there's strong protections, of course, in the law like we have here.
Yeah, and again, you'd have to convince two doctors of your argument. I mean, that's, it's pretty tall order to get it through two doctors separately who are not allowed to talk to each other. So it's just impossible.
Yes, thank you.
I know we've only got about 9 minutes left, so I'm going to allow Ms Fairman to ask another question, then I'll come back to the Deputy Chair.
Thank you, Chair. I just wondered whether there was any, after conversations with your colleagues in other states where voluntary assisted dying has been legal, whether what their feedback is, whether there's any lessons from that, what their general viewing is in terms of how it has changed, the way in which they treat dying patients. Just anything you can tell the committee about that. I know you, Dr. Lee, from the national, is that right? The national.
I'm the national co-convener, and in fact, thank you. I was talking to Dr. Cameron McLaren last night about this very issue, and I believe he's giving evidence for you on Monday, and so he may be better to speak to about that because he's literally the horse's mouth, if you'll pardon the pun. But essentially, there are a number of minor procedural problems with the procedure of gaining approval, some people waiting too long, a significant number of patients, I forget the number he told me, but it's a significant number of patients will actually die whilst waiting for approval. He asked me to emphasise that if you wait for 6 months, the 6 months qualifying period, a number of those patients will actually lose capacity because the disease is more advanced. And so you're actually denying them access to it by relying on some arbitrary number. And he, for example, cited a patient who went through the approval process, and the pharmacist who delivered the medication telephoned him when the patient was having the medicine delivered to say that the patient had lost capacity. So everything stopped right there. So that's a tragedy because that's just a procedural barrier which should not occur. But may I suggest that question be more effectively dealt with by...
But I might just
Dr.
make a comment on that. There is some research from overseas about doctors' attitudes to voluntary assisted dying, and the research shows that when it's illegal, before voluntary assisted dying becomes legal, the medical profession's often split 50-50 or 60% against. As soon as it becomes legal, majority of doctors support it. So you'll get something like at least 60% of doctors supporting it. So that one of the reasons that doctors don't support it because they either haven't thought about it and it's illegal, So once it's legalised, the majority of the medical profession in every jurisdiction where it's been legalised back it. Yeah. And not only back it, start working with it and realise, this is obviously a logical part of medicine. But while it's illegal, doctors are fairly conservative and they say, I don't think we should be involved in that. But as soon as it's become legal in any country or jurisdiction, the majority of the medical profession support it. So at the moment, the AMA has done polls and fairly evenly split, around 50-50, maybe a little bit against, maybe a little bit for.
Amongst their members.
Yeah, amongst their members. But as soon as it's legalised, the majority of doctors will support it.
And another interesting piece of feedback that I got from Dr. Grube from the United States only yesterday is that since the inception of assisted dying and its growth within the United States, the number of US hospices, those hospitals specifically dealing with dying, that incorporate assisted dying into their care model has grown dramatically. So we are seeing not a depredation of palliative care, but we're seeing an augmentation for the patient's benefit of palliative care with the increased use of assisted dying within the hospices. That was very encouraging to me. I didn't know that had occurred.
We've got about 5 minutes left. I'll allow the Deputy Chair to...
It's fine.
Sorry, Greg, you got the call.
Thank you. Dr. Mark, just noting in answer to one of your earlier questions, or a question directed to you, talking about death, you said that most deaths are awful. They're your words. But most deaths are awful. What do you mean by that?
Well, I suppose it depends on what experience you've had, but there's very few deaths where a person just sort of fades away, like on a TV scene, where someone just sort of... Unfortunately, there's usually some severe pain. I remember asking a person who we resuscitated after having a heart attack. We actually got him back, which only 10% of people, when they do have a heart attack, you usually can resuscitate, but unlike what you see on TV.
Your numbers are better than mine.
Yeah.
That's good.
So, and I said, we actually got him back. And I said, after he'd all recovered and everything, I said, well, what was that like? And he said, it was horrible. It's like having a ton of bricks on your chest. You just can't breathe. It's a horrible experience. Now, that's what's probably going to happen to a lot of us. We'll have a heart attack and die. And that's considered a pretty good death. You go pretty quickly. It's not too bad. You go unconscious fairly quickly, but it's a horrible experience for that time. So it might only be for a short time that it's horrible. But contrasting that with taking a lethal medication which puts you to sleep, you don't have any experience of that crushing feeling, which, probably most lethal medications do involve a heart attack, but, you wouldn't experience it because you're sedated. So that's the difference.
Which leads me on to, and I think this is sort of an issue that some people around the table are concerned about, that the eligibility criteria in the bill is pretty detailed. It's clause 16, I presume that you're familiar with it. Probably well familiar with it. It just seems to me, logically speaking, a number of people caught up by your statement that you made, that most people, death is awful, won't be eligible for voluntary assisted dying under the bill. That is a fair statement to make?
Well, in reality, most people don't use it even when it is legal.
No, that wasn't my question.
Yeah, and they wouldn't be eligible, no.
They wouldn't be eligible on the bill. So is that not the case then, that those people legitimately can say, well, we're not able to have that definition around the end of our life. The bill, the Act, needs to be modified to pick up this broader scope of people who are having the bad death, as you've described. Because your words, not mine, about that most deaths are awful. So you've said that for a reason. It just strikes me that what flows from that is that a piece of legislation like this just doesn't go close to dealing with what issue is that you're really driving at.
I guess the key thing is a lot of deaths we don't have any control over, like a heart attack and things like that. So this is where you do have the opportunity to choose. But a lot of deaths just happen spontaneously. You have a stroke or a heart attack. I mean, these are the most common causes of death, sudden death. And so we're not dealing with that because you couldn't even prepare for those sorts of things. So we're really talking about when people have terminal illnesses that are definitely going to kill them, and we pretty much know how it's going to kill them in not a pleasant way. And these people, we're empowering these terminally ill people to choose for themselves how much suffering they want to endure. We'll offer them the best palliative care. We can pretty much ease most pain, not all pain, I know, but we can't ease all suffering. And people have to know, people have to be educated, and most people aren't, about how they're going to die. And in most cases, it isn't going to be pleasant. And so people should have that option. This is probably how you're going to die. We'll do everything we can for you, but we can't relieve all your suffering. You can continue on if you want to, or you can choose to have voluntary assisted dying if you meet these criteria. So we're just empowering terminally ill people, which could be any of us one day, because that's one of the realities. Death and taxes faces us all, and just empowering terminally ill people to decide for themselves, not leaving it up to the doctors or other people.
May I make a point, please? And that is, Mr Deputy Chair, if you're asserting that the law may eventually want to be changed, then...
I'm not asserting anything, Doctor.
Okay. Because in situations around the world where the government has, where the community has wanted a change or there's been advice, then it's been an act of Parliament where it's changed.
With greatest respect, that's just not true. In Canada, It was the Supreme Court that changed the law.
I'm going to have to call
with respect to people with psychological illness.
Deputy Chair. I just know the time has gone 3 p.m. And I wanted to. I've got to draw the session to a close, but I wanted to thank the three witnesses today for appearing and also sharing your story and also that of Vanessa's, Dr. Psillo, and the other two doctors for providing their expertise. For the questions that you've taken on notice, the Secretariat will be in contact with you to have those tabled with us. And I thank you again for your appearance. We'll have a short break while we switch witnesses. Well, welcome back for the second session this afternoon of the hearing. I'll now ask our next set of witnesses, starting from my left, to state their name and position title and read either an oath or affirmation.
Thank you. My name's Paul Gabrielitis. I'm just a citizen. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. Gabrielitis. I'll just remind all the witnesses that it's best to bring the microphones nice and close so that we can hear you, and also those who are watching on the broadcast can hear you as well. Thank you.
I'm Kathy Barry, and I've come here as Tom's sister to tell Tom's story. I'm just a private citizen. So I solemnly, sincerely and truly declare and affirm that the evidence now about to be given to me by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Barry.
Abby Egan. I'm also a private citizen. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Ms. Egan. We'll now provide the opportunity for the witnesses to make an opening statement, and I'll start again from my left, Mr. Gabrielitis.
Thank you. and thank you all for your time and your efforts. Today I want to take the opportunity to address the two most common logical arguments put forward by people who oppose this bill. Then I want to share with you my wife's, Anne, her final weeks and her eventual and unavoidable death. It was interesting to listen to the previous session where the two arguments actually came up. The first one was about palliative care as an alternative. My wife and I were involved in 2017. She went on a quest to help members of both houses understand what she was going through and understand the issue. She was diagnosed with motor neuron disease. I think it took about 5 neurosurgeons and 2.5 years to get a diagnosis. We met with Hugh McDermott, Gladys Berejiklian, Trevor Khan, Trish Doyle, amongst others. And during these meetings, amongst other things, we spoke at length about the benefits that Anne began receiving after diagnosis from palliative care. And last year, strangely enough, in my position as a fundraising manager for a charity, I had the opportunity to speak to Dr. Joe McGurr, who is from Wagga Wagga. You may know of him. And we're both very passionate about the equality of opportunity in regional New South Wales, especially for health services, and support for vulnerable women and vulnerable youth. Dr. McGurr is a really nice guy, I found him to be. And he recently, and I believe he rightly succeeded in making an amendment to this bill, ensuring that palliative care services were promoted during discussions with terminally ill patients who sought assistance in dying. And you've, in your previous sessions, discussed at length what palliative care has to offer, especially in regional New South Wales. I'm a little confused, I must say. I am. Because you bring up palliative care and you talk about it. And you talk about it a lot. But what you don't do is actually take any action. Although recently in Wagga Wagga you supplied, as a parliament, as a government, you supplied, I believe it was a rifle range and a gun club. That doesn't help Dr. McGurr. That doesn't help palliative care. I'm really confused at where the priorities lie. And you wheel out palliative care as an argument against a bill that tries to help people, tries to empower people. But you're not taking action. When I was invited to speak at this meeting, I was informed that all proceedings would be recorded and statements made would be under parliamentary privilege. And it was also suggested to me that I don't be myself. I be nice. That's what was suggested to me. I want to be nice. I should be nice because I need to convince you of what the bill is about. This is me being nice. You're letting us down. You're letting people down. You sit and talk about palliative care, and you sit and talk about empowering people, and you're not. You're letting the community desperately down. I'm a simple kind of guy, an average member, just a private citizen. And what I'm trying to do is reflect on you what you are causing. And this brings us to the second argument. That was most common argument. The one about duress and coercion. You are causing duress. You are coercing people to continue to fight on your terms, not theirs. It's like as if someone is in a race and you're standing on the sideline saying, no, you can't stop. I know you're tired. I know you haven't got any legs left. That's it. You're done. I can see that. But you need to keep going until I am ready to let you finish. That's what you are saying. I've run half marathons. I haven't run a marathon yet. And I dared say I got to the end of it. It was a 21K. And I crossed the line. I went, oh, thank you for being over. If I had to run another 21K, I'd gone, no, where's the nearest pub? Let me off now. And if you stood by the sidelines, no, stop. You can't stop. You need to keep going. This is what you are doing. You are taking the power of the person away. People who pose this argument of duress and coercion, and as I heard the good doctor say before me, this just doesn't happen. It just doesn't happen. I'll tell you what does happen. Count how many people, and I want to ask all of you, count how many people you have affected by not having this bill. Sir, you asked how many members in someone's association. I'm asking you the same question. How many people has your opposition to this bill affected in the last 4 years since Anne died? I want a number. You can't give me one. Yeah. What's this argument about? It's about choice. It's not about death. It's not about dying. It's not about living. It's about empowerment. It's about choice. I love the analogy and the statistics. I wasn't aware of the stats. The analogy of having someone or something there that I can call on if I want to call it quits. In the cupboard. I'm not going to use it. I just want to know it's there. You know, even if you lied to me and told me it was there, I'd be good with that. So what's this bill about really? It's about love. I want to draw a parallel here. Because love is about courage and choice. We've heard a lot about consent recently. We've heard a lot about rape, domestic violence, coercive behaviour. That ain't love, because there's no choices there. And they're all examples of individuals who are being denied choice. They're being denied self-determination. By denying someone choice over their own life, you align yourself with the perpetrators of these unspeakable crimes. You're saying they have no choice, that you have the choice over what they do. Choice is a mundane seed. This is pretty poetic. I wrote this late at night. Choice is a mundane seed that produces such a surprisingly bountiful crop. What is that crop? Comfort, security, and empowerment. I hope you're comfortable. Have you ever gone on a holiday and gone, I don't care where I go. I just want to land there. And I'll make up my mind when I get there. That's comfort. That's empowerment. You're in a privileged position. Now, put yourself in a position where if you're terminally ill, you're facing it. And that's what we're talking about, that point. Anne made her end-of-life choices crystal clear to me and our children, our extended families, her friends, her doctors, her palliative care nurses, and anyone else within reach of a diminishing voice. In her last months of life, she had a detailed advanced care plan, lodged and certified, all those things. She was going to spend 5 weeks seeing Italy. You do not want to find out how much trouble I had trying to get on a plane with CPAP machines and battery backups and you name it, we had it. She was going to spend 5 weeks in Italy. We did that. She was not going to miss out on seeing her granddaughter, she was due mid-November. She wanted to make Christmas, and she hoped to make it into the new year. But she also wanted to die at home. Lastly, most importantly, she did not want to be drugged into a stupor. In other words, she wanted to see and experience life. She accepted that her death was not going to be a good one, and despite my assurances and bravado, she was unfortunately right. Look, we were leaving Rome and we were heading back. In the back of a cab, she says, "I'm going home to die, aren't I?" And being the person that I am, I went, "Stuff this. Let's go to Africa. We've got a choice." She went, "Nah, I want to go back and see my kids." Her choice, right? Choice number one. We get to Sydney. She needed to have an operation because she needed what's called a PEG, P-E-G. Can't remember what it stands for now. I used to be able to tell you. It meant that she would be tube fed. So she couldn't eat or drink anymore because she would choke. Trevor, you knew Anne. She liked the food and she liked the wine. So she had a choice to make. Do I continue eating and tasting, or do I go for a tube feed? Her choice, right? She said, "Nah, I like my wine too much, thanks, I'm done." I think it took 5 minutes for her to realise that she wasn't going to see her granddaughter. She'd gone, "Nah, tell you what, change my mind, let's do this." And we're all sitting and going, "Okay, you're not going to have it. Okay, you're going to have it. Yep, all right, let's do it." She had it done. Lived a little bit longer. Again, her choice. She saw her granddaughter on November the 18th. She made Christmas, wore a silly hat. She then deteriorated very, very quickly. Meanwhile, don't be mistaken, we had palliative care nurses and doctors all around. We had beds, we had lifts, we had everything that could move and shake. I better change. And she lost her ability to communicate very, very quickly early on in her disease. But when it came to this time, we were using eye gauge, we were using computers, we were using all sorts of things. And she lost her capacity to use her eyes and her hands completely. So she did what she could. I weigh about 80 kilos. At the time, Anne weighed about 70. She put on a bit of weight. My leg's probably about a quarter of my weight, and I'd guess yours is too. So you can imagine the noise and the empowerment that picking her leg up off the bed, lifting it to this angle, and I hope nobody minds, and doing this. Constantly. Now, to say that she was angry, my interpretation, she was angry at me. Because I didn't keep my promise. I promised her a nice, easy death. That's what I come away with. Unfortunately, my children were there to support me and support her. So they experienced this for 2 weeks. I won't do it for dramatic effect because I've hurt my hand. Came to the crunch, I think it was on the 15th of January. Remember, this went from New Year's Day to the 15th. The palliative care team looked at me and said, "Paul, you need to call it. She needs to go to hospital. You need a break. Your kids need a break." In a moment of weakness, I agreed. But I realised it wasn't my choice. She had made her choice. Not up to me to override it. Certainly it wasn't up to you. So the ambulance came and I sent them away. Anne died the next morning. Now people ask me, and have asked me, for the last 4 years, would Anne have, if given the choice, if the laws were in place, which they weren't, would have she opted to use it? Now you've heard doctors say, 1 in 3 actually use it, or less than half actually use it. If that had been available, would she have made the decision to end her life? And if she had, at what point, right? And I tell them this, the premise of your question is wrong. It's incorrect. You shouldn't be asking whether Anne would have or wouldn't have. What you should be asking is, how comfortable, how happy would she have lived those 12 months? Knowing that she had an option to do what she wanted to do.
Thank you for sharing your story, Mr. Gabrielatis. It was a very powerful opening statement. I just want to flag that we've only got 45 minutes with this session, unfortunately, and we could probably have you here for half a day to share your experiences. But I also just wanted to offer Ms. Barry and Ms. Egan the opportunity to provide some opening statements, and then also just for the committee to ask any questions they might have in the little time that we've got left. So, Ms. Barry, do you...
Can I indicate I clearly will not have any questions. I think these witnesses are entitled to tell their story.
that might be the case, but I just
to makers, and my brother's death, that's why I'm here. Particularly here today to honour 2020. He ran a successful, he was very family and highly valued, and he was diagnosed by a team of doctors, cancer, totally cancer. It was on the left side, it was a great big gaping, seeping hole on the left side of, and he was given 6 months to live and no treatment options were available. They looked all over the world and it was so bad that that was it. So, and Tom died 6 months and 2 weeks later after that diagnosis. So the oncologist knew exactly what they were talking about in terms of time. So, but Tom endured particularly terrible, prolonged and unbearable suffering in the last few weeks of his life. And I don't want this to happen to anybody else. It was just so terrible. First of all, I want to emphasise how grateful we are that they offer. Independent living unit. Throughout the 6 months of his diagnosis, a range of treatment, moving medications, how terrible it was. Said to the oncologist in a dramatic way, might die through a few things, pneumonia, erupting stroke and bleeding. And Tom then straight away said to us, his siblings, well, obviously I don't I wouldn't want to go through that. And if the end is close and I'm suffering terribly, will you help me to pass away? And we had to explain to him that no, we couldn't, because in New South Wales neither we nor any of his medical staff could help him to pass away. But he was a very brave person and he continued on. And over those 6 months, every so often his pain had become unbearable and they'd increase the medications, the morphine, etc., and it continued on like that till the last few weeks. During January and early February, 2 months before he died, he told us he was the happiest he'd ever been in his life. He was not depressed at all, but he said he knew he was dying and he really wanted that option of being assisted to die. He said he didn't want to be in terrible pain when he died again. So about 2.5 weeks before he died, Tom said to us, his family, I'm in unbearable pain all over my body and I feel really, really sick and I'm ready to die and I want to die. And that option wasn't available to him. I feel that I have to give you some detail, and I won't spend too long, as to how he died, because unless I say it how it was, nothing's going to change. And I couldn't stand the thought of anybody else going through what Tom went through. I'm going to pass around some photos of Tom, which is a progression. Sorry to do this, but there are a lot worse ones than these, but it'll give you some idea. This is for the committee. There's my brother Tom when he was well. So, because Tom had a facial cancer, it started to grow inwards and outwards. His jaw became terribly deformed and his face started dropping. He started to drool. This is months before he passed away, drool out of his mouth, and he had terrible, painful mouth ulcers. But Tom, being the person he was, assiduously followed a puree diet for the whole 6 months because his swallowing was so difficult from this cancer. So he had episodes of semi and unconsciousness throughout the 6 months where he'd lose control of his bowels and we'd find him on the floor of his unit, soiled. This is my older brother, my eldest brother, lying on the floor with his poo all around him because he lost control of his bowels. He became increasingly frightened and unable to do things that gave him pleasure, including watching his beloved Parramatta Eels. He loved the Rolling Stones and he stopped listening to the Rolling Stones. I honestly thought I'd never see that day. He stopped reading Choice magazine, which he used to use even to buy his cutlery and socks. He was a devotee. Stopped talking politics, and the worst thing for him was he could no longer use his mobile phone or computer. He was perfectly with it up here, but he couldn't use his hands properly because of the effect of the nerves in his brain. He was moved from respite care to high care. He was given a pump for his medication, and absolutely nothing alleviated his pain and suffering. It went on and on. And finally, his palliative care specialist and a GP came to his independent living unit and said, no, he needs to go to hospital, because they were trying everything to alleviate his suffering and nothing worked. So he ended up in hospital in his last week. And we thought the worst of it was at the independent living unit before he was transferred. We thought, thank heavens he's being taken to a hospital and the suffering won't be so bad. Well, let me tell you, it was a whole lot worse in that final week. He groaned, he screamed, he moaned. He had my sister in our arms. This went on day and night, day after day, where he would squeeze them to the point where we had dents in our arms, and he only was able to utter 2 words that week. One was help and the other one was inhumane, and that last photo was when he was calling for help. The other thing was the hospitals ran out of options in terms of trying to control his pain, and even one of the senior nurses said to me how upset they were about it. So they gave him a stress ball to bite down on while all this was going on day and night, day after day, night after night, and he ripped it apart with his teeth in about 5 seconds. So that's the level we were at. I just can't allow it to go on. I want the day to come where I know nobody else will go through that sort of suffering. If New South Wales had had the VAD legislation when Tom received his devastating diagnosis, he would have fitted squarely into that legislation. he would have at least had the comfort of knowing that sometime over that 6 months, if he needed to pass away with assistance, we couldn't give him that comfort. Neither we nor his doctors could give him that comfort. More importantly, Tom would have had to endure the extreme and relentless pain, pressure, discomfort and anxiety that he went through all that time. My sister Angela and I promised Tom before he died that we'd try to do whatever we could to make sure that voluntary assisted dying was available in New South Wales for other people with untreatable cancer like Tom. So I'm speaking on behalf of my sister, my brother Tony, my husband Martin and all our extended families. We don't want his suffering to be in vain. We are desperate for this legislation to pass. Thank you.
Thank you very much for that extremely powerful and moving opening statement, Ms. Barry. Ms. Egan, can I trouble you for an opening statement?
Yeah. First of all, I just want to say that I'm incredibly honoured to be here today. It's not every day that you're asked to come and talk about life and death, and in such a good death in hopes after we're here talking about our loved ones having a bad death. I think it's really good that you guys can talk, about the safeguards and the legislation and the hoops and the paperwork and everything that you need to do. But I don't think you guys would have been able to have the full picture of what this bill would mean to people unless you were to meet people like us who have had our loved ones go through this. So my partner Jade was diagnosed with cervical cancer in March 2017 and ended up dying in October 2018. So she lived for 18 months. Jade was misdiagnosed for 12 months in the lead up to receiving that diagnosis, which means when she was finally diagnosed that it was pretty progressed. She was stage 4 and we were told that she had 12 months to live from them. So it was like fairly downhill from there. Jade was probably the best person I've ever known. Her family and friends love and adore her and still do. And she, from the get-go, was a real advocate in terms of wanting voluntary assisted dying. I think because she was so sick from the outgo, she knew that this wasn't going to end very well. In her journey of having cancer, she met other people with her disease and with other types of cancers who had died horrible deaths, and she really, really did not want that to happen to her. In the last 6 months, her disease progressed so much, and the tumours in her body became so large that it impacted her on a daily basis, in that her legs would fill with, she had up to like 5 kilos worth of fluid in her legs a day, which is immensely painful, and no pain relief can relieve that. Towards the end of her time, she wanted to die at home, and fortunately I was able to grant that wish for her and make that happen with the use of palliative care, which they were unbelievable, but again could not relieve all of Jade's suffering. In terms of her emotional, spiritual suffering, which is just important as physical pain, not only could her physical pain not be relieved, but her emotional and spiritual suffering could most definitely not be relieved at all. Jade's last week on this earth were nothing short of hell, not only for Jade, but for her family and my family who were there to watch her leave. She was so dosed up on pain medication that she was hallucinating and thrashing around the bed, and she didn't know where she was or who we were or what was happening for her, which is immensely distressing, not only for her but for us. I'm going to give some gory details because, again, I think it's really important that you hear, because otherwise it's like I said, you guys can have all the paper and all the facts, but until you hear the actual things, you don't really know. So the tumour in her abdomen was so large that it was, impacting her ability to use the toilet. So she had a catheter in permanently to help her go to the toilet. And just want you to remember that we're talking about a 32-year-old woman at this point. We're not talking about someone who's 80, not that that's any better, but at 32 years of age, this is not something that she should have gone through. Yes, so permanent catheter to help her go to the toilet because of the pain medication she was on, and because of the tumours, it was impacting her bowels so much that she was unable to go to the toilet that way, so she would end up vomiting her own faeces on the regular. The way that her tumour was positioned in her body, when I would have to change her, parts of her tumour would fall out from underneath, fall out from her, which is horrendous for everyone involved, especially Jade, obviously. The tumour was so large in the back that it cracked her vertebrae. So in terms of her being in bed when we would have to move her so she wouldn't get bed sores, trying to roll her over, she would scream in absolute agony because of, cracked vertebrae, you could only imagine. So just things that people should not have to go through. Similar to what Paul was saying before, just having that comfort in the cupboard would have made the world of difference to Jade. Unfortunately for you guys, you didn't get to know Jade, but if you did know Jade, you would know that she was an incredible fighter, and she did not want to die. She wanted.
Take your time.
Yeah.
There's no pressure at all.
Yeah. Just want to get it out. She did not want to die, so she wanted to be here. So there's no way that she would have taken that medication to end her life had there been any other option. She only would have taken it to end her life at a point of no return, and she was at a point of no return. And the way that she was forced to leave this world is horrific. Like, it's just so unjust. And when, you put the people that you love the most in these positions and you watch the way that they are forced to leave this world, it traumatizes you. I was 28 when Jade died. I'm 31 now, and it's never going to leave me. It's never going to leave her family. It's never going to leave my family. It will forever be etched in my memory that these are the last memories I have of the person who I love the most in the world. And that's not a true representation of who she was. And I think it's incredibly unfair. Jade would have done anything for anybody, and for her to be forced to go out the way that she did is incredibly cruel. And as hard as this is for me and the others to be here today, it's incredibly important. And I would do it all again, and Jade would do it all again if it meant that it would change the lives of other people they didn't have to go through it anymore. I think that's it. Thanks, everyone.
Thank you for sharing that story with us. We've got about 5 minutes left, and I know, Mr. Gabrielades, I am sorry that I wanted to make sure that everybody got the opportunity to share what it was that they came here to share today. But I know you may have had a few more things to say. So, with the permission of the committee, if anybody, if everyone's happy, perhaps we can.
Thank you. No. So I'm happy for you to ask any questions. I'm not sure if you ladies are.
There's one thing I wanted to add. When Abby was talking, I left out a chunk because I was conscious of making sure Abby had some time. But not only was the issue with soiling, to see your loved one who, your older brother, soiling themselves over and over again, but when he was in the hospital, he had an incontinence nappy on, and he kept trying to pull it off and pull out the catheter with his legs in the air. Now, that went on day after day as well. And I'm asking you, how would that be for you? Tom, 2 weeks before he died, he again asked us, could we assist him to die? And we couldn't do that. and he would have not had to go through that horror and that lack of dignity if we'd had voluntary assisted dying. So he asked several times, but formally twice he asked us. Once at the start and once towards the end.
Ms. Barry, my father was named Tom, and I had the exact same experience when he passed away from cancer. So, cuts very close to home, but thank you very much for sharing that. Given that we have got a little time left, is there anybody that has any questions that they'd like to ask on the committee or seek some elucidation, or do any of the members have anything that they feel that they would like to add, given that we have got about 4 minutes left?
Look, can I just suggest, all the stories have been compelling. I need a couple of minutes out of here, thanks.
Well, I on that note, if there are no questions, I'll thank our three witnesses today for providing what was very powerful and personal stories to us as a committee. And we'll call this session to a close. Obviously, there's no questions taken on notice. But I thank you again for coming in, sharing your submissions and stories, and we'll break now for a couple of minutes. Welcome back to the last session today for this voluntary assisted dying bill inquiry. Our last three witnesses are with us. I'll ask each witness, starting from my left, to state their name and position title and swear either an oath or affirmation. Ms. Daniels.
My name's Mrs. Rebecca Daniel. I'm a private individual and a widow. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mrs. Daniel.
Hi, I'm Jan Edwards. I'm a private citizen. I have a funny accent because I was born in Canada, but I'm a true Australian. And I solemnly and sincerely, truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Mrs. Edwards.
My name is Emma Schofield. I'm a private citizen, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Schofield. Before I invite you to make some opening statements, I'll just remind the witnesses to bring the microphone nice and close, and what that will do is just provide us in the room a better opportunity to hear you, but also those who may be watching on the broadcast, and also for Hansard, the ability to hear. So, Mrs. Daniel, would you like to start by making an opening statement?
Yes.
Thank you very much.
Thank you very much for giving me the opportunity to make a submission. This is a very important subject, and it has affected me very deeply and closely as my husband died 5 years ago. Sorry, I can't read. I'm here today speaking on behalf of my late husband, Laurie Daniel, who desperately wanted the voluntary assisted dying laws. He submitted a story in the book, The Damage Done. He was interviewed by Andrew Denton on the podcast Better Off Dead. He took part in Q&A questions about voluntary assisted dying, and he submitted a very long submission into the Victorian inquiry into end-of-life choices. Sorry. I do actually have some documents that I'd like to give to each of you. They are a collection of my husband's writings. They are his submission into the inquiry, a cartoon as well, because he was a cartoonist, and also the letter that he wrote to the coroner and his goodbye letters to me, all of which I'm including because they are very pertinent to what he went through, his suffering, his experiences, and his feelings and strength of conviction that voluntary assisted dying, or as he called it, voluntary euthanasia, was an absolute necessary right for those who are terminally ill but also incurably ill. Laurie had MS. He also had Lyme disease, South African tick bite fever, anaplasmosis and rickettsia. His pain was unending and intolerable. His treatment, care and pain management didn't alleviate his agony. He had neuropathic pain, which in his circumstances was unstoppable. I was naive enough to think that the pain specialists, physiotherapists, neurologists, stem cell treatments, specialist GPs could help him, and they did. They were wonderful. They cared for him. The attention he got from his carers and from everyone was thoroughly admirable, and I thank them deeply. But the truth is that they couldn't really make any effect on his symptoms. He chose to end his suffering in September 2016 at the age of 51. I would like to use many of his own words, as he was so outspoken and passionate about the right to end-of-life choices. He didn't get to have the peaceful death he spoke of, surrounded by those who loved him and that he loved. We lost him earlier than was necessary, as he was losing the use of his hands, and he felt he needed to take action quickly before paralysis took control. If voluntary assisted dying laws were in place, he would have had peace of mind and security in the knowledge that there was a caring, compassionate, and civilised end available to him. I've included the word civilised because surely this has to be one of the clearest indicators of a true civilisation, how we as a society treat the ill and suffering, those who are tortured by pain and incurable symptoms. In 2016, Laurie wrote in the book, The Damage Done, Australian law says that suicide is legal. Now go away quietly on your own and do it. At the centre of that casually imposed cruelty is a minority who have decided they will tell us what will happen to us at the end of our lives and how we will live our dying. Voluntary assisted dying is voluntary. It is about personal choice and cannot be imposed on anyone. It should be available not only to the terminally ill, but to the chronically and incurably ill. The criteria should be unbearable suffering and quality of life, not some arbitrarily chosen time left remaining before death. That's the quote. Laurie often said when he was at his most racked by pain and despair, if I was an animal, they wouldn't let me suffer like this. And we don't let our pets suffer. We find it intolerable to let our beloved pets suffer needlessly, but our beloved humans don't get the same consideration. It's more compassionate to allow someone to say goodbye to their family. It's more humane to stop someone's pain. It's more civilised to let loved ones be supportive and involved. And ultimately, fear will be lessened, life may be extended, and damage will be considerably less for all concerned. I lost time with the love of my life, my best friend. My children missed out on precious experiences with their father. And Laurie missed seeing his pride and joy, his children growing into the wonderful people they are. He said, there are some things worse than death. Now, I can't say how long he would have lived if he had not taken matters into his own hands, but I do know that the peace of mind that he would have had, the knowledge that he could have had someone in a caring and compassionate manner to give him something that would end his suffering, that would have made a difference, and we would have had him for longer. And I know that he was well aware that there are so many different criteria of people who may or may not benefit from this law, but he felt so deeply and strongly that this was something that he wanted other people to have. And so I hope that I've done him proud, and thank you.
Thank you, Ms. Daniel, and you have done him proud. Ms. Edwards.
Thank you, and thank you for allowing me to speak to this group. Now, I could talk ad nauseum about facts versus views and about how I believe some of the terms such as suicide and euthanasia are being misused in the conversation we're having about voluntary assisted dying. But what I want to do is I want to talk about Tim. Tim was my husband. He was strong, he was smart, he was vital, he was challenging, he was also pretty good looking. He died of mesothelioma. As with Rebecca, he was the love of my life and my best friend. We thought we were very lucky because we felt that way after being together for a lot of years. Together, we raised 4 talented and useful kids who became our friends. Tim trained as an economist, but his skill was strategy. And he used that strategy with a laser focus to try to improve the world. The kids and I would often tease him to being the second Don Quixote, always tilting at windmills, but he kept on tilting. He loved a good discussion, and our family had them all the time. Whenever we had a discussion, it wasn't a chit-chat, it was about something, and we loved it. Our family was close. We had a solid foundation of trust and respect, but we weren't demonstrative. We weren't, we didn't show affection that readily. But in the year after Tim's diagnosis, something very interesting happened. The relationships we had became softer, they became more emotive, and they became tighter. And it was a lovely period, despite the fact that we all knew we were on a countdown. The strength and quality of that connection that gave us real comfort and gave us a sense that perhaps Tim could end his life well with our support and our love. And that was all he wanted. He wanted to go out on his own terms, having had a final wry and philosophical chat with each of us. But that's not what happened. In the final weeks of his life were horrendous for Tim and for his family. In the end, a cycle of intense suffering and incapacity. In that, Tim lost himself. And we lost Tim, the person, the husband, the dad, well before we lost Tim, the physical being. The really sad thing is that he knew it was happening and his whole being was being consumed by the suffering. I knew that it happened. I remember the night. I remember that it happened, that I realized that this had happened. My eldest son, Matt, couldn't be with us in the last 2 weeks of my husband's life, so he wrote a beautiful letter. And he asked me to read it to his father. And I can remember sitting in bed beside him, reading him this letter. And I glanced over, and I realized then that he couldn't absorb what I was saying. He couldn't relate to it, and he couldn't react. That's when I knew that Tim was gone, and what was left had no consciousness for anything but his suffering. Tim accepted death, but not the way he died. He died angry and frustrated. He died disconnected and suffering in the extreme. So we didn't get to say goodbye to Tim, the person. We didn't get to have that last wry conversation that he so loved. We didn't get to help him pass well and peacefully. We felt like bystanders in a tragedy, and we all felt really badly that we'd let him down. The outcome of those weeks was a good man who died badly in slow motion, and a fractured family who could no longer relate to one another or get past the guilt of having let him down. 3 years later, we remain a fractured family. It's as if the kids have got some kind of PTSD and they don't know how to mend. Tim would have hated that, and I don't have a magic wand. I'm not even sure anymore that I'll have my whole family there when I die. And that's a hurt that just sits there with me all the time. So I guess I'm here today to say that it could have been really different. If there had been voluntary assisted dying, Tim could have and he would have chosen his moment in those last weeks when he was still himself and his family was still part of his universe. We both respected, and I continue to respect, that voluntary assisted dying isn't for everyone. I myself was raised a Catholic, so I understand that some religious beliefs believe that suffering is a pathway to God. But I ask that those views and beliefs not be imposed on those that don't share them. I ask that the Tims of this world who are going to die anyway be allowed to die in a way that gives them some peace and their loved ones some way forward. And finally, I ask that we construct a law that protects the dying, but doesn't add a layer of difficulty that increases the suffering to an already intolerable situation. Thank you.
Thank you very much, Ms. Woods. Ms. Schofield, can I offer you the opportunity to make an opening statement?
Yes, I really appreciate being asked to be here, and I particularly appreciate that we have this forum all together. I don't particularly want to be here, to be honest, because it's difficult, it's re-traumatising. But I feel a responsibility too, not just to Amal, who I said I would do this for, but also to myself and to my parents and to the people I love, because I know personally I'm not as brave and tolerant as Amal was. So Amal was my partner. My experiences in caring for him for 3 years with motor neuron disease. I think the things from my experience that are relevant to the VAD bill is firstly that, as a lot of other people have said, knowing that VAD existed was worth everything, and worth everything for enjoying our life that we had, for tolerating the anxiety and panic and fear, which for me was crippling. I had a certain amount of PTSD afterwards. I was looking after my young daughter, and it took a couple of years to recover from the anxiety. But other than that, I think as the VAD is relevant in our story mainly towards the end of his disease. I don't know that he would have used it earlier on in the disease. I don't know if he would use it at all. It's actually not particularly my business if he chose to use that in the end, but I think it was our business. It affected both of us, knowing that it wasn't there for him if he needed it. So what I'm saying is the impact of knowing that VAD is there would be beneficial to both carers and the person, although it is that person's own choice whether they use it in the end. So it has a double benefit in that way. Secondly, I think there was a big power imbalance in our relationship with the palliative care team. There were a number of doctors who were excellent and the nurses were excellent, but we had a fraught relationship with the head of palliative care, who certainly caused us grief. And lastly, I think the part of our stress was the inadequacy of the current law. I like to think I was quite diligent in looking after him and trying to understand what the right thing was to do, to think how to work with the people that we had to make sure that his death was perfectly fine. I'm a collaborator. I don't like conflict. I didn't want to do anything that people say is wrong, but at the end of the day, I was overwhelmed by the responsibility that as his carer and as his partner and his enduring guardian, that it was down to me to ensure that he was okay. It wasn't down to anybody else. And at one point, I just felt abandoned by palliative care because they decided they didn't want to go that extra step and have a very frank discussion with us about what end of life was. So I don't know how long I've gone on, but I'll just tell you a bit about his disease.
I'll just say, Ms. Schofield, there's no pressure on you. You can take all the time in the world,
Okay.
and if you need to take a break, by all means, we're just here to support you.
I think I'm getting better. So Amal really genuinely loved life. He didn't want to die. He found he was positive and he was confident and he always wanted to find fun and adventure. He was passionate about his soccer and sailing with his close group of friends. He had a large family and he just loved the big meals and the getting together and the love that they created. We travelled a lot together, we rock climbed and we camped, and it was a really good life. And I got pregnant and it was really exciting. And we were ready to get old together with our little family. And 11 weeks later, he was diagnosed. I actually know a bit about MND because I did medical research in neurodegeneration. It's merciless. It's thought to be one of the worst neurodegenerative diseases, if you can say that, because he was 33 when he was diagnosed in 2016. Very quickly we learned what would happen, that it would progressively kill all of his muscle function through his body until his breathing muscles could no longer expand his lungs. His prognosis was about 3 years. He'd lose his mobility, the ability to stand on his own, the ability to hold his head up, to empty his bladder and bowels. He'd end up completely trapped within his body, 100% dependent, unable to talk, and increasingly struggling to breathe. And we knew that at the end he would be choking because his larynx and pharynx would collapse and he would inhale his saliva, most likely die from aspiration and pneumonia. We couldn't stop him dying this way. It was going to happen no matter what we did. But I think back to that time and I imagine what it would have meant to us if I could have just told him, if all that is too much, if it gets too frightening, or if you just can't breathe properly. It's your choice whether you have to cope with that or not. And I think that's my main story, in that it would have meant everything to that whole 3 years of dealing with the illness. Sorry. My next main points are about how the current law is inadequate and how even though Amal underwent a death that anyone pro-VAD or anti-VAD would have been proud of, in squeezing out everything out of life, tolerating everything it threw at him until the last minute, even though he did that, we had terrible trouble with the existing law. Our palliative care physician, we knew, was against euthanasia, we were suspected, I think, of secretly planning euthanasia, and so it clouded all our conversations. There was one point where Amal couldn't breathe well when we were transferring him to the toilet because it was strenuous, and he had it's called non-invasive ventilation, which is a mask on his face to push air into his lungs. It wasn't sufficient anymore. He would get breathless, and so he needed morphine as well to take the edge off, to give him a baseline, because morphine removes that panic associated with breathlessness. But we had a nurse advocating for us, and she told us she was, even though we were asking for relief, that she was having conversations with the head of palliative care. She was having long discussions and arguments with her, and she was trying to get us some relief, but it then took another 3 weeks for that physician to allow us to get morphine in the house, and then we were able to put him on a syringe driver, which means it slowly pumps a baseline level of morphine. I felt offended and upset that we were distrusted when I was trying to do the right thing, and I didn't know what to do, really. I was just trying to learn. So we had, otherwise, with the other palliative care physicians, we had a great relationship. We relied on them, and no doubt they were the reason for Amal's longevity in the care that because of the care that they put in. The other situation where I feel there were power dynamics at play and our relationship with palliative care was hindered by the existing law is in our conversations of end of life. There was a point where Amal said to me, we had been using a cough assist machine which suctions the phlegm out from the lungs. So you put it on, he tries to cough, it sucks it out, and then you put a suction in the back of his throat to suck the rest out, which I would need to do at various times of in the evenings, and then sometimes throughout the night. He had an episode where part of his lung must have collapsed or bled, and he couldn't breathe, and he was typing with his remaining finger, "knock me out," and pressing it on the iPad. But we didn't have the morphine in the house. We had a subcutaneous morphine, but it takes 20 minutes to act, so we gave it to him, but we had to sit through 20 minutes of him not being able to breathe. And after that, I think he knew he didn't have long to live. He kept getting bladder infections. So he wrote on his iPad, "I've got fuck all time left. I need to get things organised." That was a quote. So we talked to the palliative care team, and she went away and came back, and she said that what they can offer us is to wean him off his mask over a period of 2 weeks. So now this was end-stage disease, and so he had a non-invasive ventilation mask on 100% of the time, so he could breathe. He couldn't take it off. If you took it off, he would probably die within about half an hour, and this is what a couple of neurologists had confirmed with us based on what we've said, and we had an oxygen meter. If I took it off, his oxygen saturation was go down. We knew that he couldn't live without the machine, so really to remove that treatment would have been a legal way to kill him, but he would need pain relief. But she came back and she said what we can offer is to wean him off over a couple of weeks. We said how. She said we would get a respiratory physician to increase the carbon dioxide slowly over a couple of weeks. And I said, what are you going to give him for pain relief? And she said, we can't accelerate his death, so we need to see that he's distressed before we give him pain relief. So they would need to take his mask off and wait for him to be slightly suffocating, I guess. I don't know what they would look for, but become distressed, and then they would give him some morphine. And they said he would probably be asleep within a couple of days. And I said, well, once he's asleep, how do you know he's distressed? And she looked a little bit bemused and almost amused, and she said to her registrar, "Oh, this is a good question for you. What would you choose?" And he sort of stumbled, and she said, "Well, what I use is the eyebrows. If the eyebrows start furrowing, I'm guessing they need some more morphine." Which surprised me, because for someone who is losing muscle function, using their face to tell you whether they're distressed or not doesn't seem like a reasonable solution. Plus, I've been a neuroscientist for 20 years, and I'm pretty sure that we don't know a lot about levels of consciousness and what people feel. Unless you've got someone in a functional imaging scanner, you can't tell what they're aware of, and that's confirmed by some of the material we teach medical students at the moment about continuous sedation. I asked if they could just give him more in anticipation of the fact that he would suffer from suffocation, seeing as we knew, and she said no, because that would be euthanasia. And I said, well, what's the difference really? It's just that you're stringing it out. I mean, he's already almost dead. Can't he just choose to go? Because I was envisaging myself sitting by his bed, staring at his eyebrows, trying to work out what he was feeling, just waiting for his breathing to stop. And I didn't think I could tolerate it at that stage, because I was such in a desperate state of exhaustion and anxiety. And I had a little baby that I was waking up at night for as well. But when I said that, she said, we are palliative care, which was it. It was designed to end the conversation, and I don't think that's where the conversation should have ended. I didn't see the logic. I was trying to understand, and it didn't make any sense. So I think at the very least, I think that the current law is just inadequate. VAD would put the control in the patient's hands, which I don't think we should see doctors as having some sort of divine insight into someone's suffering and awareness of their suffering at end of life. I think doctors often really don't know what a person is experiencing, because we are all so vastly different. Any one person's response to things is different to another. There are so many different variables involved. A palliative care physician can't exactly know what that person is going to experience. So if their role was to educate patients instead about how their end of life could be, to educate their carers, to have that full conversation with me and him, and we all agree that that is suitable care, then I think that would, if with voluntary assisted dying, it would be safe to put it in the patient's hands to decide, and not give you a sort of potluck as to what your palliative care physician is going to say and going to decide for you. We have taught our medical students at UNSW about continuous sedation. There was just one thing, if you don't mind, that I was going to read out from one of the articles. It's from Brady and Verheide, 2010, Continuous Deep Sedation Until Death, Palliation of Physician-Assisted Death. This is one of the readings that we give them. It says, when sedatives are titrated to unconsciousness in continuous deep sedation, other vital functions are simultaneously depressed, such as respiration, blood pressure, heart rate and airway and swallowing reflexes. It diminishes control over the muscles in the face and throat, causing poor pharyngeal and airway muscle tone. The inability to swallow or cough can accelerate the onset of pulmonary aspiration and hypoxia. It triggers metabolic disturbances from rapid dehydration and asphyxiation from airway obstruction. These metabolic disturbances can exacerbate restlessness, agitation and delirium, and may necessitate further increases in sedative medication doses to maintain deep sedation. Therefore, it sets in motion a series of predictable, self-perpetuating, pathophysiological events that are not only directly linked to the desired mechanism of action, deep sedation, but also have a direct, life-shortening effect. So if this palliative care physician was against euthanasia but is quite happy for that to occur, I can't understand it. And so I am frustrated, and I see, when I look at the new law, I just see that it articulates well how things should be and protects the rights of the most vulnerable. That's all. Sorry, it took a long time.
It didn't take any time at all, and thank you very much for sharing that with us. I'm going to look around the committee and see if anybody has any points that they would like to raise or address. In the circumstances, I'll offer the three witnesses. Is there anything further that you'd like to put on the record? We've got a little bit of time. There's no pressure. If you've got something that you'd like to include, we're here to hear you.
I'd just like to add, I didn't include it in my opening remarks, but it is relevant, especially what was raised with Emma. We had a similar experience with our palliative care team to Emma's. We had the lead doctor who was resistant to the discussion, let alone, and all we had to say was it was Tim's wish to die peacefully. And I can remember sitting at the kitchen table with my children, getting a very long lecture about we had no right to do anything. We hadn't suggested doing anything. That he was strong and he could be around for a long time, and it was her job to make sure that happened. Nurses were wonderful. We lived in a regional area at the time, so she was it. That was our only choice. And it got after that particular conversation and the way she handled Tim, I had to tell our GP, who was excellent, by the way, that we did not want to see them again. So that was I think there is a mixed experience with palliative care. And the other the other item I thought offended me a little bit was in the reading of the amendments part of the debate in the lower house, where the member from Algoa quoted the expert evidence of palliative care experts who seek to assure good people of New South Wales they can confidently face death from terminal illness, knowing that modern palliative care can provide relief from pain and other physical symptoms and can assist in a dying person in dealing with emotional, psychological, existential, and spiritual challenges that can surround death. I don't know how she made that statement, knowing that there are large sections of that specialty that say they can't. And that's what I was alluding to earlier when I talked about views versus facts. So in general, I can commend the philosophy of palliative care, and in the nurses particularly were excellent. But it is not consistent, and it is, or is allowed to be, quite subjective.
Thank you very much for that. Can I ask if anybody else had anything that they wanted to address this afternoon? If not, then...
I think it should be explained that at least from my perspective, this is not a time for asking questions. It was an opportunity for people to explain, for the witnesses to explain their circumstances. Anything else, I think, becomes pretty trite. And so I hope you're not offended by any of us not asking a question. This is hard going for you, a little hard going for us.
Yeah, that's a good point.
Yes, I probably should have explained that. Thank you, Trevor. I think we're all very moved by what we've heard today, and I think that given that, we are only a few minutes away from our stated closing, but we'll call the session to close for today, and I'd just like to again thank not only the three witnesses here at the moment, but all the witnesses who have appeared today, and we'll be returning again on Friday morning for the next day of hearings. But thank you very much for coming today and sharing your stories and being the voice for those you love. Thank you.